Good morning, guys. Guys, you were both charged with criminal cases. Mr. Araujo, you were charged with public lewdness. You're facing up to a year in jail and/or a
Judge is frustrated but understands the heat and hurricane. Everyone still must follow bond rules.
$4,000 fine. And Ms. Serrato, you were charged with possession of marijuana. You are facing, and also public lewdness. You're facing up to a year in jail on the lewdness, and you're facing up to 6 months in jail on the marijuana. Guys, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. And on Araujo, he only has a one case, not the also POM, right? Okay, all right.
On December 2nd, 2024, officers were on patrol when he observed a vehicle parked on the dead end of the public roadway, and the officer observed two adults, the defendant, Serrato, and co-defendant Araujo, having intercourse in the backseat of the vehicle. Upon stopping the occupant, the officer observed the co-defendant's genitals being removed from the defendant's lower body as he got off her, as she was laid down in the back seat. The officer also detected a strong odor of marijuana emitting from the interior of the vehicle, and the defendant, Serrato, admitted to just having smoked along with being in possession of marijuana. She advised that all 7.6 grams of marijuana in the vehicle belonged to her, and the co-defendant stated he does not smoke marijuana. Both admitted to having sexual intercourse.
Got it. All right, guys, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to do this again in outside. I mean, great, but not where everybody can see it. Come on. You understand?
Sir.
All right, guys. How old are you, Mr. Serrato or Mr. Araujo?
30.
You're 30. What do you do for a living?
Construction.
What kind of money do you make a month? Do you have the ability to hire a lawyer? How much money do you make a month? A month?
Oh, a month. Oh, 16, probably like 24 to 30. Like 3,000, probably.
Okay, do you have children? All right, well, we're going to reset your case to give you time to hire a lawyer, okay? I'm also ordering you as a condition of your bond not to use. No more marijuana. I'm telling you, okay, just don't. Also with you, no more marijuana. I'm finding probable cause in your case as well. You have the same conditions, no outside, you know what? No marijuana as well. What do you do for a living, man? How much money do you make a month?
I don't know if I got those numbers. I'd like one check.
Where do you work?
I work at Memorial City Mall.
Okay, where in Memorial City?
Store gas.
Yes, okay. Would you like to fill out an application for an appointed lawyer?
I'm sorry?
Do you want to fill out an application for a court-appointed lawyer? Okay, I'll have you fill out an application. We're going to reset your case to give you time to hire a lawyer. Do not leave until both of you sign our bond conditions, and then we'll have you go. Okay? So first, you're going to meet with Victoria. We're going to have you sign a reset, and then we'll have you both take a seat in the jury box, and then we'll excuse you here momentarily. All right? Please. Yes, on both of them, no marijuana, no fornicating out in public. No, you.
Okay, Brandon?
Yep.
All right, have a seat in the check box.
You now have picked up a new case, Mr. Arispe. You now stand charged with terroristic threat or a family or a household member. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir. Officer was dispatched to a residence in response to a family disturbance. The complainant, the defendant's stepmother, stated that the defendant was upset because he was owed money. The defendant told other members of the complainant's family, if they don't have my money by tonight, I'm going to kill them, as well as I'm going to send my people to shoot them up. The defendant also told the complainant directly, if you don't have my money by tonight, you are going to see. A family member of the defendant and complainant stated that he had seen the defendant walking around with a pistol in his pocket, and the complainant knows that the defendant owned several rifles as well.
You were on bond for unlawful carrying of a weapon. Did we order him not to have one?
Yes, Judge.
Regardless, you picked up a new case. What happens now? is I'm going to revoke your bond in the first place and you will stay with me. I will appoint you a lawyer today, Mr. Ariste, so we can talk about how to go forward, but I am ordering you now not to have any contact with these people. Do you understand? And I'm going to tell you, you pick up a third case, I'm going to go bonkers on the bonds. Do you understand? I'm going to do everything in my power to protect this public at all cost. All right, goes with you. Do you mind appointing him? No? Yeah, when we get a lawyer. Is it Ally? Mr. Alley, you're charged with interference with duties of a public servant. This case is now 378 days old. You have been given PR bond after PR bond.
I lost my papers at the court.
Stop. Please don't say anything. You have the right to remain silent. Anything you say can or will be used against you. I don't think we've even done probable cause in this thing. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge.
Okay. Good morning, Alex.
Good morning. On November 28, 2023, officer was dispatched to a meet firefighter response call and met with the defendant's mother, who reported to the fire department that she was pushed by her son. The complainant did not feel pain when she was pushed, and the officer was advised that the defendant was locked inside the bathroom. When the defendant walked out of the bathroom, he walked past the officer and stated that he was leaving. The officer grabbed the defendant by his right wrist to detain him for a family violence investigation, and he forcefully pulled his right arm away from the officer. A second officer pushed the defendant onto a bed to detain him, so the defendant sat up and stated, "I will punch you," and then swung at the second officer with a closed fist, but did not make contact. The defendant then ran out of the sliding glass patio door and onto a third floor balcony, where he jumped over the third floor balcony and fell to the ground below, got up and ran away. Approximately 50 minutes later, the defendant was located at a park inside the apartment complex, and the defendant was taken into custody.
All right, Mr. Alley, I'm going to find that there's probable cause to go forward with you. How old are you, sir?
21. Now,
What do you do for a living?
stay at home on food.
You here with anyone today? Are you here with anyone today?
Yes, home.
Come on up, Mom. Thank you so much for coming. It's okay. Thank you so much for coming. Tell me what's going on with Mr. Alley.
He's intellectual.
Shh.
He's as an intellectual, he's learning. He also has diagnosis.
Okay. Are you taking medication, Mr. Alley? Is he taking it? Are you sure?
I'm the one, is his caretaker, which is I think he is medicine. I take him to a psychiatrist too. He goes, critical. Marquise, did you tell him that?
I don't know. He's going to have to remain silent.
We have a lot of problems. We can't get him to court. I'm here. I'm glad that you're here today, but it's the third time.
I had a transportation.
But I scored him, I really speaks for him on all his, for as his diagnosis, everything that's going on with him. I mainly speaks for him because he can't speak for himself.
Okay.
So I'm the one talks for him.
Okay. Did you graduate from high school?
Yes.
Wonderful. So what are your plans now? Okay. Then what? Okay. I'll appoint you guys a lawyer today. The only thing I'm going to ask you, Mr. Alley, don't use marijuana. Don't use illegal drugs. I'd like to send him for a test now to make sure he's not using. So what I'm going to do is I'm going to send him for a drug test right now, and I'm going to have him come back. And then I'm going to have you guys speak with a lawyer, and we'll figure out how to go forward.
Right.
Do not miss court anymore.
Cause he on medication. They be telling him, don't take, cause I be praying he don't because it'll affect the medication.
I want to know now
and
if he's,
affect your mental will.
I'm sending you for a drug test now, Mr. Alley. I'm telling you, no smoking marijuana. Do you understand?
Yeah.
If you do, we will have it's okay. All I want you to know is that we're going to work on making you into the best person that you can. But that can't happen if you're smoking marijuana. It's absolutely no. Do you understand?
Yeah.
I'm going to send you for a drug test now. I want you to come back. If you come back, good things will happen. I promise. We're not here to hurt you. We're only here to help you and have a ton of resources for you. But you got to come back. That's how it works. Okay? All right. So what I'm going to have you do, guys, just hang tight, take a seat. I'm going to have you speak with Felicia for a moment. We'll send you for a drug test and then come back. Okay?
Yeah.
I'm sending you for a drug test and then I'm going to have you come back.
Okay.
Take the test and come back. Do you have any questions? Okay. Mom, if you want to accompany him, that'd be great.
Yes, I am.
And then we'll just see you back here in maybe like
Make sure
30
you
minutes.
ain't paid, so to see what's going on.
Yeah,
With him.
take care of you. Don't worry, but just come back. We need you to come back, okay? Okay. All right. Please just have a seat, Mr. Allen.
Come on up, Mr. Come on up, sir.
We got him. I can't believe it. You're harder to catch than a leprechaun, man.
He's
For real.
been here for a minute, Judge.
This is the first time I've seen him in like 3 years.
Oh,
Well, maybe
well,
2.
he's been here since October.
How are you? You had cases, I guess, out of county. Was it Montgomery County or something like that?
Chambers.
Where was it? Chamber. Oh, ooh. Gotta be careful out there.
I know, they're going on the highway.
Give me the last name again, please.
Colbert,
That's right, Mr. Coleman.
and he's on today's docket on the jail docket.
All right. So you just entered in these 2 probations.
Yes, sir.
Be very, very careful. Because there's only so many times that they're going to bend over to help you out before they send you to prison. So you have to have a halo on your head when you're on 2 felony probations, especially for this, what you got now.
Yes, sir.
It's not hard. If you're hanging around bad people, they're going to bring you down. It's just a matter of time. Just break away. Here you're charged with failure to identify oneself as a fugitive from justice. So it's a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 30 days in jail, credit for the 118 days that you've already done. This will go on your record. You need to understand from now on, with us here in misdemeanor, any more cases that you ever pick up, you're looking at a minimum of 90 days in jail.
Yes, sir.
Do you understand?
Yes, sir.
You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to test for any behalf, confront and cross-examine your accusers. If you're not a citizen, where possible, you can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, there's no turning back.
Sir.
This is what you want to do.
Sir.
How do you plead to the offense, sir? I'll find you guilty. I'll sentence you to 30 days in jail, give you credit for the 118. If it's enhanced, abandon, please. Good luck. Just follow the rules. And if you ever have any problems, go back to the court. You're in a friendly court. They'll help you out. No issues, ever. Understand?
Yes, sir.
Mr. Coleman. Thank you.
Thank you. May we be excused?
Basically, the deal is this, man. We can't get a hold of your lawyer. We don't know where he is. We've been trying to get him for hours. He tested negative, which is great.
That's good news to hear.
So
I didn't know.
we're going to reset your case out, okay? We're going to give you paperwork to try to get a hold of the lawyer. We'll give you a couple weeks. If you're unable to get a hold of him, just let us know, okay? Come back. Don't leave. Come back to court. Good things happen when you come back. Can you make sure that he comes back? This is the 3rd time.
Oh, yes,
Please.
well, see, I didn't know about the other court because he'd been in court already.
We're going to give you the reset. That way you have it so you know when the next court date
Right.
is. Okay?
They said I got a feeling I cleared that.
Say it again.
They said I had a feeling I cleared that.
Yes, correct. Yeah. So we'll give you the reset. Just stay in touch. We'll try to get in touch with the lawyer. He's supposed to get a hold of you within 24 hours. If not, let us know and then we'll go further.
Okay.
Just stay in contact with the lawyer, okay? And take your medicine, Mr. Alley, okay? Okay, you guys have any questions?
Oh, you just come back for the court date and then,
Yeah, I guess I really don't want to talk to you without your lawyer. So the only thing, I guess, just we need him here, and I just can't get a hold of him. So we'll reset your case, and hopefully he'll reach out to you today so that we can try to come up with a game plan. Okay? If he doesn't get a hold of you, just let us know, and we'll go from there, I guess.
all right.
Okay?
Judge, what's the age of the case?
No, they got to come back. Just 2 weeks.
I didn't realize.
Yeah.
Okay, 2 weeks.
Yeah. Okay. But come back. Come back. Okay? All right. Okay, guys. Thank you, Mom. Okay. Come on.
I'm coaching on Nicholas Holland, and basically, we're trying to see what we can get done here. I think there's a rep for inpatient. We're trying to see if you would accept any intensive outpatient. And either way, we're gonna have to, just get through the holidays and do something, but it's gonna be one of those two. And it's ultimately which one you'll kind of bless.
I don't know. Should we do a TRAS?
Yes, sir.
Mr. Holland, come up.
He did the TRS and the recommended
This is why we do this beforehand. You know what I mean?
What?
This, so we know exactly what to expect, Yeah. I don't know, Tad, why? I mean, we have you evaluated by clinicians for a reason. These people know what they're doing. They've done it 100 times, and they know the best way to move forward with the case. That's why we do it. I cannot tell you how many times we've done a TRAS, we've deviated from what they say, and then we end up in a worse position because something happens. Now, I know you're going to tell me everything is little bunnies jumping in the woods, but you can never anticipate in life what's going to happen. And the problem is how do you deal with the stressors that come in life? Because that's what really defines a person. We all have issues, we all have problems, and they always come at the worst time. But the most important thing is, how do you deal with the stresses when they come? Do you turn destructive, self-destructive? Do you turn destructive in the public, right? Where you do something to endanger the public. That's why we have this. What they're suggesting is inpatient treatment.
Say it again?
I said, what they're suggesting is inpatient treatment.
Because you do have a job and
Yes, sir.
you have been working at this job for a while,
Yes, sir, for like a year and a half.
right? You've been very successful at this job.
Yes, sir. I'm a supervisor.
Okay, and that's what I'm saying. Even before we've done these things, you're already starting to turn things around.
Yes, sir.
And that's the kind of stuff, tell the judge how you've been turning things around. He needs to hear something to make him think that maybe, at least make him consider, outpatient rather than inpatient. Tell him, how your life has changed in the last year and a half.
Okay. Well, after I got the scram bracelet that you put on me, I knew that I knew it was like over with the games, the BS and all that stuff. And I just had to do right and do what I'm supposed to do. And I started just doing better at work because I wasn't drinking alcohol no more. Started doing better at work. They moved me up to a supervisor.
That's wonderful.
Started letting me manage money, invoices and stuff like that. And I just stopped hanging around the crowd of people that I was hanging around that go out and drink and party a lot. And I've just kind of been staying home or hanging out with my mom more. And
my mom used to tell me, dime con quien andas y yo te digo quién eres. It means, tell me who you hang out with,
yes, sir.
and I'll tell you who you are. And it's when you hang with dogs, you get fleas. Tad, let's do this.
Yes, sir.
Let me send him for a drug and alcohol test right now. Let's see. If he's clean, I'll acquiesce. But I'm going to tell you now, One problem, because I don't know, I'm not agreeing to this, but I will tell you that if we do go forward with this intensive outpatient treatment and you muck up, get ready, because I don't play. So
Yes, sir.
let's send him, I'm gonna send him now for drug and alcohol test. If he's clean, I'm with you, but,
And thank you enough, that's more than fair.
okay, all
More
right,
than fair.
all right, so,
It'll be clean, right?
do this, Tad,
I know you will, I'll do.
let me see if I have your cell phone so I can tell you when he comes back. Let me see.
Okay, and
I don't have, do you mind, here, give me your cell phone real quick, and then just hang tight, we're gonna send you, and then just come right back, and then I'll text him, and then we'll do everything.
Where do you want me to go to the jury box?
No, you can just sit out there. Sure, of course, this is your cell phone?
yes.
Okay, I'll text you when he comes back.
And then whatever we're gonna do, we'll reset it. and do it.
No, we'll do it today.
But if you're sitting the inpatient, can we get through the holiday?
I'm not gonna agree, I don't know, let's see first how he does.
Okay, well.
But let's just see,
Well, they bring them out.
okay?
Mr. Ozio Olvera. Oh, sorry, I'm trying to pull it up. Olvera or Vasquez Olvera?
Yeah, okay,
So his, the misdemeanor is
oh, he's not here, is he?
he's here, he's back
That's
there. He told me that he hired, counsel last week, so he's waiting on him to come in and sign on.
Mr. Olvera, come up. Or, no, just hold on a second. Hold on, Mr. Olvera, let's do this. Mr. Arispe, I forgot to do something while you were here earlier. And I essentially also wanted to wait for your lawyer to get here. You're on your terroristic threat. I'm entering in what's called a magistrate's order for emergency protection. What that is a court order that identifies Ms. Hernandez Martinez as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Muskegon Street house. Do you understand?
Yes, sir. There's also two other,
The only thing I want you to understand is you have not complied with bond conditions. You now, bless you, you now have an order for protection. If you violate this one, the state can and will file a violation protective order, and it's the capital murder of misdemeanors. It's one of the worst cases that you can pick up. It's so bad that if you violate conditions on a VPO, I can have a hearing to hold you at zero bond until these cases are over with. Do you understand?
yes, Your Honor.
Heed this warning. You won't get another. Okay? We'll just have you sign it and then we'll put you back. Okay, I think, do you need anything else from me on that? We're good, right? I think we're good. Okay. Come up.
See, I wasn't lying.
All right, good morning, Mr. Olvera. We're not waiting for a lawyer. Your case is 181 days old, and today's the day for you to decide what we're going to do. If you wanted to have a lawyer, that lawyer should have been here today. You've had nearly 6 months to go get a lawyer, and now, on the day of decision, you can't just say, well, I got a lawyer to, no. Today is the day. We need to figure out where we're going with this case. You can either accept the plea bargain offer from the state. If you don't, we're going to set your case for trial.
I didn't even know there was an offer already.
Well, what's the offer in this case?
There's no offer currently on the case. I can speak
It's
to
180 days. How is there no offer?
Ms. Saba and see if she wants to put one on right now.
Please.
Yes.
All right, just go ahead, take a seat. We'll figure it out and then I'll get back to you. If anything, I'll give you a couple days, but I'm not giving you much time. you get the offer today and you get a couple days to figure it out, but I'm not waiting any more than that. Do you understand? Let's see what they offer. Perhaps you have something you like today.
Judge, as his current lawyer, the felony is the underlying crime for his misdemeanor. So I would not advise him to take any offer, no matter what it is, so.
Okay. Oh, I didn't even know that he had a felony. What's going on with the felony?
Your Honor, on the felony,
Wow, it's a big time theft, huh?
felony either, Your Honor.
I can email the felony prosecutor, Judge, and see what's going on. They haven't put in an offer yet. I can put in an offer on my case. It's the UCW, but I just need to run it by felony first.
Then when you email them, see where it's headed. Are you gonna put an offer on the case?
Well, it's out of the same transaction.
What happened? And see, it's a big theft. Is it car?
So it was an auto theft, Your Honor, yes.
Do you want us to read?
No, but what's the value? 40,000, 50,000?
The value is approximately 56,000.
Okay. Yeah, so can you give us a little bit? Let's see what they say. Perhaps they'll give us a little bit of guidance on how they want to go forward and,
I'll email them right now.
thanks. Hey,
I've got a case from a month or two ago. He bonded out and needs bond conditions.
you mind bringing them up?
Mr. Bledsoe. I just sat him down. Give me one moment, Judge. Thank you. Hey, what's Stephen's last name?
Our bailiff?
Yeah.
Carson.
Carson?
Carson.
Okay. Occurs to me that it's somewhat unprofessional to say, hey, Steve.
It's okay.
Well, I mean, yeah, I talk to him every day, but still. All right. Yes, sir. No, sir. Arms by your side. All he's doing is setting the rules that you want to follow, okay?
Yes, sir.
What's the name?
Bledsoe. Evading arrest and terroristic threat. He was in custody because he had a pending felony with 228. So he's bonded out on all. The evading, I think, is 12 yards per the officer.
So I see that on 10/17 of 24, he picks up a felony assault. And 3 days later, he picks up a terroristic threat, and then he picks up an evading arrest. And they give him PR bonds on these cases? Is that what happened? And
He bonded out since his last setting. I didn't check to see if there were PRs or not, Judge. I know that he had to pay money in felony court.
yeah, it's just, I'm not dealing with PR bonds on this. I mean, he picks up 2 new cases if it's the same. Well, hold on a second. Let's not get ahead of ourselves. You've now picked up 2 new cases. You picked up a terroristic threat. You picked up an evading arrest.
I will say our cases are the new cases, so I wouldn't call them
Alright.
new, they're just cases. But he picked up the felony, and then afterwards he picked up these 2 misdemeanors.
I don't understand why he's coming here in December when he got a bond in October. How on earth is it?
He was in custody, I think, on the felony.
Oh, I see. Okay, and then he bonded out of the, right, okay.
Yeah.
Done. All right. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Please, what happened?
On October 19, 2024, officers were dispatched to a minor crash at a residential home in Harris County, Texas. The call described a male at the location crashing his motor vehicle, then pulling a gun, and was trying to fight people at the location. When officers arrived at the location, they observed people at the location pointing at the defendant. Upon contact with the defendant, the officers introduced themselves as Houston police and told them to stop. The defendant then walked into his residence and came back out approximately 2 minutes later. The officers instructed the defendant to come towards them, but the defendant began to evade on foot from the officer the second time. The defendant ran approximately 12 yards from the officer before placing him in handcuffs. A person search on the defendant revealed he had he had a prior arrest and an active felony warrant. Upon contact with the complainant advised the defendant was driving up and down the street in his car and crashed. The complainant stated the defendant began to tell the complainant he was going to shoot him and kill him. The complainant advised the defendant then began to reach into his waistband and kept saying he was going to shoot him. The complainant feared for his life and felt threatened by the defendant's statement.
I will say, gun was never found, no charges where the gun were ever filed. They charged him with terroristic threat. They would have charged him with ag assault if the police had believed that a firearm was used.
Mr. Bledsoe, let me make something perfectly clear to you. I will do everything in my power to protect my public at all costs, and I don't care if I have to make your bond $2 million. I'm going to do everything in my power to protect my public at all costs. Do you understand? I don't care who you are. I don't care where you come from. I don't care what, nothing. I want my county safe. You will be signing an affidavit with me today, promising me that you're not going to have any weapons whatsoever. And if I find that you have a weapon, I can have a contempt hearing. You're looking at 180 days in jail every time if you're caught with a gun. Do you understand? I'm sending you now for a drug test. I want to know what, if anything, is going to be in your system as well. I'm ordering you not to use alcohol or illegal drugs, and I'm going to test you like crazy. Do you understand?
Yes, sir.
What do you do for a living?
I work for Leland Airmark Bakery.
Okay, that's what you need to concentrate on. Working a lot so that your time is occupied. When you have too much time on your hands, you become self-destructive. Do you understand?
Yes, sir.
Do you have? Thank you. Do you have a Texas driver license? It's a yes or it's a no. Then you're not allowed to drive. On this affidavit, you will also be promising me that you're not going to drive. Do you?
Do you have a different state's driver's license?
City?
He asked if you have a Texas driver's license. Do you have a driver's license from any other state?
No, I'm from Houston.
Okay, sorry. I'm just making sure you didn't have Louisiana or something.
Not drive. I am also putting on this affidavit that you're not going to drive. Do you understand?
Yes, sir.
You're looking around, you're just, heed this warning, Mr. Bledsoe. Do you understand?
Yes, sir. Yes, sir. I totally understand. I only have one off day. I just sleep all day.
Did he say, did I hear him say that he had an objection?
No, most definitely not.
He was just asking me a question.
Okay, just
Objection.
don't use. Stay out of trouble. You're in enough hot water as it is. You know, the thing is, Mr. Bledsoe, is that a lot of people make very, very poor choices when they're out there in life. And sometimes that choice makes it to where you will live the next 40 years in a 6x9 box. And I'm going to tell you now, I've read have you been to prison before?
Nope.
I've read, I want you to hear me. I've read stuff about what happens in prison, and it had me in tears. It was as bad as could possibly, if you think of your worst nightmare, it's worse in our Texas prisons. They don't give a rat's behind about you, and you will be passed around like a proverbial doll. It's awful. Believe me, it's not worth it. Don't have a gun.
Yes, sir.
All right?
Thank you, Judge.
All right.
Judge, did you have the contact and referring form as well?
Yeah. Judge Hatton, it's so great to have you back. I heard it was just like,
Went from, Florona and then turned into actually a mom pneumonia as well, so I'm glad to be.
I'm so sorry, man. But I'm really happy that we're here, you know, just, sometimes it's just not fair, you know?
It is, you can stand a stack on you at one time. Thank you.
That's right. All right, you are Mr. Gary Graves?
Sure.
Good morning, Mr. Graves. Sir, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you a year in jail. I'm sorry, a year. You're facing a year in jail and or a $4,000 fine, but you've worked out an agreement that they're offering you 100 days in jail, credit for the 104 days that you've already done. Is this how you understand it? Yes, sir. You need to understand, Mr. Graves, that this is an enhanceable offense, meaning that if you ever pick up another evading like this, you will be facing a felony charge, years instead of days. Do you understand? Yes, sir. Is this what you want to do? To go forward with plea. You're giving up the right to a trial. I've done that, right? How do you plead to the offense, sir? Guilty or not guilty? I'm going to find you guilty. I'll send it to you the 100 days in jail, give you credit for the 104. Be careful, man. Life's too short. You know what I mean? All right, good luck.
And I also have Mr. Trujillo this morning.
Morning, Mr. Holland. Ready to go?
Yes, sir.
You know, you can lie to me, but you can't lie to yourself, and you can't fool yourself, and you can't get away. You are who you are. If you have a problem, you have a problem. It's better to own up, man up, and get it done before it becomes too late. You've got one life to live, right? And the more convictions you rack up, the more dangerous you act out in this world. Hopefully you don't do damage that's irreparable, where you go out, you kill someone. And the thing is that we get that you don't intend to do it. No one does, right? No one intends to go out and kill someone in a car, but it happens. And when you do, there's serious justice. DWI is big business in the United States. It's expensive. And here, every single day in Harris County, someone dies from a DWI or an alcohol-related collision. Every single day. We lead the nation per capita in DWI fatalities. It's a disgusting statistic. And it's so avoidable because literally all you have to do, one button on a phone, $30, anywhere you want to go in the city, no matter where you want to go. How much money have you spent on all this here when it's a rhetorical question. What I'm trying to get you to understand, it's $30 anywhere you want to go. This is going to go on your record. Today is that proverbial slap on the wrist, but from now on, you will be facing a minimum of 30 days in jail. And if you act like a child, where you can't control yourself to get in a car when you've gone out on a night of drinking, then we will treat you like a child. And like I told you earlier, or I didn't know if I told you, but we have a lot of kids in there. Some kids are young. Some kids are 60 that never grew up. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty to an offense, it will go on your record. It'll be there for the rest of your life. You can never take it off. Do you understand?
Yes, sir.
Are you sure you want to do this?
Yes, sir.
How do you plead to the offense of driving while intoxicated?
Say guilty or no con?
It's guilty.
Guilty?
Yeah. I will find you guilty, sentence you to 3 days in jail, give you credit for the 2. I have to suspend your license. I will suspend it for 90 days, which is the minimum. Do not drive. And I'm absolutely serious. Driving on a suspended license is a Class B, just like a DWI. So if you get popped driving, then you're going to be right back over here and things will not go well. You understand? From now on, even if you pick up a suspended license, it's a minimum of 30 days in jail. You understand? Now, I told you DWI is big business. Is this a 15 or above, or is it just a regular DWI?
I don't believe it was a 0.15, but let me double check. Actually, it was a 0.165, Judge.
Wow. Is it true or untrue that you had a 0.15?
Is it true?
True.
True.
The reason I'm asking you this is because now, instead of a $3,000 surcharge that you will owe to DPS, it's now $4,500 plus court costs of another $400. So it's now a $5,000 bill that you have to foot. And if you don't pay it, you sit in jail 1 day for every $100 that you owe.
So
I think that you wanted to tell me something, Ms. Spurlock, right?
Yeah, so Judge, he is working again. He makes maybe, it's gonna be between $3,000 and $4,000 a month. He does pay his own rent, living expenses. Until recently, he was helping to support a girlfriend and children, but that has since not worked out.
Wait, say that again?
So that relationship broke off, so he is now
Okay.
back supporting himself. But when it comes to finances, he does have some issues where he's not really making that much money. So if you could help me on that fine, that would be.
I love to help people, but the problem is that I asked you to remain clean and sober. You test positive. What did you test positive for?
He was presumptive for THC, and he did state to our technician that he had consumed marijuana around a month ago.
Yeah, I would told her I was a very heavy smoker prior to that, and I just got basically, excuse my language, my head out of my ass like a month and a half ago. And that I read that on there, it can stay in your system longer than for 30 days. And I told her, I was like, I haven't smoked in 30 days, but prior to that, I was a heavy smoker, so it could still be there.
You're still using.
I understand.
How would I know?
You wouldn't.
You didn't smoke a joint yesterday.
You wouldn't.
You know what I mean?
You would have to believe me, which is not a very easy thing to do right now.
Everyone tells me it's little bunnies jumping in the woods here. Everyone.
I understand.
I want you to understand, Mr. Holland, that I'm not going to play this game with you again. You come back here with the DWI, it's a $6,000 surcharge, not to mention court costs. You can probably leave here owing around $7,000, not to mention a bunch of jail time. Heed this warning. You won't get another. I will reluctantly waive your cost today, but if you come back here with the DWI, get ready. Do you understand?
Yes, sir.
Use Uber. It's there for a reason.
Yes, sir.
All right. Let's see.
The 0.15?
True to the enhancement. Yeah.
No, we don't have it on the information.
Oh, is it not pled?
It's not pled on the.
Because it was probably, I guess, the blood warrant, Judge.
Got it. Okay. All right. So just don't do the enhancement then.
So you still want to do the 4,000 or the?
No, it's 3,000 because it's not. If it's not alleged, then we can't do it. But so the 3,000, we'll waive it, and then with the court costs. All right, bud. Good luck to you. Remember, 30 days in jail from now on.
I won't do this again.
We'll see. Actions speak louder than words.
Yes, sir.
All right. Okay. Thank you, Ms. Spurlock. I got to tell you, I was disappointed that you took off. I really was. But you're back. How did we get him? Did he come in voluntarily or did they catch?
Your Honor. Yeah.
I'm assuming it wasn't. Right. We're going to keep at it. I'm not letting you go, Mr. Frazier. I'm going to keep you until, we make you the best person that you can absolutely be. You can't continue. The only thing you're doing is you're killing yourself. It slowly. Life ravages your body. The more destruction you do to it, you're only making things worse. Life doesn't get better when you age, and then you can just continually destroy it. I hope that you get it before it becomes too late. Some people, it's like children, right? Some children mature. Some children never mature. They're 60 years old in there and they've never matured. You want to party? Great. Do it responsibly. Don't hurt others. But at some point it's going to stop, right? If you want to drink, okay, hey, yeah, but you got to be responsible with anything in life. When you don't, I'm keeping you till the end. We're going to make this work one way or the other, Mr. Frazier. So they've worked you out a great deal. All you have to do is go back. They'll dismiss the felony. You're looking at 2 to 10 in the penitentiary. But I'm going to tell you now, if it happens again, what's the likelihood of the same thing happening again, of them dismissing a felony? So heed the warning. They just caught him out there on Alex.
I don't have any information besides seeing the warrant returned unexecuted, so it doesn't seem like he was arrested on anything.
We wish you the best of luck. Stay there. Don't go. Okay? All right, Mr. Frazier. Good luck. Thank you so much, Mr. Booker. Good morning, Mr. Trujillo. Sir, you were charged with terroristic threat of a family or household member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. December 3rd, 2024, officers were dispatched to a disturbance at a residence in Harris County, Texas. The officers were advised that the complainant had been threatened by the defendant who was still in the apartment. The complainant stated that he was in his apartment when his roommate, the defendant, came banging on the door. The complainant stated that the defendant was going to open the door, and the defendant made his way in with a stick or a bat and began to threaten him by stating he was going to kill him. The complainant then stated that he was in fear for his life due to the defendant's past aggressions toward him.
Any drugs or alcohol? Any indication?
No, Your Honor, there's no indications of drugs or alcohol.
Okay. Mr. Trujillo, I'm going to find that there's probable cause to go forward with your case. Please don't talk to this person anymore. I'm making it a condition of your bond. You're not living with him now, are you?
No, sir. Nowhere near. I'm gone from there.
Right. There's a protective order that's been issued in this case. You got to get to know it. If you violate this protective order, the state can and will file a violation of a protective order against you, and things will go sideways real quick. So we're not asking for much. Just don't have any contact with him. Don't have any weapons, and just be nice.
Yes, sir.
Do you understand? Are you working?
Yes, sir.
What do you do?
I'm an insulator.
You're an insulator?
Yes, sir.
What do you insulate?
We insulate hot pipes, boilers, stuff from the Navy base.
What kind of money do you make a month?
Right now I'm unemployed because I lost.
I was asking if you're employed.
Oh, no, I work on and off on part-time, and right now I'm kind of off right now because of the fact that I went to jail that day.
Let you off? Okay. You want to apply for an appointed lawyer?
Yes, sir.
Okay, we're going to give you an application. Don't pick up any new cases.
Yes, sir.
Be good while you're out there. That's all we're asking. You understand? All right, I'll have you fill out the application. Steve is going to get it to you. I'm going to have you sign a receipt with Victoria. We're going to have you take a seat. I need to get bond conditions. We need you to sign it. And then I'll have you talk to a lawyer here momentarily.
Yes, sir.
Okay? All right.
Good morning, Your Honor.
Hey, bud, what's up?
Yes, I was approaching on behalf of William Spencer regarding bond and bond condition.
Page 42. 30 days.
You're here on Peyton, you said?
William Spencer, William Spencer.
Okay, we need to set a bond.
Yes.
So, Alex, Mr. Spencer looks like on 9/20/24 picked up an FSGI. At the same time, it looks like he also picked up 2 aggravated assaults with a deadly weapon. Is it all in one continuous car accident just gone awry? Do you mind bringing him out, please? Hey, hold on, Morgan, let's
Yes, Judge.
get him out, please. Hi, Aaron, how are you? Thanks. You want to talk to me real quick? Yeah, of course. Hi. Hey, how are you? I'm David, nice to meet you. How are you? You're in great hands. He's the best. I'm telling you, really.
Studying for LSAT and we'll see where we go.
It's great. You got to do it. It's a great profession. You learn so much. It's hard, but if it was easy, everybody would be doing it, right? It's a rite of passage. Study hard. Good things will come. And then when you get into law school, the amount of information you learn, it's incredible. Even if you don't practice.
And then he went to the
I had a friend made, and I tell this to a lot of people, right? 300 million. I think he got a judgment. 300 million. Can you imagine? Sick. But if you treat the law well, it'll treat you back. It'll pay off in dividends.
That's how they found.
Yeah, you're in great hands, and you're welcome to come anytime and hang out with us if you want.
Thanks, right?
Yeah, great. Yeah, of course. Good luck.
Yes, and then they saw him, and they're like,
Yes, so the.
oh,
so the
look, you were involved in this, yeah.
Yeah, so the FSGI was on 9:50.
Jesus,
Yes.
okay.
Morning, Mr. Spencer. How are you? It looks like you have picked up a failure to stop and give information, which is essentially leaving the scene of an accident. You're facing up to 6 months in jail and or a $2,000 fine. I have no idea what happened on your case, so we're going to do probable cause at this point. The only thing I do know is that you're set at no bond at this point, that's not a good thing. So we're going to set you a bond. I just don't know what. And I do know that it looks like out of the same transaction, you picked up also 2 aggravated assaults with a deadly weapon. Those are each set at 150,000. So with that in mind, please.
Yes, Judge.
Mr. Spencer, before they read this, this is your attorney, Alan Williams. Do not say anything. Just let them read the probable cause, okay?
Yes, Judge. On September 18, 2024, officers were dispatched to a suspicious person call in Harris County, Texas. The officers were investigating and noted the vehicle involved in an aggravated assault matched the description of a truck in a hit-and-run case. The officer observed a blue Sierra parked on a construction site and observed the Sierra to have a broken right front headlight. The officer ran the license plate and learned the truck was listed as a suspicious vehicle in a failure to stop and give information. The officer met with the owner of the Sierra, the defendant, and the defendant stated he is the owner of the blue Sierra and that he is the only one that drives the truck. The defendant stated that on September 15th, his daughter used the truck and told him she was involved in an accident, but did not give any information to the other driver. The officer spoke with the complainant, who stated that on September 15th, he was parked at a gas station and he was pumping gas when the defendant struck his vehicle on the front driver's side. The complainant stated the defendant drove away, sideswiping his vehicle, and the complainant called 911 and followed the defendant as he drove away to a nearby gas station. The complainant stated he observed the defendant almost strike a building while driving in front of the gas station, and the complainant remained in visual contact of the defendant and watched him exit the vehicle and enter the gas station, stumbling while almost falling over while walking. The complainant stated the defendant remained in the store for about 10 minutes before leaving the store, and that the driver of the truck was a white male, and the complainant stated the defendant caused $3,000 worth of damage to his vehicle. And the officer reviewed surveillance video from the gas station and saw the defendant as the only occupant of the vehicle.
Okay. What happened with the ag assaults?
So it was, right. I believe that when the officers were called for the FSGI, when they were called to that place, I think it was an apartment complex or a construction site. They, I think, noted that that was the vehicle that the suspect in the ag assault had been driving at the time of the ag assault, because the ag assault occurred at an apartment complex. I think that's how they connected.
Yes.
Yeah. So that's how they, I guess, connected this defendant, but it wasn't out of the same transaction.
Was it though? Did he hit someone with the car?
No, Judge. So the officers were dispatched to an apartment complex. The complaining witness or a witness stated the defendant was firing a gun while out of the vehicle. Officer spoke with the complaining witness, age 13, who states that he was walking with friends and observed a Hispanic male sitting in a truck parked on the street arguing with a black male inside the apartment complex in the gated area in Harris County, Texas. Complaining witness stated he observed the male in the truck pull a handgun and start shooting in his general vicinity. The complaining witness was struck in the knee, requiring medical treatment. I believe a different complaining witness states that he and his friends were near the pool area of the apartment complex and heard gunshots and started running and realized that I guess their friend had been shot in the foot. But yes.
Okay. Do you guys have a recommendation as to a bond?
We're gonna ask the bond be set at $10,000, Judge.
Did you hear that, Alan?
Yes, Your Honor. Given the circumstances, that would be a good one.
You're in agreement then?
Yes, Your Honor. He's currently on a parole hold as well. And his current bond, at felony level is, I think, set at 150,000.
Right. So there is a parole hold, so I guess this doesn't, I was gonna do a no driving affidavit, but I mean, don't drive. You know, there are happy drivers and then there are people who are not happy drivers, right? Just don't drive, please. All right. We'll set your bond at, Mr. Spencer, I'll set your bond at 10,000. If you bond out, you must come here. Well, I guess you can't bond out. He's got a blue warrant, right? You know, what's he on parole for? Do you know?
NCIC.
Yeah, Judge, sorry. There's a little bit of criminal history.
Aggravated robbery.
Okay. Thanks. But just don't, you know, I don't know what's going to happen, but if you do somehow get out, please come back here for the next business day for bond conditions. But as a condition of your bond, I'm ordering you not to drive now, regardless. Yeah. Okay. So what we'll do is I guess we'll wait it out to see what happens upstairs. We'll just keep this rolling with that. And at some point, something will happen and then, you know, but yeah. All right. Good luck, Mr. Spencer. All right. Thanks.
Thank you, Your Honor. Also, I want to.
So hold on, let's get you a date. The felony is set for 1/8. You want to do the next day?
Yes, Your Honor. That'd be great.
Okay. All right. Good luck, Mr. Spencer.
Thank you, Your Honor.
You requested the 21st.
Oh, yeah, of course. If that's, you want the 21st or do you want the next day? Whatever you want, Alan.
The next date would be fine.
Yeah.
What day?
Yeah, that's the 9th, 1/9. It's a Thursday.
1/9?
1/9, yeah. Mr. Patlan?
Yes, sir.
Sir, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On December 2nd, 2024, officers were dispatched to a minor accident on Sam Houston Parkway. Upon arrival, the officer met with both parties of the accident as well as a witness. The witness advised that there were minor disturbances on scene in which a knife was brandished by the defendant who was parked across the street from the accident. The officer identified the defendant and discovered he had a mandatory suspension on his driver's license for a second DWI. And the defendant advised that he had still been driving for work. He had personal business despite having personal knowledge of the suspension. The defendant stated he was driving from San Antonio and was only waiting for his coworker who was involved in the accident.
Does he have an open DWI right now?
Does not appear so, Your Honor. It appears that the last DWI he had was in 2019 out of Bexar County.
Bear
County, yes, Your Honor.
Okay. Mr. Patlan, I want you to understand one thing. I'm going to find that there's, so wait a second. Someone saw him driving or did the officer see him driving? Because I didn't.
He admitted that he had been driving for work. And he admitted to having personal knowledge of suspension as well.
Did anyone see him driving?
No, Your Honor, there's only the
Do we know even when he was driving?
There was an accident, that's what dispatch involved, and then he.
Okay, so, okay, so.
There was an accident, and then officers arrived, and then they made contact with the defendant.
Got it. So all this was in response to an accident that he was allegedly involved in?
Yes.
Got it. All right. So I am going to find probable cause, Mr. Patlan.
Sure.
And no, don't. You have the right to remain silent, exercise. I've got about a bunch of DAs here. Anything you say, they're going to use it against you. But let me make something abundantly clear to you. I'm going to have you sign with me today an affidavit. This is a promise that you're making to me that you're not going to drive. I don't care what is going on in your life. When we mean no driving, we mean no driving. I don't care if there's a burning building and you have to save 50 kids. Do not drive. If you do, I can have a contempt hearing facing up to 6 months in jail and a $500 fine every time you drive. Do you understand? I don't care what your excuse is. You cannot justify at all any reason. If you want to drive, go get a license, get liability insurance, and then we can talk. But until that point, I will even do this. This is the number to the DPS Driver's License Division. If you call them, they can tell you exactly what you need to do to get your license back.
Classes now, sir.
There may be, an SR 22, you may have to do all these other things. What you need to do is call them and they can advise you, but don't drive. Do you understand?
And Your Honor, and just to make a correction, after reading the full DIMS, the defendant was parked across from the accident. It was his coworker that was involved in the accident. He was parked across, Your Honor, and I do apologize. After reading the complete DIMS, the officer wrote that the defendant was parked across the street from the accident, and he made a statement that he was waiting on his coworker who was in the accident.
No one sees him driving.
He was just parked across the street.
No, no. What? Really?
He made the statement that
I get it.
he was in the vehicle and he made the statement.
I took a shower today. No. I mean, you just make a statement. I mean, no, there's no proof.
To having knowledge of the suspension, and he was in the vehicle parked across the street.
But no one sees him driving?
He did make a statement.
No. All right, I'm going to find no probable cause. Sir, be careful.
I will.
We have enough.
I understand.
All we're asking you to do is follow the law. It's really not hard. Give them a call. They can tell you exactly what you need to do. That's the way we do things, right? All right, sir. Just hang tight for me, okay? Sure. Thanks. Good morning, Mr. Bolden.
Good morning.
Sir, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement. They're offering you 3 days in jail, credit for the 7 days that you've already done. Is this what you want to do, sir?
Yes. Yes, sir.
Yes, sir. You understand that you're pleading guilty, right?
Yes.
You understand it's going to go on your record, right?
Yes, sir.
You need to understand from now on, you are facing a minimum of 30 days in jail for any new cases that you pick up. You understand?
Yes, sir.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, you cannot change this or undo this. You still want to do this?
Yes, sir.
You know, Mr. Bolden, if you come back, good things happen. It's not hard, you know? Just don't say anything now. For future reference, when you come to court, good things happen. Everybody works here is amazing. You know what I'm saying?
Fell into a pier. Yes.
Come back. Good things will happen for you.
Yeah.
How do you plead to the offense of criminal trespass? Guilty or not guilty?
Guilty.
I'll find you guilty. I will follow the agreement. I'm going to roll your court costs so you won't owe anything. Good luck to you, sir.
Okay,
Thanks, Carl.
Mr. Bolton.
Sure.
All right, Judge, page 2, Alvaron. I'll read all, mark those cases.
Hey, hi, Marcos. How are you? Who we have?
Page 2, top of page 2, Alvaron.
Got it. Good morning, Mr. Albaran. Sir, you were charged with illegal dumping. You were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, and the officer went to 16938 Tomball and saw newly dumped debris at the location. The officer reviewed surveillance video from a department-owned camera and observed a vehicle pull into the dumping site and showed debris in the bed of the truck. The video showed the truck leave and the debris was on the ground. The video was able to capture a Texas license plate, and the officer performed a search for the vehicle's owner, and the officer was able to find the registered owner of the vehicle, as well as the truck's title holder. The officer attempted to make contact with the company, and at a later time, the officer went to a residence to meet with the owners of the truck. There, the officer was met by a Hispanic male who was identified as I apologize, Your Honor, as Freddie Alvaron, and he advised.
Freddie?
Yes, it says. Identified as actually Freddie Antonio Guevara. And this male was advised who the officer was and was shown photos of the truck used. The male was asked if he recognized the truck in the dumping. He did recognize the truck. And he was asked if the truck belonged to the company. He said yes. And he was asked who was driving the truck in question and was shown videos of the dumping to see the driver. And at that point, the male advised the person driving the vehicle is the defendant. The male then advised the defendant was not there at that point. And the officer was able to provide, or the male was able to provide a phone number for the defendant.
Does he admit that?
It says that the defendant was asked about the dumping, and he admitted to the dumping.
Mr. Albaran, I'm going to find that there's probable cause to go forward with your case. Tell me, are you a United States citizen, sir? Do you have a Texas driver license?
CDL, Judge.
CDL. You have to be very careful with that CDL. You need to understand that you are held to a very high standard with the CDL. If you don't believe me, go look. Because of the permissions you have to drive other vehicles, you are held to a higher standard. If I find that this occurs again, I'm going to take your ability to drive away. I'm not putting any conditions on your bond now, but if I find that you participate in any of these activities, any kind of reckless driving or whatnot, I'm going to take your ability to drive away. Do you have liability insurance in your name? As long as you have both, you can continue to drive. Just don't pick up any new cases. You have a lawyer. Because you have a lawyer, we will waive your appearance. Stay in touch with Marcos. If he tells me he can't get a hold of you because you're playing games, we will issue a warrant for your arrest. I'll have you sign a receipt with Victoria, and then we'll have you just get out of here. All right? Just take care. Okay. Thank you. Yes.
Right this way.
So no conditions.
All right, Judge, next is page 4. Araguyo William. And the
Storm is raging, people are stressed, but bond conditions are not optional.
co-defendant on page 21, Serrato. Judge, is there state's bond conditions on this one?
No, no condition. So you said, what was it first?
Page 4.
Page 4. All right, got it.
Top of page 4.
Will be appointed to you, ma'am.
Yes, Judge. Okay. Officers were dispatched to a residence in Harris County, Texas in response to a disturbance. The complainant stated they were in their car and
Even in emergencies, rules must be obeyed, no exceptions for anyone.
backing out of their driveway when the defendant parked behind them. The defendant then got out of her car and started banging on the complainant's vehicle while shouting obscenities and threats. The defendant also tried to gain entry into the complainant's vehicle. Specifically, the defendant stated she was going to whoop their ass, and the complainant stated they were in fear for their lives during the incident. The officers discovered the defendant is a coworker of one of the complainant's family members.
Owner, boss.
So the threat is what?
The threat is she was banging on the door and said, "I'll whoop your ass."
I have it on camera.
Ma'am, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with this person and not to be in possession of weapons, okay? What do you do for a living, ma'am?
I own a fleet company, 3 trucks, and they're my drivers for the road, my OPR drivers.
Okay.
So they just basically stole my vehicles.
We are going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign and reset. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. When you come back, please have a lawyer, okay?
Okay, but I move out of state next month, so I just talked to my mom.
We'll have you sign a reset, and then we'll just take a seat while we get your bond conditions. We'll have you sign the bond conditions, and then you'll be free to go. Okay, please. You were Jalen Washington. Mr. Washington, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On November 7th, 2024, officers conducted a traffic stop on the defendant's motor vehicle after observing it driving with an expired registration as of July 2024 and failing to maintain a single lane, with both left tires crossing over the white marked lanes and the defendant's vehicle failing to signal a lane change. The defendant was the driver of the motor vehicle, and upon contact, the officer observed him with a strong odor of an alcoholic beverage, glossy eyes, swayed balance, slurred speech, and the defendant was slow to answer questions at times. The defendant admitted to drinking, and standard field sobriety tests were administered. HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The DIC was read, and the defendant consented to breath. The results were .106 and .106.
Mr. Washington, I'm going to find that there's probable cause to go forward with the case. How old are you, sir? What do you do for a living?
Currently, I work at FedEx, but I'm in college.
You're currently enrolled in college? Great. Where do you go?
PV. Sorry.
Okay. What are you studying?
Architecture, civil engineering.
Fantastic. Great. It's a big hiccup, man. This can really affect you. You know, anytime you want to get licensed to be an architect, you got to be licensed. All this. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You're not allowed to smoke any marijuana. I'm going to test you. If I find that you continue to use, I'm going to put you in jail. Do you understand? I'm not asking much. I'm just asking to stay clean. That's it. Do you have a Texas driver license?
Yes, sir.
Do you have liability insurance in your name?
Sir, but I don't have a vehicle.
Do you see if he has a license? Any prior DWIs as well?
There are no priors, Your Honor. I'll run his license right now.
You don't have insurance in your name, then you're not allowed to drive any vehicle. You have to have insurance for, I don't care what car you're driving, unless you have insurance on whatever car you're driving, then you may not drive. And don't come up here and tell me, well, the car has insurance. No, people get insured. Do you understand?
Your Honor, he's eligible.
Okay. Did you want to apply for an appointed lawyer? You're going to go hire a lawyer? Okay. If you have any issues, if you want me to appoint your lawyer, just come back, tell me, and I'm happy to do it, you know? I mean, money that you have, I'd rather you spend it on school. Are you sure? You don't want an appointed lawyer?
I'll make a phone call to you. Yes.
Okay. Got to understand that if you're going to hire a lawyer, there's a lot of timing requirements with the DWI. Don't sit and wait a month, 2 months, 3 weeks because you're hurting yourself. You got to do it like lickety split. Do you understand? Okay. Like I said, you ever have any issues, come back, talk to us, and we can appoint your lawyer. Okay. For sure. So I'll have you sign a receipt of Victoria. We'll have you get with Felicia for your bond conditions. If you have a change of heart, just come back. You know? Okay. Danielle Free. Miss Free, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge.
Okay.
On November 6, 2024, officers conducted a traffic stop on the defendant's motor vehicle after observing it speeding 55 miles per hour in a 40 mile per hour zone in the 7800 block of Spencer Highway. Upon contact with the defendant, the officer detected an odor of an alcoholic beverage on the defendant's breath, and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 3 out of 8, and one leg stand 3 out of 4. The defendant admitted to drinking and to taking prescription muscle relaxers on occasion. The officer located a case of twisted teas in the defendant's motor vehicle with 2 open cans of twisted teas, 1 in each cup holder. And
consuming while driving?
There were 2 open cans in the cup holders, yes, Your Honor. And DICs were read, and the defendant consented to blood.
Ms. Free, I'm going to find that there's probable cause to go forward with your case. I'm now ordering you not to drive. Do you understand? You are not allowed to drive any vehicle whatsoever for any reason. You will be signing an affidavit with me today promising me you're not going to drive. If I find that you do, I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? I'm also ordering you not to consume alcohol or illegal drugs. You will be randomly tested. If you consume alcohol, illegal drugs, unprescribed controlled medication, likewise, you will go to jail. No more PR bonds. Do you understand? Any prior DWIs, Alex?
No, you're right.
Any prior criminal history at all?
He has a prior racing on a highway that was dismissed earlier this year.
What do you do for a living, Ms. Free? Why?
I just graduated nursing school, so I was a CNA and caregiver in an independent care facility. But right now I help take care of my great grandma, so it's just a lot at once.
So how do you support yourself? How do you eat?
I live with my grandparents and I help them take care of her. She can't take care of herself. She has dementia and a mental disorder.
I'll fill out an application for you. I need to know everything about you, how much money you make, what kind of car you drive, any source of income that you have, money in the bank, stocks, bonds, IRAs. I'll have you fill out an application, but I need to know everything about you. Don't just put zeros because I'm going to send it right back to you. Do you understand? And I'll see whether you qualify. Above all else, do not drive. Do you understand? There's no justification that you can give for getting in a car. Likewise, don't consume alcohol or drugs. If you have a problem, you better address it, because if you don't, I'm going to do it for you. Promise you're not going to like the way that I do it. You understand? Okay. You might give me an application, please. Morning, Mr. Singleton.
Good morning, sir. How are you?
Doing great. You know, it's Thursday, Friday Eve. Ready for the weekend, you know?
Yes, sir.
So,
you have decorations.
Thanks. Well, tell them.
Yes, sir.
Your lawyer has asked for me, or is asking for a bond reduction in your case, but, you know, my concern, and I guess my very, very primary concern, is public safety. You've got a lot of serious charges, and from what I see, your bond is now at around 200,000. You've got 2 open aggravated assault cases, and you got an assault of a family member with us. Our bond is set at 5,002. What did you guys want?
We were possibly looking for a PR bond, due to the fact that his other 2 cases are extremely high. We believe that he should be able to bond out on that. We have been talks, he has been in talks with some family members regarding possibly coming up with money for the other 2 bonds, but reducing it, he would possibly help him out regarding the overall amount that he will have to come up with.
Well, so my concern is, it looks like in September, he had an aggravated assault with a deadly weapon dismissed, right?
I believe that case got filed twice, and they.
So what's going on with the cases upstairs? And is it the same complaining witness as our case?
There's two complaining witnesses on those cases, Judge, and it looks as though it's a different complainant with us.
Is there a weapon involved? Is it a shooting?
On the aggravated assault with a deadly weapon, Judge, so in the felony cases, there's 2 weapons involved, a machete and a gun, a 9mm handgun.
Does he shoot at them? Does he shoot?
At them. So the state would be opposed to lowering bond, Judge, given the severity and the propensity to violence that felony cases also show.
Oh, I think I remember this case. It's about a neighbor, and it's either about like a fence or it's about some bushes or some, right? So
The state's concern is community safety, Judge. So for those reasons, we would be opposed to lowering his bond.
Even if it's not going totally to a PR, if it's possible to do 2,500, that was great.
I don't know, you know, I mean, we gave you a PR bond in this case. I let you out, right? And then you go out, you allegedly have these now 2 aggravated assault cases, where in one, you point a gun at someone.
Shoot them in the head.
And if I remember, it's something so trivial over. Don't talk about the cases though, because I don't want you to.
I wouldn't incriminate myself or anything, but I live by truth, sir. And these people stole stuff from me.
No.
But, Mr. Singleton,
Not that.
but there's a certain way when someone takes something from you, there's a certain way that you gotta act.
I'm the one that
No.
called the police, Your Honor.
And that may be so, but there's still a certain way to act, right? And if you,
Washington?
refresh my memory, because I just don't remember it.
I can read.
Yeah, go for it. Just a brief synopsis.
On or about September 7th, 2024, complainant Sarver in his truck when he was awoken by the defendant knocking on the window with a 9mm handgun. The defendant then pointed the gun at complainant Sarver and demanded that the complainant get out of the car. When complainant Sarver got out of the car, the defendant stated that he would shoot the complainant in the head. Complainant Sarver advised that prior to coming home from work and having his incident with the defendant, the complainant too was also involved in an altercation with the defendant earlier in the night. The second complainant stated that an altercation arose between him and the defendant, which resulted in the defendant punching the second complainant in the face, causing him pain. The second complainant punched the defendant back, and the defendant ran to his house. Shortly after, the defendant returned with a machete in one hand and a stick in the other, and was calling out for the second complainant to come out to the street. So it seems as though he pointed a gun at complainant 1, and then in complainant 2, he punched him, and then when the complainant punched him back, he came back with a machete and a stick.
Sorry, Mr. Singleton, it's just too dangerous for me, man. I can't give you a PR bond. I already gave you a PR bond. We let you out, and then you pick up these 2 serious cases. You know, if we give you a PR bond now, if we were to lower, I mean, what's going to happen? You're going to pick up a 4th case? We're trying to prevent that from happening, you know?
Order in the court. May I speak?
But not about the cases, okay? Just because I don't want you to hurt yourself, you know?
Yeah, I understand, Your Honor, but I don't recall you ever giving me a PR bond, sir.
We gave you a PR bond on, in our case, we gave it to you on 8/12 of 24. And I gave you a PR bond. We let you out of jail. You know, you had certain conditions that you're supposed to follow. No weapons, no contact with the complaining witnesses. And so here we are with 2 very serious cases. If you're able to bond out, and if you have someone, come back, talk, perhaps we can.
My fiance.
No, but.
The person who this is.
You're your own worst enemy, Mr. Singleton. Really? I mean, you're your own worst enemy.
I guess it's the military.
Well, don't blame it on the military. They're choices, right? And
yes,
sometimes choices are made such that.
I know I need help, Your Honor. I'm not saying I don't need help. However,
the problem is that you can't do that after the fact.
I understand.
You got to recognize it before the fact, before it balloons out of control. That's why, you know, and it's not our first rodeo here with you. You've had prior assaultive cases like this. So you have to understand that when you get these feelings, these urges that you're going to lose, you got to try to take care of this beforehand. Now, why don't we have him TRAS'd? Okay, let's see what it says. Let's see how to go forward. You know, if they say that there's treatment, that's, you know, I have options available to help you with these issues. And I'm willing to help you, and I want to. Yeah, we will do it. But the first things first is I got to have you evaluated to see how we go forward. And if you let me do this, and if you're honest with me, Mr. Singleton, let's try to work something.
I will be.
All right. Can you set up a TRAS for Mr. Singleton? Yeah, please. I'm going to set you for an evaluation. I'm going to have you speak to clinicians. Be honest.
I will.
We'll come back in a couple days. Today's what, Thursday? Come back on Tuesday. Let's talk about how we go forward, okay?
Yeah.
Look, this isn't the be-all, end-all, but let's see how we go forward. You know, that's why God put eyes in the front, so we go forward. We don't go backwards. All right? Okay, all right.
Thank you. Appreciate it.
Stay. Okay? You know, Alan, you know, depending on what that TRAS says, it may also help with what upstairs to try to work out some kind of treatment program so that, you know, because it's all just anger, right? Yeah.
That's the first time I see it actually. Okay, so it makes
It may be worth exploring because it'll help, hopefully upstairs as well. Yeah, thanks. Mr. He? Yes, sir. Good morning, Mr. He. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir. Okay. On November 11th, 2024, officers conducted a traffic stop for a defective license plate lamp in Harris County, Texas. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and observed a strong odor of an alcoholic beverage, watery bloodshot eyes, and disorientation. Standard field sobriety tests were administered. HGN 4 out of 6. Walk and turn and one leg stand were not administered due to the defendant becoming belligerent. Walk and turn, prior to termination, they had detected 1 of 8 clues. The defendant read the DIC and refused to provide a specimen. A blood search warrant was obtained and executed.
Any prior DWIs?
No, Your Honor.
Okay. Mr. He, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. We will randomly test you. If we find that you consume alcohol or drugs, you will go to jail. And that's it. Do you understand? Do you have a valid Texas driver license? Do you have valid liability insurance in your name? You may continue to drive as long as you have both, and Mr. Murphy will tell you if it does become suspended. If it becomes suspended, you may not drive. Now, because you have a lawyer, we will waive your appearance. You do not need to waste your time coming to court, but you must stay in touch with Mr. Murphy, and he will tell you if and when you have to come back to court. If he tells me he can't get a hold of you because you're gone and you're not responding, I will issue a warrant for your arrest.
That won't be an issue, Your Honor.
I don't think it will, but we have to put you on notice of what we expect and what happens when you start acting up. So we will have you just sign a reset with Victoria. We'll have you get with Felicia for your bond conditions, and then you guys are free to go. Okay?
Judge, thank you very much.
Guys, we're talking about Akin Pelu. Is he on the docket today or no?
No, you just want us to come back.
Let me give you a cause number, guys. And
I remember this case, Judge.
I'm at a loss of everything, you're on 2 different felony probations, both of those for driving while intoxicated. Both of those are felonies. So it's not only do you pick up 1 DWI third, but you pick up a second DWI third. Get on probation for both of those. And now you've picked up here, driving on a suspended license. We ordered you, number 1, not to drive, and number 2, not to consume alcohol. That's all I've ordered you to do. Just don't consume alcohol and don't drive. Has anything happened upstairs?
Well, Your Honor, to be fair, I think the integrity of the machines are in question. 11-7. So when he picked up the first one on 10/29, you told him to test Monday and Thursday.
You mean pick up what? The machine?
No, when he when you thought it was a tamper on 10/29, he started testing Monday and Thursday, which in this case helps us. So on Thursday, 11/7, he was here in court where he tested. He tested at 12 o'clock. At 11 a.m., they got a tamper and a sign of alcohol. However, he tested clean with the test you told him to take that day. So which tells me that that machine's integrity is not correct. So if the integrity, and he's maintained that he has not been drinking either time. Every time we did the court, I promise he's not drinking. So if that machine is saying tampering alcohol and he goes and tests on 11/7 at 12 p.m., an hour after the tampering and alcohol, then he may be telling the truth. And I understand what we're dealing with, but he has tampering, sign of alcohol, and then it dissipates and there's nothing there. So
I'm on the same page as you as far as I never want to punish someone who's never done or who has not done anything wrong. That's not, we don't do that. We're the exact opposite. I mean, I scrutinize every single thing that Michael does. Every case, every probable cause, I don't think, I scrutinize the hell out of it. But at the same time, I also do that with people that are in front of us as well, as people with charges, right?
And Your Honor, and to say off the record, I know that you do that. I know that you are a judge that will be very fair in these situations. So I'm just saying that.
So he takes a urine sample, it looks like on 11, what day was it?
11/7.
11/7.
I think the sample was taken around noon. He did two that day, one upstairs and one downstairs. So 11 and 1 o'clock, he had to do two different samples. 11, I think 07, they say he tampers and a sign of alcohol occurs. So he was here in court, but still have two urine analysis around the same time to say he.
Alicia,
Yes,
do you
Judge?
have a test for 11/7? Because I don't have it.
Yeah.
Yeah, so it's probably not in those records because right now it's just presumptive. It was presumptive, but it's negative. So nothing came back. I have it on my end here. It should be,
What time was the positive for alcohol on 11/7?
for the scram report. Let me see.
I thought it was like 11 a.m.
Sorry, normally I don't look over those reports because I don't know how to use them, but I will try to figure it out.
Hey, Judge, I might have an unupdated report. The only BVR I have here is for a scram violation from October 30th.
Yes.
Was there another violation?
Yeah.
Okay.
So there's a violation technically pending our end because he was coming in that day, so I addressed the violation. And so they were waiting to file it to see if judge wanted that to be filed because he was going to address it at court. And that's what we're discussing from 11/7. So that violation is pending a DVR because the judge is taking action on it already.
Do we have a,
I could have sworn you said that there's another presumptive alcohol
On 11/7.
on 11/7.
No, there's a presumptive negative for the POC test that he took, our rapid test.
No, yeah, right, I know that
On
one.
11/7, it was a alcohol detected, but.
What time was that?
I'm trying to read the report.
Because that's, we've got
So I got it right here from Brittany Gordon. The defendant order was obtain a scram device. The defendant's scram device has confirmed one tamper event. The tamper event occurred at 11/7 at 12:42 p.m. Now he was taking the test at 12:30 p.m.
You're saying it was 11/7.
At 12:42 p.m. Got this email on November 11th. It went to everybody in the court. And alcohol was detected during the tamper. However, alcohol cannot be confirmed as consumption because of the nature of the tamper.
It began at 2:25 p.m. and returned to baseline at 8:04 p.m.
We also took another test with you guys on 11/7.
Yes, that was at 12:47, I believe. Let me double check.
What? So at 12:42, he tests positive for alcohol, and then at 12:47, he tests negative for alcohol. Am I right?
It was, sorry, let me see real quick. It was Tuesday, October, I'm sorry, Judge, respectfully, I have no idea how to read scram results and everything that's in my email, but I can check on the direct test for you.
Well, so the 11/7, we have the email on November 11th, okay? Then if you go to the email she just sent me, it tells you when the lab test was submitted. Hold on. She just sent me this email. And this email from A versus size individual screening report. On 11/7, it says that it was, one of the collection times was at 12:08 PM on 11/7, 12/24. He did negative. So that means while he was in court, he would have to drink. But then he took another test after that. I don't know what the other test is at. What I'm saying, Judge, I've been saying this whole, if we were in trial right now, the whole integrity of these machines would be in question right now, because in the previous test, because the same exact message that we got on 11/7 was the same exact message that we got on 10/29. Scram temper, alcohol cannot be confirmed, same thing. So what I'm saying at this point, he's maintained to me, and I know he's messed up numerous times, he's maintained to me that he has not touched alcohol since his last situation. He did drive, he's wrong for that, but these new testing procedures that he's gotten,
What do you mean he did drive?
that's why we're in here, because he was driving.
So due to the charge, though.
Yeah, he did drive.
I hope to God that you're not driving this driving.
No, I'm talking about due to this charge, while we're back in your court.
Okay.
Judge, I don't have any of those emails. I think the best thing at this point is we can set this off for a bond hearing, and I can bring Ronald Grant here to clarify all of this with all of us, because none of us are experts. We don't know how to read the report. I know what defense is saying, but I can't even tell you the veracity of anything that's happening because I don't even have these emails.
Yeah, so
I can subpoena Ronald Grant. We can do this next week. I can get it done.
Let's not disrupt other people's lives. It's not necessary.
Sure.
He is saying that we have a test, and I mean, what Mr. Evans is test 11/7, the scram at 12:42, there's a positive, but then 7 minutes later, there's a negative when he goes up there to test. The machine's obviously messed up if that's true.
Is that what you're saying, Felicia?
And then I've also noticed on the scram report, I asked them, because again, myself, I cannot acquire this, I have to have it provided from our case managers and the, provided for the device. But the scram report, the only one that I'm seeing attached to the email is for the DVR that was filed, for the 29th, but I'm not seeing the one from 11/7.
So we don't have a scram report from 11/7.
We have an email.
It's not attached in the email, but we do have the rapid test when he was on site.
The rapid's negative.
Yes, and then we were informed, like I informed you yesterday, of the pending BVR violation for the 11/7 at that time.
Hold on. So, Judge, we don't even have the scram report. We don't know what the presumed blood alcohol content was. It's very possible that if he had a very low blood alcohol content or breath alcohol content, that the scram detected that he could have come to court, taken a test, and gotten a presumptive negative, because it's already been eliminated from his system. That's why I'm saying I believe we need to get that scram report from 11/7, get what the tamper is, have Ronald come up here and tell you what's possible or what's not possible, because he's the expert, and I get what defense is saying, but he doesn't know either.
But let me respond to that. What we do have is a test that happened at 12:07.
Right.
And I can show you that one. So even if we don't have the one that she spoke of at 12:47 that she referred to, we have a test right here, which will make us have to believe that he, while in court, he drank some alcohol if these machines are deemed to be valid. And we were about to reprimand him for the 11/7 situation, but now it's time to
reprimanding or remanding. He's suggesting that we just do it at a later time to get everything all together.
Okay, well, in the meantime, since these machines,
I'm not going to take him into custody until I know 100%.
but can we, because he's working, he's come here. The reason why you put him on Monday, Thursday is because these tamper going down. So we're going to wait to see if these machines are valid. I'm requesting that we go back to the same bond conditions that we had prior to the tampering, so he does not have to miss work twice a week coming out here and testing, because all we know, this could be a big mistake.
And I would strongly object to that, Judge, based off what he's on probation for right now.
But the only reason why we're doing the twice testing is because of the tampering. So if the tamperings are invalid, why are we doing something extra when that wasn't what the judge originally wanted?
Well, because there's an allegation right now. We need time to confirm or deny that. But for now, the safety of the community warrants these bond conditions, in my opinion, Judge.
And I strongly disagree.
Mr. Evans, we have a curfew on, right?
I don't think we have a curfew. We just have the scram. You just have
He
the
has a
scram.
curfew, Judge.
Well, so, okay.
So,
Are you working now?
yes, sir. Working with a hospital in, I have a project with, Epic. So I assist, physician and nurses on the software they use. Called Epic. The software is called Epic.
I don't want anyone to lose a job. I mean, the last thing I want is someone to lose a job, right? But I have to know that you're not drinking. I can tell you. I know that you tell me no, but all I have are consistent problems. Every time we had you on docket for whatever it may be, there was always problems. Every single time you came in here with the DWI, there were issues. Every time you came in here with the suspended license. And I'm telling you the history that we have.
Understand.
You know? So that's why it's hard to believe all these coincidences when the nature of my relationship with him was every time we had a case, there was at least 3 BVRs. Every single.
And I was completely on your side. I thought he was telling me not the truth. But once I saw that he was in court that day.
Let's do this. Let's set it for next week. Let's get every record, subpoena the person, right?
Can we do next Friday, Judge? Is that possible? I'll be in trial next week till about Wednesday. Can we do next Friday? Okay.
Or not Friday, Thursday? Okay.
Friday's okay? Yes, Judge.
Yeah, and do you want me to waive the appearance?
I just want you to waive the test.
Okay, I will.
Yeah.
I will.
Yeah, that's all I want.
But he's got to be here for the next BVR here.
No, you can't, yeah, that's fine. Yeah, I just want him to be able to work. So thank you so much.
I'm tired of having to deal with one problem or the other. I would suggest that you go now, go get a new machine so that we know that there are no more issues. Go down there, tell them, hey man, give me a new machine so that we know if there are any issues, that way you can make sure that you get a new one. Felicia, can we send him for a new one now?
Yes.
Just to make sure that, Okay, so you guys pick it, we'll do it. And then we'll do it. We'll take them off that.
Thank y'all.
Yeah, we'll stop for now. Yeah.
So you send me the test upstairs,
Okay, Connor. Okay.
Salazar, Your Honor.
Good morning, Mr. Salazar. How are you?
No good. How about yourself?
Friday Eve. So,
Got everything worked the felony out, Judge. He pled guilty to the felon. I believe they reduced it to a lesser included, reduced it to a misdemeanor.
Oh, they did?
Yeah. And,
Okay, so it's not a felony. Good.
but they're deported. They've already got the deportation order saying on it.
Really?
Yes, sir.
Yeah.
These are things that you got to think about, man. When you're not in this country with permission, you have to think about these things, because when you start acting like a fool out there, they can put you in immigration custody, and then you're stuck like Chuck and then they'll end up, sending you back. What's going to happen now? Is it from Mexico? Where is it?
Yeah.
Yes, sir.
Yes, sir.
So do you have family there? At least when you get there?
Yes, I do.
Okay, well, that's good.
Yeah.
The only thing I'm gonna tell you is that if you want to come back here, do it the right way. You gotta ask for permission first. Don't just come here. Because if you get caught with the feds, you could be looking at serious time in federal custody. Years and years. Don't just come. Do things the right way. And when you do that way in life, good things happen, So what are we doing here?
We're pleading true to the MRP violation, Judge.
In essence, I mean, there's nothing we can really do anyways, because you got the ice hole, so it's,
We had 40 days before they come pick him up.
all right. Did you agreed to voluntary departure? Is that what happened?
Yes, sir.
Yeah, okay. All right, so Mr. Salazar, you were placed on probation for assault of is it a family member, right?
That's correct, Judge.
So there is an affirmative finding.
Yes, sir.
You have to understand that you can never own a gun or ammunition as a result of this. There's an affirmative finding of family violence. So if you ever pick up another one of these cases, you will be looking at a minimum of 2 years in prison, a maximum of 10 years in prison. A second assault of a family member is a third-degree felony. Do you understand? The other thing you need to understand is that you now have had already a felony reduced to a misdemeanor. The likelihood of them doing that again, it's like lightning striking twice. You understand? Is it true or untrue that you violated your probation?
True.
I will find that it's true. Let's do that on allegation number 15, that he tested positive.
Yes, sir.
Not on the
Law violation.
law violation.
Yes, sir.
All right, I'm going to find that is true, Mr. Salazar. I'm going to sentence you to 90 days in jail. I'll give you credit for the 78 days that you've done. Like I said, there's an affirmative finding of family violence. You can never own a gun or ammunition as a result of this. Just be careful, man. You know, if you want to come back, do it the right way. Ask for permission first. All right? Good luck.
Thank you.
Thank you, Mr. B.
Yes, sir.
All right. Anderson, tell me about Mr. Anderson.
So there is a bond violation.
Come up, Mr. Anderson.
However, we worked out a deal with the state,
What?
and to reduce it to a first and then 12 months probation.
Okay.
We have the paperwork in your,
Are we doing that now?
if you'll allow us.
Sure.
Okay.
Is this a foregone conclusion that you're going to go into rehab, Mr. Anderson?
Yes, sir.
Because I'm going to tell you now, this is now makes 3 bond violations. The next time you even go next to alcohol, I'm going to put you in a rehab facility.
Yes, sir.
Understand me. I don't care what you're doing. I don't care what it is. You come here kicking and screaming. If I find that you use while you're on this probation, I will amend conditions to put you in a rehab facility. You could be in there for a very solid year, depending on how well you respond to treatment. Do you understand?
Yes, sir.
Okay. It's up to you. If you want to do it, I'm game.
That's his decision.
It's up to him. Okay, done. Do it.
You need to do the.
Are you, I'm sorry, are you ready to go? Okay. Mr. Anderson, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement that they're offering you 180 days in jail to be probated for 1 year. As part of the conditions, you will do a DWI repeat offender. It must be a repeat offender DWI education class, okay? 1 victim impact panel, a TRAS to see what other conditions you may need. You must fulfill those conditions while you're on this probation. No breath test refusal. So if you're pulled over in a car and an officer asks you to submit to a breath test, you must take the breath test. No drugs, no alcohol, guardian interlock, 16 hours of community service. Do you have children, Mr. Anderson? What does he have on now? Does he have on a guardian interlock? What does he
He has
have?
a scram right now.
Okay, I'm going to keep that on for now because I'm suspending his license for a year and I want to make sure that he's not consuming alcohol at all.
So you want him to have the scram and the interlock?
And that's with the franchise, so it'll have to be taken off and then you want to be put on some.
Okay, no, I don't want to take this off until he puts the other one on though.
And Judge, just a reminder, this is a drug. I don't know if that changes your
No.
decision.
I have here that he consumed alcohol. So he's still using. I don't care how minute any alcohol that you have, Mr. Anderson. I'm telling you, you consume even a smidgen of alcohol, you will be looking at a motion to revoke that gets filed, and then you will be perhaps and very possibly looking at a rehab facility in the jail. Do you understand? I would like him TRAS'd today. Since he's here today, he gets the TRAS today. And in the TRAS, I wanted to make it known that he has, this is his third bond violation, and that he has a consumption of alcohol 3 days ago, because I want that part of their analysis and how to move forward. So what part of what you are agreeing is that you are agreeing to whatever conditions. What conditions are being done by the TRAS? So I don't know what they're going to assess. They may assess intensive outpatient treatment. They may assess supportive outpatient treatment. They may assess something else. Whatever they assess, you must fulfill those conditions. Do you understand? The other thing that you must understand is that even though they're reducing this to a first, and the reason that they are reducing this to a first is to a first DWI is to bypass the mandatory 5 days in jail. That's why this is happening now. But I want you to understand that for the next 70 years of your life, you have all these charges on your record. So if you get pulled over from now on, even the slightest smell of alcohol, you will be in felony court looking at a minimum of 2 years in prison, a maximum of 10 years in prison. Do you understand? Sir. So I wouldn't even step near a car if you've had something to consume, or if you've had any alcohol whatsoever. Even if you take too much NyQuil, that will cause a loss of the normal use. You understand? You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this or undo this. Do you understand? How do you plead to the second offense, DWI, being reduced to a first? Guilty or not guilty? Guilty. Guilty. Is it above a .15? Is this above a .15, Morgan?
No, Judge.
Sorry?
No, Judge.
No? All right, I will find you guilty. I will send it to you, the agreement. What do you do for a living, sir?
I build valves for oil rigs.
And how much money do you make a month?
About $2,000 a month, $2,000 a month.
How much do you really make a month?
25.
How much do you really make a month, sir?
2,500.
Order in the court.
I'm not going to assess court costs, but I don't know about assessing the surcharges. That's why I'm asking these questions.
The surcharge shouldn't be assessed on a probation. It's only on a final conviction.
This is a conviction.
It is a conviction, but
It is a conviction.
it's not for DPS. They don't consider it a final conviction because,
It is, though. It absolutely is. We're not doing a deferred.
right, it's a final conviction for the purposes of it being on his record forever, but not for the surcharge.
Okay, so I'm going to take a look at that now. I don't believe that that's the case because I'm going to issue the surcharge on him.
Okay.
Okay? If it's not, I mean, I'll take a look now after it dies down.
Okay.
But I don't think that's right. But, and, I mean, you'll be around, right?
Yes.
Okay, give me a second. Let me thin out the line and then we'll talk. All right. Take a seat, or I'm going to have you sign all the paperwork.
Yes, sir.
Watch yourself, Mr. Anderson.
Yes, sir.
No tolerance. All right. Good luck.
Sit down.
There's an open container. That's a minimum of 3 days in jail.
So we are sending them
Did you want me to abandon the open container?
I'm okay with abandoning it, Judge.
Okay, all right.
Do you remember the one you said yesterday?
So what's going on?
I'll let you finish up, Your Honor. The defendant ended up calling us back later in the afternoon, but that was after.
Are you guys happy?
Yes, sir.
You want to withdraw it?
Yes, sir, I do.
Done.
Okay, perfect. Thank you.
Okay, for sure.
And Judge, before we're done, there's a companion case that's being dismissed as part of the
Right, and I see that the gun case will be dismissed. Oh, what about the gun, though? Are you guys forfeiting the weapon?
I believe that was part of the agreement.
Okay, the weapon will be forfeited. All right. It'll be coming.
Do you want him to speak with probation?
Yes, please.
Judge, I just had a question. You want us to do grandma and sweet?
Correct. Yes.
And then they can sign it.
Is it all right if I text one of our clients?
Of course. Yeah, of course.
Judge, see my attorney, is it okay if she stands up here with us?
Sure. Hi, how are you?
Good. How are you?
Welcome. Who do we have here?
We have Miguel Gonzalez, Your Honor.
Okay. Good morning, Mr. Gonzalez.
Good morning, Your Honor.
Mr. Gonzalez, you were placed on probation for driving while intoxicated. It is now alleged that you have violated that probation, specifically in that, I guess we're not going to go forward on the Berg habit.
Correct. We agreed that we're going forward on the 3 technicals, not the first 2 new law violations.
Okay, I guess to make it easy, we'll just go forward on the failed to perform the community service hours as ordered. Is it true or untrue that you violated your probation?
True, Your Honor.
I will find that as true. I will now revoke your probation, sentence you to 75 days in jail. I will give you credit for the 8 days that you've done. Did I suspend the license?
It wasn't the first time?
Because when they get on probation, normally, unless it's a second, so was this a first?
It was originally filed as a second and pled down to a first.
No, you're saying I didn't?
You did it.
Okay, I have to now. I'm going to suspend your license for 180 days. Mr. Gonzalez, don't drive until you get a license, otherwise you get into a car, you're rolling probable cause, man. You understand?
Yes, sir.
Okay, good luck with you.
Thank you, Judge.
Thanks, guys.
May I be excused?
Yes, ma'am. Thanks.
Good morning, Your Honor.
I will be
Repeal it.
pleading non-guilty today, and I will be representing myself.
Okay, there's a certain way we go through things. Just bear with me a second. So the first thing is that you're charged with failure to stop and give information. You're facing up to 6 months in jail and or 2,000. I know that you're ready to say, go through your list of this and that, but because you want to talk, you're not listening. I need you to listen for a second. I'll give you time to talk, I promise. Just let me get through the spiel and then I'll give you an opportunity, okay? You're charged with failure to stop and give information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay, we're just going to do probable cause because I don't know what happened. Maybe there's no probable cause and then you're out of here. I don't know. Stop. You have the right to remain silent. Exercise that. They're DAs. Every single thing you say, they're going to sit there and type to use you.
I know, that's my right.
Just hold on. Let's do probable cause first.
Okay, Judge. On June 15th, 2024, officers were dispatched to a crash. They met with the complainant who reported that she was involved in a crash with a Toyota Tundra and provided the license plate number. The male with gray shorts, no shirt, and tattoos stepped out of his vehicle and offered the complainant to follow him back to his house, and the complainant declined the offer. The defendant then left the scene without giving any information and sideswiped the complainant's vehicle a second time. The officers began to head to the car's registered address, 0.4 miles away, when they received a second call for help at the address they were headed to. At the address, a male matching the description provided by the complainant was having a mental episode in front of his house. The defendant admitted to driving and leaving the scene without giving information. The damage is approximately $2,000.
Okay. All right, Mr. Peeler, I'm going to find that there's probable cause to go forward with your case. How old are you, sir?
So on June 15th, I was in a state of psychosis, and I have documentation of the settlement that took place for the liability property damage which occurred on that incident. I have the claim number in front of me if you need it, Your Honor, for that settlement. I have the mental health crisis documentation discharge summary provided by the Harris County Constable living at 13800 Lake Superior Lane if you need that. Upon further request, I can provide documentation of the discharge from the hospital that I went to.
Let's do this.
Supporting the mental health,
Mr. Peeler.
and I'm disabled, so.
Let's do this. Why don't I have you talk to a lawyer? Okay, your lawyer can talk with you, get to know you, find out what happened, and then they can approach the state to try to, see what's going on.
'Cause I'm disabled and I don't want to be, and I never was.
Just don't say anything.
Warrant at all. I never received anything in the mail, not once. So how can we help?
Sometimes cases work like that. Sometimes a person is involved in some kind of situation where a warrant will not issue immediately to where they get taken into custody at that time.
Well,
Those are called,
in the mail, so I assumed that I would have received something.
never assume anything.
You're right.
Never assume anything. But let's do this. I can have you talk to a lawyer here momentarily. You can explain your situation to the lawyer. The lawyers can talk to the DA, and then we can work something, okay?
So.
Just hold on.
I agree.
I don't want you to say anything because there's a bunch of DAs here and everything you say, they're going to use it against you. I will give you the opportunity, but first let me have you talk to a lawyer. I've got a bunch of them and they're great. They truly will help you out. Okay? Really. Yeah. So let's do this. I'm going to have you go to Victoria, sign a reset. I'm just going to have you take a seat in the jury box while I find your lawyer. Be patient though. I've got 150 people here, Mr. Peeler, okay? So just be patient, okay?
Failure to, well, I actually did stop. I mean, for the record, we both have exchanged words outside our vehicle.
Okay, come on.
Doctor? Bessie?
Good morning, Ms. Stokes. Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On October 31st, 2024, the officer was dispatched to a Walmart in Harris County, Texas, in regard to a theft. Upon arrival, the officer met with the complainant, the loss prevention staff, and the defendant. The complainant advised that she observed the defendant concealing items on her person along with skip scanning items at the register. The complainant then observed the defendant proceed to walk out of the store, passing all points of sale. Total cost was $49.92.
Stokes, I'm going to find that there's probable cause to go forward with the case. I'm barring you now, and I'm ordering you not to go to any Walmart for any reason. You understand? If I find that you go to Walmart and I don't care what your reason is, I'm going to put you in jail. You will not get any more PR bonds. You're already on bond for a felony theft as it is now. It's very possible they revoke your bond and issue a felony warrant for your arrest. What happened with the felony theft that she's on now?
Your Honor, on the felony theft, it says that the officers were on patrol and ran the vehicle through NCIC and noticed the vehicle was reported stolen. The traffic stop was conducted. The driver of the vehicle was identified as the defendant. The complainant identified herself as the sales manager of the auto dealership and stated the defendant came into her office to purchase the vehicle for $11,000. The complainant stated the defendant presented 3 money orders for $1,000 each as down payment. The complainant stated they only allowed the defendant to leave with, they allowed the defendant to leave with the vehicle. The complainant stated several days later she found out the money orders were stolen. The complainant contacted the defendant and told her to return the vehicle immediately, which were ignored.
And I see that she has yet another one from March of this year as well. Same thing?
Let me see, Your Honor. In that incident, she used stolen identifications and rented a car for 1 day and was supposed to return it, but failed to return the vehicle.
I'm ordering you not to drive. I'm making it a condition of your bond that you're not to drive. Do you understand? Do you have a Texas driver license?
Yes, sir. Yes, sir.
All right, Your Honor.
You know what, let's do this. I'm going to appoint your lawyer today, ma'am, and then we'll talk about all your bond conditions. I'm going to have you sign a receipt of Victoria, and then I'm going to have you take a seat in the jury box, ma'am. Do not go away until we have you talk to the lawyer, okay? Please.
Right this way. All right, Judge, next is page 19. Warza, Emily.
Is it Miss Warzibach?
Worsbach?
Ms. Worsbach, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. On October 23rd, 2024, the officer was conducting surveillance at a department store in Harris County, Texas. The officer observed the defendant enter an Old Navy. The officer made contact with the complainant, the loss prevention manager, who stated the defendant entered the store, selected multiple pieces of clothing, and walked towards the front of the store. The defendant abandoned merchandise on the table, but kept a white sweater. The defendant passed all points of sale with the unpaid sweater, causing alarms to sound. The officer observed the defendant remove the security tag and throw the tag on the ground. The officer made contact with the defendant and recovered the sweater.
Okay, Ms. Worsbach, I'm going to find that there's probable cause to go forward with the case. I'm sending you now for a drug test. I want to know what, if anything, is in your system. I'll appoint your lawyer today, but I'm sending you for a drug test. If you fail to go take the drug test, if you fail to come back, I will issue a warrant for your arrest. You will not get any more PR bonds. Do you understand, ma'am? Okay, take your seat for me, please.
Walk through TRAS. We're time for the FER today.
You've done the TRAS? Okay, great. That way we know what to,
About to start a job at Fiesta. There's somebody.
Can I get the thumbprint first?
We need your thumbprint, please. I've got another Brown on a DVR. That's why I thought it was. Okay. All right. Good morning, Ms. Brown. Ms. Brown, you're charged with assault, bodily injury. You guys have worked out an agreement. They're offering you a 13-month deferred. That is a type of probation that if you complete it successfully, you do not end up with a conviction on your record. This is really important. You don't need a conviction because when you get one, you become very difficult to employ, meaning it gets very difficult to get a job. The more convictions you get, the more difficult it is to get a job because people know that you have a volatile, meaning trigger temper, that if you get upset, holy moly, she could lose it and just, so it's really important that you make this work. Not only that, if you complete it successfully, you can have it sealed after a while so that the public can't see it. I will pay for it for you. If you complete this and you can qualify for the sealing, I'll do it for you for free. All you got to do is come back. And I'll make it even better for you. If you do everything you're supposed to do, stay out of trouble, I'll cut you loose in half the time. 7.5 months, you can be done with this thing, no conviction on your record. How does that sound? Be nice. It's not hard. That's all you got to do. If you get upset, walk away. Go somewhere else. When I get upset, I distance myself from everyone. I'll go over there. I'll go run. I'll find something else to do. My kids piss me off like crazy. What do you think I do? Yeah. It would be very easy for me to just beat them into submission, beat them and spank. No, that's not the right way. If I get upset, I get up and I leave. I'll walk out of the house. I'll go to find something else to do. That's what you need to do when you get upset. It's not the end of the world. It's never the end of the world. All right? So, what does the TRAS say that she has to do?
She's gonna have to be in the mental health.
Okay, great.
Career management, cognitive behavioral therapy.
Okay.
Job skills training, and monitoring and psychotropic medication and treatment.
Great. That sounds great. Do this 7 months, I'll let you loose, and then you're done. We early terminate people all the time for when they do well. We let them go in half the time. My only issue is, will she qualify for funding? Do you know?
I would have to ask.
Because she doesn't have any money, and if one of the conditions on here is GPS monitor, There's no way she's gonna be able to pay for that. I know that we have, is it
Because
TLAP?
that was something that her case manager had recommended that he thought would be helpful for her, and so.
I think it's a great idea. But what I want to do is be able to pay for it because I know that she can't, and I can't waive the fee while she's on probation, but she might be, I know that she'll qualify for the funding. Can we try?
We can verify.
Yeah. I'm going to try to get you to qualify so that you don't have to pay for anything. Okay? But if you ever have a problem, do you have Josh's number?
This is my tablet, so I don't have any contact.
Who took it?
My God.
Did she tell you, is it she or he?
She.
Did she tell you how you can get it back? Is the guardian here now? How did you get here?
My group home, staff. We did it.
Are they here now? Where, are they in the courtroom? Can you, who is it?
Miss Simone.
Yeah, but where? Miss Simone, come on, coming up, ma'am, please. Yes, come on up. And Josh, give her my card too, will you? This is my card. If you ever need anything, all you got to do is just, you have us. I mean, Miss Brown, we're always here to help, you know? All you got to do is just make a call, send me an email.
I'm Simone.
Hi, thank you for coming. So they took her tablet.
Yes, they did.
How can she get it back?
In 1 month, if she behaves well.
You can get it back. It's not the end of the world. If you're good for a month, they're going to give it back to you. Right? Can you do that? Okay. You'll have it back in a month. That gives you a way to be able to contact us. So she's getting into a probation today. It's a 13-month probation. I told her that if she does well, then we'll take her off in half the time. All she has to do is the anger management class, stay up on her medication, and then there was one more important thing. What was it? The cognitive, it's therapy, okay? Do that, things will go well, all right? You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you enter into this agreement, this is a contract you're signing with us. You either complete it successfully, or if you violate it, I'm going to issue a warrant for your arrest. We put you in jail. I'm going to bring you back out in orange, like you've seen all the other people that come out, and we're going to discuss whether you violated it. And if you did, we can put you in jail for an entire year. Do you understand this? This is serious business because you could go to jail for an entire year if you violate this, if you get violent with someone, if you do something you're not supposed to, if you pick up a new case, if you don't do your classes on time, if you break curfew, it's a problem. Can you get it done? Okay, I wish you luck. How do you plead to the offense, guilty or not guilty? I won't find you guilty. I'm going to wait 13 months. Make us proud. You'll be done in 7.5. All right? All right. Good luck, Ms. Brown. Artavia Ellis.
Yes, sir.
Ms. Ellis, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. I know you don't have one, but we're going to do probable cause first. Okay.
Yes, Judge. On November 8th, 2024, officers were dispatched to a disturbance at a residence in Harris County, Texas. The complainant stated that he and the defendant had been dating for at least 2 years and stated that he and the defendant had been staying with each other at the defendant's apartment or his apartment. The complainant stated that on November 8th, 2024, the complainant stated that he was seated on the couch and the defendant became aggressive and punched the complainant on the right side of the face, and the complainant stated the defendant then jumped on him and put her burning cigarette on the right side of his face, leaving a mark and causing him to feel pain. The complainant stated that he told the defendant to leave, but she refused. The complainant was afraid and called 911, and the officer spoke to the defendant, who stated that she and the complainant had been dating for 3 years and that she and the complainant had a verbal argument over a cheating issue in the living room. And the defendant stated that the complainant kept bothering her, accusing her of cheating, and kept following her around. The defendant stated that she then ashed the burning cigarette she was smoking on the complainant's face because the complainant used to get violent with her in the past, and the defendant stated that she did not punch or have any physical contact with the complainant.
Ms. Ellis, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're consuming alcohol or any illegal drugs, I'll put you in jail. You will not get any more PR bonds. Do you understand? She has a prior assault of a family member. Is this the same complaining witness, guys?
No, Your Honor, it's a different.
It was my ex-husband.
We don't need your help, please. You have the right to remain silent. Exercise that right. If you say something when you think it's going to hurt you, it may very well hurt you. If you think you're trying to help, just don't. I'm ordering you now not to have contact with this person. I'm entering in an order for protection that identifies London Renfro as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. Do you understand? That means you're not allowed to go within 200 feet of 10307 Dell Court in Missouri City. You cannot go within 200 feet of that address.
What is address?
Okay. Until I know differently, you're not to go within 200 feet of that address. You know, we can work things out. My only and my primary concern, Ms. Ellis, is public safety. I will do everything in my power to protect every person of Harris County. If I have to put you in there kicking and screaming, crying, and praying to whatever God there may be, I don't care. Do you understand? What do you do for a living?
I drive. I work for Amazon.
Do you have a Texas driver's license, ma'am?
Mm-hmm.
Do you have liability insurance in your name?
I don't currently have a vehicle right now.
You said you're driving something. You have to have car insurance.
I use their vehicle to deliver packages.
Okay.
So yes, I do have a driver's license.
How much money do you make a month?
Not much. I haven't worked in like a month. I've been having problems with my heart, so I haven't been at work lately.
Are you still earning an income?
As of a month, I haven't worked in like a month because I took an absence of leave because I've been dealing with my heart problems.
Okay. I'll have you fill out an application, but I need to know everything about you. I need to know how much money you have in the bank, what your monthly income is. Don't just put zeros because I'm going to send it back to you. I need to know everything about you, and I'll look to see whether you qualify for an appointed lawyer. Okay? Do not leave until you sign all of our bond conditions. Otherwise, I'll issue a warrant for your arrest. And remember, no alcohol, no illegal drugs. That includes smoking marijuana. If you smoke marijuana, okay? Please.
It's everything.
All right, Judge, can I come over here, ma'am? Next judge is case
Can you file no contact and no weapons as well, please?
15. Sarah, come on up. Judge
Victoria, what did you say?
Page 15, Sarah.
Edwin Sura Aparicio. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Good morning, Ms. Reyes. Okay.
Yes, Judge. On November 10th, 2024, the officer conducted a traffic stop on the defendant's vehicle after observing it run a red light and through an intersection. After the officer turned on emergency lighting equipment, defendant's vehicle accelerated at a high rate of speed. Officer activated sirens. The vehicle slowed down. Upon contact with the defendant, who was the driver of the vehicle, the officer observed red bloodshot eyes, slurred speech, and a strong odor of an alcoholic beverage. The defendant admitted to drinking. Standard field sobriety tests were conducted. HGN, 6 out of 6. Walk and turn, 3 out of 8. One leg stand, 0 out of 4. The DIC was red, and the defendant continued to breath. The results were 0.15 and 0.149.
You said the stop was for
Running a red light, Your Honor.
Oh, he ran a red
He ran a
light.
red light, and then the officer pursued.
Got it. Okay. Mr. Sura Aparicio, I'm going to find that there's probable cause to go forward with your case. Tell me, are you a United States citizen?
Resident.
Do you have a Texas driver license?
Manejar de Texas. Yes.
Can you run his license? Do you have liability insurance in your name?
De responsabilidad. Bajo su nombre. No.
Then you're not allowed to drive.
No se le permite.
I am making that now a condition of your bond. You're not to drive any vehicle until you have car insurance in your name, and we were able to see it. Once you obtain that, come back here, show us that you have it, and then I will take this restriction off. But until I know every person of Harris County is protected in the event that you get into an accident, you're not allowed to drive. It's just the law.
Seguranza sistema, pensé que era como seguro.
Oh, I'm sorry, I do have insurance. I thought you were talking about life insurance.
I don't care about life
No, a mí no me
insurance.
importa de seguro de vida.
Car insurance. Show me that you have it with your name before you leave here today, and I won't put this restriction off. I want to know that you're protected. I want to see that you have car insurance, and then we won't restrict your license, your driving privileges. I am ordering you, though, not to consume alcohol or illegal drugs. I will randomly test you. If I find that you're consuming alcohol or any kind of illegal drugs, I will put you in jail. You will not get any more PR bucks. Do you understand?
¿Entiende? Yes.
Okay, you have a lawyer.
Tiene un abogado.
Job having a lawyer. Because you do, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Mr. Reyes, and he will tell you when you have to come back to court. If Mr. Reyes tells me that he can't get a hold of you because you're playing games, I will issue a warrant for your arrest.
Una orden de arresto.
Do you understand?
¿Entiende? Yes.
All right, guys, well, I'll have you sign a resale with Victoria. We'll have you get with Felicia for your bond conditions, and then free to go.
Thanks, Judge.
All right.
Have a great weekend and day.
You too.
Time for your reset. All right, Judge, the next Spanish arraignment is page 8. Hernandez, Ramos, come on up.
Parece que conteste a voz alta, por favor.
Okay, Luis Armando Hernandez Ramos,
Estamos. Yes, I am.
charged with driving while intoxicated. You were facing up to a year in jail and or a $4,000 fine because of the high blow. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
No diga nada.
On November 9th,
El 9 de
2024,
noviembre del 2024,
officer conducted a traffic stop on the defendant's vehicle at approximately 10:47 p.m. after observing it weave between two lanes and fail to signal lane changes. Upon contact with the defendant's vehicle, the officer observed a strong odor of an alcoholic beverage, red glassy eyes, slow speech, unsteady balance, and a glazed over look. The defendant had inconsistent statements and trouble with the timeline of the evening. The defendant admitted to drinking beer in his truck prior to driving. Standard field sobriety test.
Did he have alcohol in the car while he's driving?
Your Honor, yes, and towards the end of the statement. So, Officers conducted standard field sobriety tests, HGN 6 out of 6, walk and turn 8 out of 8, and one leg stand 3 out of 4. An inventory search of the vehicle revealed 5 empty 32-ounce Corona bottles, one 32-ounce Corona bottle with 1 ounce.
Corona, I'm sorry, can you repeat that?
Oh, fair.
Go a little bit slower, huh?
Thank you, sir.
An inventory search of the vehicle revealed 5 empty 32-ounce Corona bottles, one 32-ounce Corona bottle with 1 ounce of fluid in the bottle, and one empty 24-ounce Modelo.
Un modelo vacío.
Drinking while driving?
DIC was red, and defendant consented to arrest. The results were .174 and .173.
Mr. Hernandez Ramos, I'm going to find that there's probable cause to go forward with your case. Tell me, are you a United States citizen?
Ciudadano de Estados Unidos.
President.
I'm a resident.
I don't know if you are or
Yo
not.
no sé si lo
And
es o
quite
no.
frankly, I don't care.
Francamente, a mí no me importa.
But one thing I want you to understand is if there is any problem with your immigration paperwork whatsoever, and you go to jail and immigration finds you, they will put an immigration detainer on you and you will be stuck like Chuck in jail until this case is over with. And then you will be shipped off to immigration where you will sit for another 6 to 9 months. I hope that you would recognize it's damn elementary for you not to have alcohol in the car while you are driving. You now, I am barring you from driving whatsoever. You will be signing an affidavit with me today promising me that you're not going to drive. And I don't care what is going on in your life. If I find that you drive in violation of this affidavit, I can have a hearing to hold you in contempt, slap you with up to 180 days every time you drive.
Yes, cada vez.
Do you understand?
Entiende. Yes.
You cannot give any justification at all for getting into a car and driving. And there will be a very hefty toll. I'm also ordering you not to consume alcohol or illegal drugs, and I will randomly test you. If I find that you're consuming alcohol or any kind of illegal drugs or unprescribed controlled medication, likewise, you will go to jail. You will not get any more PR bonds. And like I said, any issues with your immigration whatsoever, you will be with me for a long time.
Estar ahí por largo tiempo. Okay.
I will have you come up here, swear to us that you're not going to drive. I will have you sign a reset with Victoria. I will also have you sign your bond conditions with Felicia. We will get you out of here because you need a lawyer to represent you, and we will give you time to go hire a lawyer. When you come back, hire a lawyer. If you fail to come back, I will issue a warrant for your arrest.
Yo entonces voy a dar una orden de arresto.
Hurricane or not being out past curfew can land you back in jail.
All right, Judge, the next Spanish arraignment is Vasquez Jose.
Romero, do you want to take a guess what in God's name they would do to you in prison? You have
Judges can revoke bond instantly. You cannot play around.
had already in September. You get on probation. 3 months later, they file a motion to revoke your probation. They keep you on your probation. They extend, or they did whatever they were going to do. And now 2 months to 3 months later, you're back yet on another revocation. Do you have any clue what they would do to you in prison? You and your 18-year-old self. Do you know what they do to 18-year-olds in our Texas prisons? Take a guess what they do to 18-year-old kids in prison. Take a guess. I read stuff that had me damn near in tears because it was so bad what they do to certain people when they go to Texas prison in Huntsville. They literally treat you like a freaking rag doll, pass around like it's a freaking cigarette. You are chattel, meaning a piece of property. That's only the half of what they do to little young children in Texas prisons. You have now are on your second motion to revoke. It's only a matter of time before they say, you know what? This little dude don't get it. Let's send his ass to prison for 3 years. When that happens, you'll be crying for mommy and daddy. And if you don't believe me, start asking the people in jail. They'll tell you. I'm happy to roll it whatever you want, Jillian.
Let's do that. Thank you,
If you want to
Judge.
do a week, 2 weeks, whatever you want.
That's fine.
Get a clue before it becomes too late and you become a piece of chattel. Okay.
All right, sir. Oh, it's okay.
Mr. Thurman, you're back. Okay. So I told you before, two of my main concerns are, or my two main concerns are, number one, are you going to go back to the jurisdiction that where you're wanted from? And number two, most importantly, are you a danger to my public? I take public, safety. It's as important as my hair. You know what I mean? It's that important, right? Because I don't want anything to happen out there with my name attached to a bond. I try everything in my power to ensure that everybody's protected. And I see that you're wanted for a really serious case. It's an armed robbery, right? I mean, that's what you're wanted for. There's no denying it. That's what it says on the paperwork.
He's on lifetime probation in Michigan.
Lifetime? There's such a thing as lifetime probation?
Yes.
Whoa.
So that Kate, I'll let you do the talking.
No, he did his time and he got out and lifetime probation out of Michigan. So that's what's happened. I believe it got.
How on what would, aside from like a murder case,
So he was
what
charged
would garner?
twice, along with 2 armed robberies.
I wasn't charged twice for no murder.
It just shows up.
It just shows up
Oh, I was
twice.
about to say, I wasn't charged
Murder
twice.
along with armed robbery or aggravated robbery in our jurisdiction. He's placed on probation. Since that time, he's been charged in our jurisdiction with aggravated assault with a deadly weapon and felon possession of a weapon. In those, he had bond conditions when it started off, where he was ordered to have a GPS monitor. He has had multiple curfew violations on top of that noted. And so I do believe he's a safety risk, because even with literally an ankle monitor, he doesn't follow court conditions. And so I believe he is a safety and flight risk. And the fact that there was a weapon involved with multiple witnesses, some of them children, him threatening to murder them, is that I would be opposed to a bond being set. Also, it should be noted that because of the way the probation was transferred, I can't confirm, so I can't approach on it yet. But from what I see on the system is that he moved the probation to Texas, which means there's an ICA. But I don't have the documents, which is why I can't present them. If there's an ICA hold, he's ineligible for a bond, because that's an ICA hold. I don't have it, which is why I can't say. But if I get the documents.
Interstate compact agreement.
I understand. May I speak, Your Honor? Of course. Okay. After we talking about the probation, I'm at the probation, the GPS curfew wise, my judge knows all that was going on. So he knows every information and why I've been late. I have evidence of why I'm late. So he knows everything that's going on with my GPS.
You're not supposed to be late.
He knows why though.
I understand.
That's why he said, okay, it's fine. So he said it was fine.
Quick question, is it a motion to adjudicate?
Well, no, it's still an open case. It's not under probation, but you're just asking if they do a bond violation report. They did on November 1st, 2024. They filed a motion to revoke.
Oh, so it's recent.
It's very recent.
So they've not
This month.
heard, okay, and then so there's not been a hearing on that yet, right?
No, but that's even after they amended the order. Also, he has further bond violation reports on December 18, 2023, another one on November 28, 2023, and that's after they amended it twice. One moment. So he seems to be agreeing with this. So the fact that he has 3 violations on top of having lifetime probation and a possible ICA, obviously, I'm still opposed for him.
Why are you on lifetime probation?
That's the way they set it up as. I took the plea deal.
What are you on probation for?
The armed robbery, conspiracy to commit armed robbery. I did 5.5 years. Came home off lifetime probation. And to continue what I'm saying, I'm a threat to, a flight risk. I can't be a flight risk. Every court that they set, I came every single time. Every court that Michigan have set, I flew out there every single time. I knew I was getting locked up Monday. They told me that Thursday. I still showed up to court. and we got locked up. So there's no flight risk in this whatsoever if I'm been showing up every single time.
And you may be showing up, but at the end of the day, you continue to do what you want to do without regard to bond conditions.
And what do you mean by that, Your Honor?
Meaning that they put you a GPS monitor, and they give you a curfew.
Yes.
And you don't abide by the curfew.
I was working, Your Honor. That's why the judge has stated, because they had my probation curfew time at us. I forgot what time they had as, but I had started my new job because I came, got locked up, lost my other job. He said, okay, the violation he's talking about, I came into court and talked to the judge, and he extended my curfew. He was like, okay, we've been working. I said, yes, I have documentation of new work. So I show all my documentation, and he said, okay. So the stuff he's mentioning violations for, they already been taken care of. So he's not stating that either. He said 2023 is, obviously I'm still free, right or wrong. I'm still free. That means he's seen all the paperwork. I came with legit paperwork.
And that's kind of where I was coming from at it. If it's a lifetime probation and it's curfew violations that he's still out, my speculation would be that he was able to make an explanation to the judge, and that's why he's not been revoked. So he's still here. As to the underlying charge, it's still a charge and that's what it is. Like he said, he turned himself in on Thursday knowing that he was going to get arrested and held. And so I'm sure that Michigan it's a probation violation because of the underlying charges. And plus, that's where that MRP is probably coming from. I believe he's proven time and time again that he's gone to Michigan, taking care of what he needs to take care of, and he will still be here he's been on bond on the underlying case for about a year. Your Honor, he's not been locked up this whole time up until this recent arrest. So, and at this point in time, this is really just for if since we don't have proof of an ICA, if the judge is willing to set a bond, how much that would be, if there's a willingness to set a bond.
Let me read this to you.
Yes, Judge.
Okay. Texas Code of Criminal Procedure 17.03. NLR, out of state Michigan, armed robbery, armed robbery with a conspiracy, 2021. Probation transferred to Texas 3/2021. Concurrently charged with murder, which was dismissed. No holds. Defendant is not indigent, and defendant is alleged to have gone to complaining witness's home and pointed a gun at complaining witness and complaining witness's 3 children because one of the complaining witness's children was involved in a dispute with defendant's sister at the child's school. Defendant threatened to kill, quote unquote, everyone in the home. Defendant then left complaining witness's home and came back with defendant's father, both ready to fight complaining witness and complaining witness's wife. That's the aggravated assault that we have now. So, knowing that you're on lifetime probation for a very serious case, you know that you're supposed to be out there with a halo over your head. And yet you pick up an aggravated assault with a deadly weapon where allegedly a gun is pointed at kids. I mean, the way your mannerisms.
I wouldn't say something, Your Honor, that's why.
But don't, though. You have this open case.
Understandable.
Everything they can say, they can use it against you. My concern is public safety, man. And you got to understand that I don't know if you're guilty of this offense or not, but the problem is bad stuff keeps happening to you for some reason. It's like sometimes people are their own worst enemy. They get out and then something happens and then they just end up picking up another charge. It's like a cold. You pick up another charge, you pick up another charge here, you pick up another charge there, you don't follow bond conditions here. Mr. Thurman, you scare me, man.
Did I scare you, Your Honor?
Yeah.
And I've been out for a whole year since this case happened, and this is my first time being into this courtroom again, and you're fearful for safety if I've been doing nothing but right and working.
That's not true.
That has been true. I've been out for a year on bond and I have not been into this no courtroom, but in orange jumpsuit, I should say. Your courtroom, anybody's
You want
courtroom.
me to reward you for
I'm
being a
saying,
good
but you say you're in
person?
fear. You say you're in fear for safety. That's what I'm saying. Like, who are you in fear of? I've not been into any trouble whatsoever. I've been squeaky clean. Just I bind it out.
And Your Honor, to
You
your,
don't get rewarded for being a good person out there. You know what I mean?
I
You're
understand.
supposed to be like that anyways.
I understand that wholeheartedly, Your Honor. I'm just saying, but you say you fear, and I'm saying, how are you in fear if I've not been doing anything? That's showing you. That should show you some type of sign. Like, okay, he's not been doing anything wrong. So where is the fear come to play? That's what I'm asking you.
The fear is really because, when people come here, it's little bunnies jumping in the woods, rainbows, gumdrops. And then when they get out there, they turn into different people. It's like Jekyll and Hyde. And I don't want that. Like, I don't want someone out there to suffer because we let you out. I let you bond out. You've got an armed robbery, you've got an ag assault. You continue to violate conditions on those bond, right? That shows me that you're not willing to abide by bond. I mean, quite frankly, you're lucky to even be out on those charges with the ankle monitor, and you continue to violate.
In Your Honor, you keep saying violate. Like, if I was in violations they have on file, by the way. Those have been taken care of. Once again, you keep on saying violations, but they took care of. The felony court judge seeing I have proven, what's the word I'm looking for? Just proven, facts that this is why I'm late. I have a new job. I got fired because I got arrested from the other job, so I started a new job. For me having a felony in my position, and just call it what it is, a young black man with a felony, it's hard for me to get a job anywhere. So the jobs I do get, I take up on those. So it's hard. Any shift they open up for me, I'm going to take it and show my work ethic to them. So I let the judge know that. He sees that. He understands, like, okay, that's why you keep on bringing up violations. I have to work. I have to eat. I have to have a house to live in, like anybody else here. So you keep on bringing that up. I'll keep saying, I already talked to the judge about it. He granted it already. He let it go. That's why I'm still free to this day. Well, was free to this day. And you keep bringing that up. You say threat to your fear, which is understandable. Everybody gonna have fear. But I have not been into any trouble. I've been working. I've been working for a whole year. I've been on my P's and Q's. And like you say, the police report that you're reading, sir, the case is still open, so I can't really speak on it. I'm pretty say much, but it's a lot more to what you're just reading on that police report. It's always gonna be video cameras and house ring cameras, body footage. It's gonna be a lot more other things that you're not gonna be able to read off a police report. It's just understandable.
Just too much blood, Mr. Thurman. I'm sorry. I can't set you on. It's just too much. I'm sorry. Hey, this isn't.
Do not walk away.
This isn't.
I said, okay, it's fine.
Really, I understand that you're hurt, Mr. Thurman, but look.
I've been doing my best, Your Honor. And y'all sit here telling me I'm the bad guy, and I've been doing nothing but my best of my abilities, working, staying out of trouble. And you're a threat, and I'm a threat to society. Really? For a whole year I've been out? And they just not issue a warrant for me just now recently? And I come to turn myself in, and I'm a threat to society. And people, if you fear me for what? From turning myself in and show you that I'm not running for nothing. I'm not running for anything. I'm innocent, and I'm coming to show you I'm innocent by turning myself in. But y'all a threat. You can let go of me, sir.
Stop.
You can let go of me.
You do not tell me how to do my job.
Just you can let go of me. Grab my arm too tight.
Guys, relax. Relax.
Arm too tight. All I said, grab me. Look how you grabbing me up.
Back up.
Look how they grab me. I said you let me go a little bit.
You gotta calm down.
I'm calm. I just asked him a question. I asked him a question. Let me go a little bit, sir. That's all I said.
Open the door.
That's all I said. When you make somebody cuss you out, you think? You said I'm all tight. You just look. You know what I'm saying?
So he already waived, so if
He did.
holds it, then it's.
I can't.
I'll go talk to him, but once again, Judge, understandably, I think I know that he's frustrated. I believe.
I understand. I get it. And I would be too, but I can't. That's just too much blood. It's too much.
It looked like there was.
Even, what I'm going to tell you, even if he didn't have those bond violations, I'd still be very hard pressed to even,
No, and I was curious because when she brought it up, it was a little bit older, and so I was wondering why.
Do you know, are they going to come get him?
I'm not gonna get him. I was trying to figure out why now, and they were just having back and forth.
But here's the problem. So he hasn't made bond on those cases. So we're sitting anyways.
Yeah.
He has not?
No.
He said he did.
No, he's not made bond on those cases.
He's been in jail for a year?
No.
He may have, but they revoked the bond.
Ah,
Yes.
So he's sitting there and I didn't have the heart to tell him right now that the 14 days is not going to apply.
Yeah.
Because
I gotta do that.
I really.
I would
I
imagine.
will, I'll let him know.
I would imagine it's gonna get resolved, because it's one of those, it's a bizarre, so we revoked, Harris County revoked because Michigan revoked because it was charged with the ag assault. So it's a chain of events, because the only thing the court sees is that they revoked on the probation, which was caused by.
Please let him know that the 14 days hasn't kicked in and it will not.
It will not kick in.
Resolves.
Right.
And either he resolves the cases.
So which one does he need to resolve first in order for?
Well, for the felon possession of the weapon, there's, hold on, I don't want to.
Is there an offer?
No, it's going to trial. That's why it's been reset out. It's been set for jury trial at least.
Four times.
4 times. 1,
Yeah.
2, 3, 4, 5. Yeah.
5 times, Judge.
Next time is January 6, 2025. But he's held on $55,000 bond for the ag assault and $55,000 for the felon possession. So he has to come up with $110,000 for.
Wait a second. So
it doesn't matter what you did today.
can't. Even if I gave him a bond today, he would still have to make those bonds.
$110,000.
So my question now is, when did that warrant for the felonies pick? Because he's saying he's been out for a year ever since this ag assault got picked up.
I show a remand defendant custody on November 18th, but I don't know what the previous.
So the only reason why his felony bonds got revoked was because Michigan revoked.
Oh, no, it doesn't, but we don't know that for sure.
Yeah.
Because there's no notes that reflect why they revoked the bond. It just says court directive remand defendant to custody. Let me see if they give an explanation. Hold on.
Okay.
It's remand to custody, violation report, but that's not a revocation. Yeah, because.
It's a violation report from Michigan?
No, for me, so remember when I said the newest violation was on November 1st for all the curfew violations?
Mm-hmm. Is that from here?
Technically, that could be the reason why they revoked instead of Michigan. I don't know, because I don't have the document.
Yes.
So.
But he hasn't gone out to Michigan to I guess take care of
For that
the
one,
current
that
bound
one since
violation.
2023, so it would have predated.
I get you.
Take some time for them to do it, which is why I hate it, because they should have waited to file it. But whomever originally had him, well, actually, if he said he was in the courtroom, that happened. Yeah, sheriff's office. So they should have known to wait and file.
I got you. Okay.
Okay, well, I guess reset to track locals. Oh, man.
Don't set it to January.
I'm not. When in December would you like to touch base?
Now, my question now is, does it matter for us to touch base if his locals are going to be reset far out? What's the point of?
Yeah, we have to,
You gotta do like a plea deal,
makes sense.
or mid-trial dismissal, because it's Troy Locklear on the one of.
So let's do this. Do you see a date for like a pretrial motion or a pretrial setting for them?
They file a motion.
Highly doubt it, Judge.
I mean, there's nothing between here and there. Judge Jones, I would be surprised if they set another.
Okay.
So if you want to talk to Troy.
18th, 17th of December?
17th of December.
Finner?
No.
Is it Troy Finner?
No.
Troy Locklear. So hold on, December 17th.
I'll find out.
Yeah,
All right.
okay.
17th or 18th, whichever one of those days works for you, I'm good by it.
I live in this building, you tell me.
And then if you have any problems with him, we can bring him back out as far as just tracking locals, meaning that just let him know they revoked the bond. And essentially the time here is kind of told until he either gets a bond reinstated, post bond, or somehow deals with the case.
Because the bond is set, so if he can come up with the money, he can. But I'll put 17th, and then if you want it sooner, or a couple
Got
days
you.
out, let me know.
Sounds
See you
good.
tomorrow for.
Yes, sir.
Okay.
I think
Thank you, Judge.
we are done.
Maybe excuse, Judge.
Oh my God.
And Your Honor, I filed dismissal on moves. I eval.
Come up, Mr. Burrows.
Also, we did the. I was in the process of appealing this on Friday. I was on back and forth with Nathan.
Appealing.
Appeal for a pizza. And
Oh, so they denied him?
No, we're almost there. He took the decision, and then this came, so I just wait to talk to you. I told him about this on Friday, and he drove straight to the pretrial services. alcohol test because, but, that's what's going on. I'll look at this.
So, but I don't understand what you're saying about appealing. What are you?
No, I'm doing a P-tip appeal because he's not necessarily allowed to P-tip what the situation is, so I did.
You mean you're doing a mitigation packet?
I already did it. Everything's turned in. I did everything, mitigation packet.
They said yes.
I don't know yet.
Oh, you don't know?
We're going back and forth, and then I stopped that because I literally, I got that report right then and there. I was going back and forth with Nathan on Sunday.
Do you guys have any guidance on boroughs? It looks like he's filed for the diversion program for the DWI.
Amanda?
Just whether he's been accepted into the program.
Are you Amanda? I'm sorry.
I'm not. She works for recovery unit.
Okay.
So I believe that Nathan he was waiting because there was a previous DWI that was filed out of county, and he was waiting to receive the OR from that previous DWI. Because we don't know, it might have been dismissed.
No, it was dismissed. I gave him the dismissal paperwork, and it was because there was nothing on it.
But I still have to know too, so I can take the appropriate action as far as bond condition.
I'm happy to email Nathan right now. I think we just received the OR this morning.
Where from and when?
From Galveston County. Let me look for the judge.
This case has been open since June. I'm just now finding out that he had.
I didn't know it either because he thought it was expunged because it says interest adjustments, no evidence for DWI. Basically, it was like he had no. It was nothing. Just got thrown out. So that being said, he said he didn't do anything. That's whatever. That's that. But
yeah, I think it had been. I think that we are all in agreement that it was dismissed. I think Nathan just wanted the copy of the offense report.
What year was it?
1 second, Judge. Yes, Judge, the DWI is from 2019.
Yeah, I probably would have put an interlock on him.
But the reasoning on the dismissal, they put it on there.
And now he's still consuming alcohol, Mike.
That's what I'm saying. He's here to tell you, I don't believe that's the case. He swears up and down he didn't.
I have a scram.
I understand that. And he puts some crazy amount of makeup on him, and the alcohol, I gave you the pictures of it also. It's called alcohol what's it called? Hang on. He can explain to you, but I have it here.
I have pictures of
the nature alcohol can be mistaken for alcohol consumption. I know.
I have these pictures. It has no date. It has
to give you context to it, I have the dates here. Those are just pictures of the close-up makeup, but he was DJing on those particular dates. And I have it right here because I was trying to get it in the club.
And I guess drinking while DJing, right?
No, he said he wasn't. I mean, you talked to him. I wasn't there. It was DJ Sidney Ray, October 31st at this place, and that was the day in question. And then this is October, this one, I'm sorry.
Okay, so
October 27th.
I have here that you're consuming alcohol. I have here that the consumption is October 26th.
Yeah, that's the
October 30th.
And
November 9th. Oh, and October 9th. So I have 4 different events that you're consuming alcohol.
For October 9th, Your Honor, that was whenever you told me to put the scram on, and I put the scram on right after that. And then those other 3 dates.
So you're allegedly consuming alcohol the day I tell you to put it on?
No, he did it that's the day, and then he put it on. No, that's the violation. We addressed that.
I have a positive for alcohol on the 9th of October.
Not from the scram, I think.
Yes.
October 26th.
I sent him on 10/9. So Felicia.
Yes, Judge.
So we sent him for a POC test on 10/9 on that time. Did he test positive for alcohol?
Yes, Judge.
Why on earth are we just now getting the violation?
The violation was already addressed.
That was addressed.
Yes, that violation was already addressed in a previous BVR. They started to put it in that section, that's why I didn't highlight it. But
Did I address that BVR?
yes, and that's why we amended the conditions to put a scram.
Okay, so now we have alcohol consumption as a second violation on top of all this.
For the scram itself.
I've been very grateful for the second chance you gave me. That was from the makeup that I applied to myself, and I was just ignorant to the fact that that would actually set off my scram device, but I have not consumed another alcohol beverage at all. Those are also the days that I was working, I was entertaining, I did not consume another alcohol beverage at all, so I've been very grateful. I'm not stupid, I wouldn't consume another alcoholic beverage after you put the scram device in.
Mr. Burrows, I told you at every single stage of this game, do not put anything into your body that could be positive for alcohol. It is your responsibility to know what you can and cannot use. You're old enough to know that actions have consequences.
Yes,
and
sir.
here we are. I've already let you go one time with a positive for alcohol. When I told you not to consume, you literally tested positive on the day that we sent you for the test, and now we have another 3 positives for alcohol.
I don't think that's all. That's the part, the other parts, yeah, but the first part, that's not, he didn't test positive.
He tested positive 10-9.
No, that was.
It was a positive urinalysis test, and because of that, we amended the.
And because of that, I amended the conditions. I did not put him in jail. I put the scram on him.
Yeah, but we addressed that he didn't go in and like.
I got it.
It's not 2 tests, is what I'm trying to say.
Okay.
You're right.
But he's continuing to consume. Stephen.
The scram reports are also in your email. I'm not sure if you viewed them, but we got the notes of the records as well for all of those dates.
Have you seen that?
I have whatever I was sent yesterday.
That's it.
I'm sorry, Mr. Bros. What am I supposed to do? Just let you go again?
No, sir, I'm not asking to, and I did not consume any alcohol. It was just yes, sir. The products that I put on, and I just was not aware that that was set off that. And it was makeup, sir. That's all it was. I didn't consume an alcohol beverage at all.
That party is 10:31, and I have here 10:26, 10:30, and you're telling me that you put this makeup on November 9th? Is that what you're trying to tell me?
Yes, sir. It's for my TikTok, and I have the videos of it also, sir. I do cosplay, and I just put on those products, and that was the sweat from it. I had no idea that would actually get inside my blood system and and set that off.
You have levels?
Yes, they're in the scram report.
What is it?
I have.
It's like a peak of 0.08, and then.
He's a 0.08.
Yes.
You're telling me that makeup made you a 0.08?
Yes, sir. And those are the days I was at work.
I don't believe it for a second.
I
don't believe it for a second. I'm sorry. A 0.08 because of makeup?
Yes, sir. I understand. I promise you I have not consumed alcohol at all.
I'm sorry, dude.
I understand.
That's it.
Yes, sir. I understand.
With you?
I understand, yes, sir.
And possibly believe that makeup is going to make you as intoxicated as having 6 to 8 drinks. ¿Qué has hecho cerca de este caso?
Mandé a hacer las placas.
Prueba.
No, mandé a la señora.
Cuando tú haces cualquier cosa con el DPS o DMV, te dan prueba. Un email, receipt, algo te dan. Muéstrame algo que tienes, que has hecho.
Pregunté a la señora que es la que me está tramitando la placa y me dijo que no tiene nada, que a ella no le dan información.
So, no has registrado entonces, solamente hiciste una pregunta.
No registré.
Pruébamelo entonces.
Tengo mensajes de texto con la persona, la gente que me está haciendo el trámite.
Muéstramelo.
¿Puedo ir por mi teléfono?
I'm not going to take his word that he's just asking questions. I want some kind of proof that he's doing something, you know? Yeah, I mean, go get your boys, see what he's doing.
You want to bring back these? Oh,
Typically, Victor, as long as they start registering and you have proof,
No, I understand.
that's good enough.
My understanding is that he's going through somebody else to get the process done for him.
Ahí están mensajes. Cuando lo hice, le hice el pago, mandé toda la información.
So, I don't know if you want to see this, Judge. This is text message string. This is the inspection that he did that he sent to the lady who's doing the process for him.
Ayer mismo le pregunté si tenía.
So this is the actual registration?
That's the person who's doing the process for him. So he's sending her all the information, she's doing it for him.
I don't understand why he can't do it.
Whatever he feels comfortable doing, Judge, I don't know.
We got to put a time limit on this thing.
Okay.
It's 200 days. I mean, it's,
I'm only asking for one more reset.
how long do you want?
My last person was reset to December the 17th.
That day, if it's not done, it's plea or trial. I'm not going to give you any more. Tú no tienes más tiempo para la próxima vez que tú regreses aquí. Si no lo tienes hecho en total, no me importa un coco que tienes que hacer. Jurado con juicio la próxima vez. ¿Entiendes, Méndez? Okay.
Understood.
All right.
Appreciate it.
SFBF, please, Jermaine.
Yes, sir.
Right, Ms. Zuniga on page 30 is the first one.
Good morning, Your Honor.
Hey. Happy hump day. Wednesday. So we have Ms., is it Magali Zuniga?
Yes.
Ms. Zuniga, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge.
Okay.
The officer initiated a traffic stop after observing the defendant weaving between lanes and disregarding a traffic control device on an exit ramp. The defendant stopped her vehicle in the middle of a moving lane of traffic on the entrance ramp to Katy Freeway, and upon contact, the officer observed a strong odor of an alcoholic beverage and glossy eyes. The defendant admitted to drinking a couple beers and stated that her last drink was at 9 p.m. and that she believed the current time was 11 p.m. or 12 a.m. It was actually 1 a.m. Centerfield sobriety tests were conducted, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 4 out of 4. The DIC was read and breath was refused. A blood warrant was signed and executed.
Okay. Can you look to see if there are any prior DWIs, please?
There are no prior DWIs, Your Honor.
Okay, Ms. Zuniga, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license? Can you get a license, Alex, please? Do you have valid liability insurance in your name? Okay, you're not allowed to drive unless you have both, but I am now placing a restriction on you and your bond that you're not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're consuming alcohol and kind of illegal drugs, you will go to jail. You will not get any more PR bonds. Do you understand?
I understand.
Because you have a lawyer, I will waive your appearance, but it's your responsibility to stay in touch with them, and he'll tell you when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. So don't get in any trouble. Don't use, and just stay in contact and everything will be fine. All right. We'll have you sign a reset with Jermaine. We'll have you get with Fleischer for your bond conditions. And then after that, you guys are free to go.
Thank you very much, Your Honor. Great to see you.
Mr. Adams on 2 is our next one, Your Honor.
Okay.
I just feel just like.
Morning, Mr. Adams. Good morning. Mr. Adams, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during any questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
Yes, Judge. The officer initiated a traffic stop after observing the defendant's vehicle run a red light and travel 73 miles per hour in a 60 mile per hour zone. Upon contact, the officer observed a strong odor of marijuana and asked the defendant when he last smoked. The defendant stated, "You caught me, I just finished rolling one." The defendant then handed the officer the blunt, and then the defendant gave the officer 2 bags of marijuana, approximately 0.636 ounces of marijuana.
Did you say there was the odor of weed in the car?
Yes, Your Honor.
Okay, Mr. Adams, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license?
Sir.
Run his license, please.
Yes, Your Honor.
Do you have valid liability insurance in your name? Are you sure?
Yes,
Do you have car insurance?
Yes, sir.
If you don't, you're not allowed to drive. I'm making that a condition of your bond, Mr. Adams. I want you to understand that I take it extremely serious. If you don't have car insurance, you get into an accident and you maim someone, they're going to come after you, where if you have liability insurance, your insurance takes care of you for all those needs.
Yes, Lord.
I'm not putting any conditions on your bond. Just be careful. Don't pick up any new cases. Do you understand?
Yes, sir.
Okay, we're going to reset your case to give you time to hire a lawyer. I'm going to have you go to Jemay, sign a reset. After that, we'll just get you out of here. And when you come back, please have a
Thank
lawyer.
you.
Okay? All right, be careful, man.
Bowman, page 5, Your Honor. Bowman.
Okay? Good morning, Ms. Bowman. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge.
Okay.
The complainant and the defendant are in a dating relationship and live together. On November 12th, 2024, the officer was conducting a neighborhood patrol and observed an on-view disturbance between a vehicle and a pedestrian. The complainant stated that he and the defendant got into a verbal argument. The defendant hit the complainant approximately 1 time and bit him approximately 2 times on his right bicep, causing pain. The officer observed visible injuries on the complainant's right bicep and his right upper eye. The defendant stated that she bit him because she thought he was going to hit her.
Okay, Ms. Bowman, I'm going to find that there's probable cause to go forward with your case. Have you guys spoken to this person? Do we know whether he wants to continue to have contact with her or not? I'm sorry? Okay, don't say anything, please. I have a bunch of DAs here, and everything that you say, they're going to use it against you. They sit there, type it, so just don't say anything at this point.
A rip was performed, Your Honor, and it's...
So guys, CW is here if you want to try. Because unless I know that this person wants to have contact with you, I'm going to order you not to have contact with this person. It is a Kevin Callahan? Okay. That's Mr. Callahan with the beard.
Yes, Judge.
Okay. Regardless, even if he wants to have contact with you, I'm ordering you not to have any threatening or harassing contact with him. You need to understand what is threatening or harassing doesn't matter what you think. It's what he perceives. So if I go like this, is that threatening, harassing? It is, and it can land you in jail. Do you understand? Do we know if alcohol had anything to do with this, Alex?
There's no allegations of alcohol, Your Honor.
Okay. The only other thing I'm going to advise you, Ms. Bowman, is that a protective order has been issued in this case. I would get to know the protective order, because if you do something to violate that protective order, the state can and will file additional charges against you. And a violation of a protective order is one of the worst cases you can pick up in misdemeanor court. Do you understand? Okay. What do you do for a living?
I work for a consulting company.
And what kind of money do you make a month?
If I keep my job, like 8,000.
Okay, we're going to give you time to hire a lawyer. You don't qualify for an appointed lawyer. So I'll have you sign a reset with Jemay, and then we'll just have you take a seat in the jury box right now while we work out the kinks as far as the no contact order. Okay? Please. First, we'll have you sign a reset.
Our next one, Your Honor, is going to be Mr. Cruz on page 8.
Harassing, no way.
Yes, Judge.
Are you Xavier Luis Cruz? Mr. Cruz, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
The officer initiated a traffic stop after observing the vehicle failed to signal a lane change, and the officer detained all occupants in the vehicle because none were wearing seatbelts. The driver of the vehicle gave a verbal consent to search, and the officer searched the vehicle and located a black and red bag located on the right rear passenger floorboard where the defendant was seated. The officer located the following items: a clear baggie containing meth, ice, and Xanax. and 2 baggies and a scale, and 1 Glock 47.
Was he the driver?
He was the rear passenger, and that's where the bag was located, where he was seated.
Mr. Cruz, how old are you, sir?
18.
I'm sending you now for a drug test. You must come right back. When you come back, we'll talk about your lawyer situation. But if you fail to go test, if you fail to come back, I will issue a warrant for your arrest. You will not get any more PR bonds. Do you understand?
Yes, sir.
Okay. I'm going to have you sign a receipt with Jamae, and then after that, we're just going to have you take a seat while we send you, and then come right back. Don't leave.
Yes,
All right.
Case on 16 and 17 is our next one.
Blake Jenkins. Mr. Jenkins, you're charged with 2 cases. You're charged with 2 counts of terroristic threat. Was he on bond for this case, and then he picked up a new case?
Yes, Your Honor, it appears so, that he was on bond for the...
He was literally on bond, and then a week later, he picks up a new case.
Can I say something?
Don't. Are you here with anyone today?
Sure.
Yes, it appears correct. He was on bond and then he picked up a new case.
So, as what I see, he picks up his first terroristic threat. We gave him a PR bond on November. So, tell me if I'm wrong. So, check this out. Tell me if I'm wrong, but it looks like both of these were just both 2Bs, meaning warrants had been issued, and he had not been picked up. This is Jenkins. And it looks like we picked him up all at one time, and he was given a PR bond on November 13th.
On the terroristic threat?
On both cases, they're both terroristic threats.
Yeah. Yeah, because it would have taken a month for him to get arraigned, so it must have been.
Yes, Your Honor, that's correct. There were.
So he was not on
No,
bond.
he was not. There were both 2Bs, Your Honor.
Now, do you guys know the relationship of Ryan Kalal?
He was just a member at the gym that the defendant attends.
Okay, so let's just go ahead and do probable cause on both cases.
Okay.
So, Mr. Jenkins, you're charged with 2 cases. You're charged with 2 counts of terroristic threat. One is against a family member, so on that one, you're facing up to a year in jail and or a $4,000 fine. Your other case is just against a garden variety civilian, so on that one, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
So for the terroristic threat involving a family member, the complainant and the defendant are brothers. The officer was dispatched to a residence in Harris County, Texas, in response to a family disturbance. The defendant was removing the complainant's belongings from the residence and putting them in the back of his own vehicle to prevent the complainant from getting his things. The complainant tried to remove his things from the back of the vehicle when the defendant stated, "I will kill you." The complainant was in fear for his life when the defendant said this. The defendant also later texted the complainant that if he touched his things again, that he would cause him severe pain. And then for the other terroristic threat, on October 26, 2024, the officer was dispatched to Crunch Fitness in regard to a terroristic threat. The officer made contact with the complainant. The complainant, the manager at the gym, stated the defendant was involved in verbal and physical altercations with other members, and multiple complaints were filed. The complainant stated that the defendant's membership was canceled due to the issue with other members and the defendant making threats. The defendant then continued acting aggressively after finding out this information and caused a disturbance by screaming and cursing loudly. The complainant told the defendant he needed to leave and not return. The defendant became more agitated, left the business, but returned multiple times. The complainant stepped out with the defendant and told the defendant repeatedly not to return. The defendant responded multiple times he was going to come back to the business and kill the complainant.
All right. So, Mr. Jenkins, I'm going to find that there's probable cause to go forward on both of your cases. I'm now ordering you on both of your cases not to have contact with each of those witnesses and not to go where they either live or where they work. Do you understand? In the first case against your brother, a protective order has been issued. So I would get to know that protective order, because if you violate the protective order, they will file additional charges against you. You violate those conditions, I can hold you at no bond. Zero bond until this case is over with. And I want you to know that I will protect every single person in Harris County by all means necessary. And if that means putting you in jail, locking you up at a $100,000 bond, $50,000 bond, $2,000, whatever it may be, it's going to happen. Do you understand?
Yes, sir.
I'm also ordering you not to be in possession of any weapons as well. You're not to go back to Crunch Fitnesses also. Do you understand?
Yes, sir.
You pick up any known cases, violate even one iota of these conditions, I'm going to keep you with me. And I'm going to tell you now, it's going to be high. And if you don't have anyone to pony up that kind of money, $10,000 to get you out, you will be stuck like Chuck in custody until these cases are over with. And I'm going to tell you, it takes damn near 9 months just to get a 911 tape. Do you understand? How old are you? What do you do for a living?
I worked in catering, and then now I'm doing solar. So I'm a sales representative.
What kind of money you make a month?
I haven't made any money. Right now I'm living off unemployment checks because the money I had from my last job ran out, and the money that I'm making on my new job is all commission, so I have to close the deal before I have any income.
Who are you living with?
I'm actually living in my car at the moment.
Okay. I'll have you fill out an application for an appointment. Actually, let me see your name. On this application, you says your spouse's salary is $10,000 a month. What does that mean?
My what?
It says under spouse's salary, $10,000. You make a total income of around $11,000 a month.
Did I fill that out? I didn't fill that out.
I'll have you fill out a new one then.
Okay.
So you're living in your car?
Yes.
How is that?
I mean, it's fine as long as it's not too high.
Sucks. Sucks to live in your car, doesn't it?
I mean, I don't have any money, so I mean, it's better than the street.
What I'm trying to tell you is that when you're living in someone's house, under their roof, don't bite the hand that feeds you, because
It was my brother that I got it.
register what I'm trying to tell you, Mr. Jenkins. If you're under someone else's roof and they're kind enough to take you in, when you bite the hand that feeds you or burn a bridge, you never know when you may need to cross that bridge. Now you've burnt the bridge, you can't even cross that bridge, you're living in a car. Living in a car sucks. So be nice. It's not hard, especially when you're living under someone else's roof. It's not that hard. And if you get into an issue where you fight with someone or you're upset, walk away, find another release. Do you understand what I mean? It's not hard. Be nice. Would you mind giving an application? I'm going to have you fill out this application because I need to know everything about you as far as money-wise. I'm gonna have you sign a reset with Jermaine, and then I'm gonna have you take a seat in the jury box where we get all your orders ready, and while I find you a lawyer, okay? Okay.
So I'll be on the court today.
Yeah, I'm gonna have you talk to a lawyer today. So don't leave until I excuse you.
Our last one, Your Honor, is Mr. Walker on 28.
So on both of those, no contact, no weapons, and they're going to Crunch Fitness and please.
Yes, Judge.
Are you Johnny Walker? Mr. Walker, you're charged with driving on a suspended license. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. The officers were dispatched to a minor accident in Harris County, Texas. The defendant provided the officer with his driver's license, which returned as not eligible. The officer noted that the defendant's license has a mandatory suspension with no lift date. The defendant also admitted to not having insurance on the vehicle.
I know.
Mr. Walker, do you have a Texas driver license?
Not a license ID, I have.
You're not allowed to drive. If you drove here, you're not allowed to drive home. I will have you now sign an affidavit with me today promising you you're not going to drive. I don't know what you're doing in your life. I don't care who you're talking to, what you need to do. Nothing at all can ever now justify you getting into a car and driving. If you do, this is an affidavit. You are in violation of the affidavit, and I can have a hearing to hold you in contempt of court and slap you with an additional 6 months jail and a $500 fine every time you drive, because it's an offense in and of itself. So if you drive 5 times, I will have 5 contempt hearings. Do you understand? If you want to drive, go get a license, get liability insurance, and then we can talk, and I will happily take this off. But if I find that you drive, there will be HE double hockey sticks to pay.
Your Honor, the defendant said he has questions.
About an occupational license, what, do you have any information on it?
I cannot give you legal advice.
Okay.
What I would do, first and foremost, is go get your license. That's what you need to do. So you need to really do the legwork, call DPS, and find out what you need to do. Don't take a half-ass approach, because that's what you're trying to do. You're trying to take the easy way out, and that's not the way to do it. You need to call DPS. I will even give you the number to DPS for you to call. That's the number to the driver's license division to DPS. When you call them at 7 o'clock sharp as soon as the phone line's open. Don't call at 7:02, 9:05, 1:42, because you will never get through. I'm telling you this from past experience. The only time I ever got through was to call right when the phone line's open, which is at 6:59 to 7 o'clock, because then you'll get through to.
This drug test could make or break the next step in court.
Talk to someone, call them and say, okay, this is my number. This is who I am. What do I need to do to get my license back? Has it been more than 2 years since you've had a license? Then you're going to have to retest. You'll probably have to take the driver's test. You'll probably have to take a written test just to get it back, not to mention surcharges and everything like that. Well, Ms. Caldwell, you were charged with assault of a family member. You are facing up to a year.
Failing to follow bond rules is never worth the risk.
You're in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you next.
Yes, Judge. The officer is dispatched to a residence in Harris County, Texas, in response to a family disturbance. The complainant stated that she got into a verbal argument with the defendant, her daughter, because the complainant believed the defendant was not taking care of her children. At that point, the defendant picked up a baby bottle and threw it at the complainant, hitting her in the cheek, causing pain. The defendant admitted to having thrown the baby bottle.
Em, I'm going to find that there's probable cause to go forward with your case. I don't show a protective order as an issue. Do you show one? No? Okay. Ms. Caldwell, I'm entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Candy Lachey as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand? Mm-hmm. It's not an answer, ma'am.
Yes.
How old are you, ma'am? Are you here with anyone today? Who are you here with today? I'm sending you now for a drug test. I want to know what, if anything, is in your system, ma'am. You're to come right back. If you fail to take the test, if you fail to come back, I will issue a warrant for your arrest. You will not get any more PR bonds. Do you understand? Okay, can you have her sign the note before she leaves, and then we'll send her for a test, please?
You're done with it, Your Honor?
For now. So just normal reset. Everything is normal.
Okay.
Nothing special. Just stay out of trouble.
I believe her bond conditions require her to not go to the residence at issue. Her two children, right, are still there, and I'm not clear who.
Who is the complaining witness again?
Her mother.
Do we know if mom wants her back?
Let me see if it works. It has. Let me read this.
And the only time I say no is when the complaining witness says no, because I want to honor their wishes. If the complaining witness is okay with it, then I am too.
The complainant is fine with contact. She just wants no threatening or harassing contact.
Okay, that's it. We'll let you go back to the home, but you have to understand what is threatening or harassing doesn't matter what you think. I'm trying to
understand.
Okay, I'm listening.
It's how she perceives. So when you start going like this, is that threatening or harassing? It is. So be careful how you act, because if we find that you're threatening or harassing the complaining witness, I will revoke the bond and put you in custody. All I'm asking you to do is be nice. That's it. If you constantly bang heads with your mom, be careful, you know?
Not only that, you could also get charged with violating bond conditions, right?
Protective order. And
yeah. Can we make sure the protective order mirrors the bond conditions?
Sure.
Okay.
Who is this?
Caldwell. Do you mind printing out? Okay, ma'am. We've given you a lawyer. It's your responsibility to stay in touch with Corey. He'll tell you when you have to come back to court. I'm going to waive your appearance so you don't have to waste your time coming here. But just stay in contact with him and he'll tell you when you have to come back. And just be nice. If mom kicks you out, where are you going to go? You got two kids too, right? That's what you got to think about when you're out there. You just get in a fight with mom, they kick you out. Where are you going to go? And you got two kids. You can stay here with us. I don't think you're going to like that, though. It's not, you know, it's not funny. Okay, so I'm going to amend the conditions and then you guys are good to go.
Okay, thank you, Judge.
For sure. Thanks, Corey. Come on.
To the middle. I have a Norma Solano on today's docket. It looks like she had missed a drug test. For bond, we're here for bond violation. Oh, yes, Judge, she's here. And she said she was not aware that she had the drug test. I don't know if the manner in which they contact them, I thought they maybe call them for that. But she was originally going to do DWI PTI. She now says she would like to take a time served offer. Would you allow her to do that today?
Why she doesn't want to do the,
Judge, she just said she
you know
doesn't,
what's it going to test positive for? Is that what it is?
no, Judge, but she just said that the expenses of the program and she's working right now and she doesn't have time for the program.
Come up, Miss Solano.
But we had already gotten her approved and we're kind of on our way to, I think we might even have the contract already even for DWI PTI.
How old are you, ma'am?
25.
Okay. You know, being in court, it's not like being in Target, Costco, HEB, where if you don't like something, you can return it or you get buyer's remorse. When you make decisions in here, they're lifetime decisions that you have to live with forever. And, you know, there are collateral consequences that may arise, meaning consequences that you may never see pop up as a result of decisions that you make in here. When you plead guilty to an offense, that offense goes on your record and it's there for the rest of your life. And when you plead guilty, you can't take it off. You cannot say, you know what, I have a change of heart. I can't get an apartment. You know what, let me go and try to do something else. Once you plead, you're stuck like Chuck for the rest of your life. I tell you now, I have, you know, every month, people that call me that go, you know, this lawyer pled me to this case and I can't get an apartment. Can you take it off? I have, like, they pled 10 plus years ago. You know, truck drivers that want to better their life, but they pled guilty to a, you know, a less than a gram case and can never take it off. When you plead to a DWI, not only is it very possible that you lose jobs with regard to, you know, making a living with a car, your insurance is going to go up. Your insurance is going to skyrocket. Insurance is expensive as it is now. You pick up a DWI, it's going to be about 4 times what it is now. Not to mention any other consequence that can arise from a DWI conviction. You have the opportunity now where if you are granted entry into this program, if you complete it successfully, they dismiss the case. It looks like you've already have been granted entry into it. The only problem I see now is that you were called upon to take a drug test and you failed to go. I'm going to go send you for a drug test regardless, right?
Yes, sir, that's fine.
Right? But when you take a half-ass approach to something, you get a half-ass result. And it's usually not a good idea to do that with a criminal case. You know, when you try hard, you get a good result. You know, James worked hard to try to get you into this program. Has she been already admitted into it? Do you know?
She's not in PTI, Judge, but she's been.
Right. But right. I mean,
Yes, Your Honor, the last update was that the contract was signed, the NDA was in.
all you literally need to do are 2 things. You pay the DA fee and you get an interlock. The DA fee, if you fill out a waiver, they may be able to waive that $300 fee. As far as the interlock, I can't pay for that. I can only pay for it while you're on bond. That's something that you'll be required to pay for. But I tell you now, the $50 to $75 cost you per month now is nothing compared to what you will end up paying with a DWI conviction. So you make the decision on what you want to do. I am going to send you for a drug test right now regardless, and alcohol test. But think long and hard before you make this decision because there's no turning back from it. Okay? Okay, man. Just hang tight for me.
You want my approach?
Sure.
Judge, we got Norma Solano's test results and she came back negative. What I was gonna.
Hold on.
Oh, sure, Judge.
Who is it?
Norma Solano. You sent her to go get tested?
Is that Miss Solano?
Yes, Judge. She's right over there.
Come up, Miss Solano.
That's kind of a alternative as opposed to having her plead today. Maybe we can get.
No, I don't want her to.
No, I know you.
She doesn't want to.
She wanted to do time served today, but I was thinking just instead of that, because she's already has the contract, maybe we can give her a couple weeks to talk to some friends and family and see if she would rather.
What do you want to do?
You said you want to do the time served, or you think you want to do the 1-year program?
Well, I was iffy in the beginning. I just wanted to do the time served, and then I talked to my friends and my family, and they suggested to do the program. But since I got...
Anytime you can get something dismissed, no matter how, that's always the best result, you know, really, because like I told you, The consequences of a DWI conviction, they're staggering. You never know how it's going to affect you. It will. It's going to affect you. It's just, you never know how and by how much. And with the DWI is big business. If you plead guilty, from now on, you're looking at a minimum of 30 days in jail. You're also looking at a mandatory about $6,000 to $7,000 in fines and fees just here from court. Not to mention insurance going up, not to mention all the other stuff in your life, how it's going to affect you. Whereas if you do this program, you do well, maybe they'll even boot you out early. If you do everything speedy, you do it quick, maybe they'll take you out early too. Just depends on how well you do. But you have to put effort into it.
Yes.
All you do is, there's 2 classes, right?
There's a couple classes and then there's the alcohol monitoring device.
And there's 2 classes, a little community service, and just stay clean. That's all you have to do.
I have clients regularly do everything in 6 months.
Take your time. I don't want you to rush into something now. So we'll set you off a couple weeks. In the interim, do we have the financial affidavit so we can have her doing that as well?
I can send you a copy of the financial affidavit to waive the $300 fee if you qualify, but you need bills and pay stubs and all that to be attached. I can send that to her, Judge.
Please. And I think we may even have a copy here actually for you. So, try to get that $300 fee waived, and then all you have to do is pay for the interlock and just stay clean. What do you think? We'll give you time. I'll give you a couple weeks. If you still want to do the time serve, that's on you. If you want to do the program, great. It's up to you. Take your time.
I think.
Yeah, just talk about it.
Take your time.
Thank you, Judge.
I'm glad that you're clean and don't miss again. Okay? All right. Good luck, Ms. Lano.
Thank you, Judge.
For sure.
Hey, quick question.
Ricardo? Antonio. What's his name?
His name is Cesar Albarbo.
Good morning.
Yes.
Your lawyer has tried to work out an agreement with you. The problem is that it's going to take a while. And sometimes for a good result, it may take a while for that to happen. Here, his advice was for you to set it for trial. But unfortunately, because of the holidays coming up, normally we do a 30-day trial setting. But 30 days from today runs into the Christmas time, and we don't have any juries here. So the first jury trial setting that we have is for January 7th, and he wanted to set your case for jury trial on that day to see whether they can make the case or not. I know that you're itching to get out, but you got to understand that if you plead today, there are very serious consequences. You're charged with assault of a family member. This carries an affirmative finding of family violence. What that means is that if you ever pick up another one of these cases again, you will be charged with a 3rd-degree felony, and you will be looking at a minimum of 2 years in prison, a maximum of 10 years in prison. And when I mean an assault, it doesn't have to be a beat down with blood everywhere. Simple fact is you grab someone's arm and squeeze it to where it hurts. That's enough for them to charge you with a serious felony where you're looking at 10 years in prison. If you do this, you can never own a gun or ammunition as well. So the advice by your lawyer is for you to wait a bit and set up a trial January 7th. What would you like to do?
¿Qué quisiera hacer usted?
Mejor si lo espero el 7 de enero.
I'd rather wait for the January 7th.
Okay. Antonio?
Yes, sir.
There you go. Yeah, and we'll set up a trial for January 7th, and we'll see what happens. That's the advice of your lawyer. I would,
Okay.
Yeah. Okay. Here you go.
Yes, sir. All right. Thank you, Your Honor.
All right. Absolutely.
Okay.
Bridge, this is the, yeah, this was the last one.
Okay.
Good morning. So, Mr. Hercules, you were charged with reckless driving. You're facing up to 30 days in jail and/or a $500 fine. You guys have worked that agreement where they're offering you 3 days in jail, credit for the 18 days that you've done. You sure?
Yeah.
3 days in jail, credit for the 18. You know, the way that you were driving in that parking lot, God forbid that you hit someone, kill them, run someone else over, driving out like that and then bolting out at 90 miles an hour in a parking lot. You're begging for trouble, man. Can you imagine if you hit and kill someone? Who gets charged with murder? Mr. Hercules.
You're right.
So, you know, in a parking lot, that's not the right place to do it. If you want to do it, there are places in Houston, but not in a parking lot, man. How many racing facilities are there in this town? I mean, a lot. Don't do it again. I'm going to tell you one more thing, that the legislature has made it really easy for DAs across Texas to seize and take cars away from individuals who do this. You are now going to end up with a conviction for this on your record. You pick up another one of these cases, it's very possible that they seize and take that car forever and you don't get it back. Do you understand?
Yes, sir.
The right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never change this. Is this what you want to do? How do you plead to the offense? Guilty or not guilty?
Begging me the time served.
Yes, you get the
Yes.
Are you guilty of this offense?
Yes, sir.
Okay, all right. I'll find you guilty. I'll send you the agreement. Now, we're not going to release you today because Louisiana wants you. So you'll probably Monday or Tuesday be out of here and then on your way to Louisiana. Okay? Good luck over there.
Thank you, sir.
All right. Take care.
Yeah, I like
Mr.
your sports jacket. It looks nice.
Thank you, sir. Take care.
All right, Mr. Ricketts, have a good one. Your Honor, may I be excused? Thank you, sir.
And with that, that's it.
Raspberries.
You done?
Well, you're good. Prior to the.
Oh, okay.
In your honor, briefly on Williams, were those state's conditions or pre-trial for the marijuana? Is that a state's condition for bond or pre-trial?
Pre-trial.
Okay.
Did you want random testing or just?
Do you know why you're here?
Yes, sir.
Why are you here?
Because I didn't finish my community service. And my class, I did finish, Your Honor, but I got into a tight budget. Very, very bad.
One of the only other things we ask you to do, don't use drugs or alcohol.
Yes, sir.
And now you're testing positive for cocaine. You tested positive for cocaine in February, and you've just now tested positive for cocaine again. Take a seat for me in the jury box, sir.
Good morning, Your Honor. Good afternoon, Your Honor.
Yeah.
Judge, I am here on Mr. Alejandro Guardado. Looks like it's an MRP judge. I've been informed
Come up, Mr. Guardado.
my client had tested positive for cocaine, I believe. I think this is his second or third time testing positive. We want to know what direction you.
Hey, this isn't the club, man. You. So you trying to talk to her. This isn't the club, man.
Yes, sir. No, sir.
Yes, yes, sir. Yes, sir.
Hit you, brother. Mr. Guardado, you were placed on probation for a very serious case, and you've had issue after issue. The reason I brought you here was try to ensure that we could get you on the right path, but you're continuing to use, and you just today tested positive for cocaine again. And I'm at a remiss that they didn't even inform us in February when the first time you tested positive for cocaine. So now I'm issuing a motion to revoke your probation, and I'm issuing a warrant for your arrest. I've appointed you a lawyer so we can figure something out, but you can't continue to use cocaine while you're on probation and expect good things. Do you understand?
Yes, sir.
Okay. So what I would suggest at this time is we probably get a TRAS to see how we go forward, because I just don't know. You're using, and that's not something you're supposed to be using, you know? It goes with you.
Yes, thank you.
All right.
How much are you setting the bond?
How much you setting the bond, Judge?
What's it at now?
100?
5,001.
Judge, I have Evan Nelson, and we're approaching, because of the age of the case, wanted to also just update you as to what's going on with it.
Okay.
We have talked, my client and I, and we have asked the state to evaluate this one for trial. They did make a 3-day time served offer, which I presented to my client, and he is not amenable to accepting that, just based on the elements of the offense, and we talked through those.
You know, Mr. Nelson, the only problem I have is that you don't show up. We've already had, you've been given one GOB, you've been given one PR bond, and now you've made a surety bond. You miss again, I'm gonna make your bond so high, your hair's gonna look like mine. You know what I mean? You're gonna be losing it because you're gonna be so upset. So don't miss again. Really. Giving you a great lawyer, all you got to do is stay in contact. What offer have you made on Mr. Nelson's case?
It looks like Pavel had put in a time served offer when he was still on.
Is that it?
I'm welcome, I'm happy to talk to counsel, about another
Okay.
offer. This is just an old offer put in by Pavel.
Okay, oh yeah, it's a prior assault, it's dismissed, okay. We'll give you guys some time. It's not gonna be too much time because your case is already 190 days old, so it's time to figure out what we're gonna do. We'll give you, 3 weeks, but at that time, you gotta come back and we gotta figure out what we're gonna do.
Yes, sir.
At that time, in 3 weeks, if you don't accept anything, I'm gonna set your case for trial,
Yes, sir.
okay? All right, guys.
Thank you, Judge.
Good luck, see you in 3 weeks.
Have a good weekend.
Sure. Is there gonna be any bond conditions? Because we just put them in the box straight away.
Just no weapons, I guess, that's it. He's a prior AFM, so, yeah.
All right.
Okay,
let's take
so
one.
Morgan, do you mind following? Just no weapons. If it's not already there, I don't know. So no PTI?
No PTI,
She knows about it, right?
yes. Oh, I'm sorry.
Morning, Ms. Hutcherson. It's Hutcherson. So you no interest in doing the PTI program?
She's currently in the
You're wrong.
PTI
She was
program,
just
she's
removed
terminated.
from
She was removed?
I didn't have a,
Got it. No, yeah, too late. Okay, so Ms. Hutcherson, you've worked out an agreement where they're offering you 3 days in jail, credit for the 1 day that you've done. You need to understand, ma'am, yeah, I just see that it was removed. You need to understand that this DWI will go on your record. It's going to be there for the rest of your life. You need to understand that if you ever get pulled over, an officer's going to look at your history. They're going to see this DWI. If you smell like alcohol or dope, it's not going to go well, The other thing, what we're doing today, it's not gonna, you're looking at a minimum of 30 days in jail from now on for whatever you pick up. So no more proverbial slaps on the wrist. You understand? You're giving up the right to a trial, right to compel witnesses, testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization, you give up the right to appeal. Once you plead guilty, it will stay on your record. You can never take it off. This is what you want to do. How do you plead to the offense, ma'am? Guilty or not guilty? I will find you guilty. I will send you to the agreement. What do you do for a living, ma'am?
I work as a receptionist.
And how much money do you make?
I bring home
I want you to understand something, ma'am, that, DWI is big business. There's a $3,000 surcharge that usually is tacked on when you pick up a DWI, and when you get a second DWI, it's a $6,000 surcharge, and if you don't pay it, you go to jail for every $100 that you owe. You understand? I will waive your fees now. I'm not, it's, next time, it's around $7,000 you're gonna be walking out. So if you wanna get lit, just don't get into a car. $20, a button will take you anywhere you wanna go. All right, good luck.
Thank you, Judge.
All right. Oh, I have to suspend your license. I'm suspending it for 180 days. You are Aziel Gracia.
Sir.
Mr. Gracia, so
He's charged with, I've never seen this before, Judge, but he's charged with violating a bond condition.
yeah, I mean, I've certainly seen it.
And,
It's either,
It's not a protective order, it's a bond condition.
right, because they can't make the protective order case because it's been more than 61 days,
Had
right?
nothing to do with the protective order, Judge.
So, yeah, right, I get it.
It was a different situation completely. Had nothing to do with family violence.
We'll get there. So you're charged with violation of a bond condition / protective order. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. If you cannot afford a lawyer be appointed to represent you. So before we start, was he in a PTI? Is that why this case is 1,000 days old?
Yes, sir. He just has a few BIP classes left to finish the PTI.
Okay. Okay, go for it.
Judge. The officer was dispatched to a business in Harris County, Texas in response to a disturbance. Upon arrival, the officer observed the defendant grab another male aggressively, and the officer conducted a search on the defendant's person and found a loaded gun in the front pocket. The defendant is currently on bond for an assault family violence and has bond conditions in place prohibiting from possessing a firearm.
Yeah, all right. Mr. Gracia, I'm going to find that there's probable cause to go forward on the bond conditions. State, what's your position as far as he's in a PTI? He's now picked up a new case. Mr. Gracia, I want you to know that we take these bond conditions extremely serious.
Sir.
You don't, though. This is not your first VPO. This is not your first violation of bond condition. You don't get it. No means no. Doesn't mean maybe. Doesn't mean I'm going to a high crime area. No means no. And now there are consequences. Stephen.
Judge, can I tell you a little bit about the case?
Sure.
You know, like, just to explain to you what happened. He was at his business. He owns a trucking company. He hired somebody who he said he took a chance on him because he's has a sketchy record, convicted felon. It didn't work out within a couple of days, so he ended up firing the individual. The individual refused to leave the premises or refused to accept it. So he started threatening him. He went inside. The individual started trying to damage the trucks. So at that point, he was fearful. He went and retrieved a firearm that he knew was hidden in the vehicle. I'm sorry, in there. I understand, Judge.
It's about the worst thing that you can do. Imagine if you used a firearm. Who gets charged with murder, Mr. Gracia? Who has now dug themselves into a potential 50-year hole? We have a case like that today where a meager argument, someone who's charged with assault is now charged with murder because of a silly-ass, stupid-ass argument. Now, dude is sitting in custody with a $250,000.
And he's been punished at this point, Judge. He's been punished for violating the bond by getting an entire new case on that. So as far as him going into custody for violating the bond condition, I would hope that you would take that into consideration, the fact that he has gotten punished on the bond violation already, and the fact that he's already had to hire a new attorney for two cases at this point, and it's probably going to affect the other case. So I would hope that you would continue supervision on that, just taking that into consideration.
I truly appreciate your position, but you have an assault from 2019 of a family member. The following year, you pick up a violation of a protective order or bond condition. Now you have another assault that they were even, what the hell you're looking over there? Was it Jesus over there? You already have an assault of a family member that was dismissed as it is. You were lucky enough to even have this kind of an agreement where they're willing to dismiss a second assault of a family member, and now you pick up another violation of a bond condition. Eric, he doesn't get it.
I understand, Judge.
You don't get it. And now I have to show you we mean business. I think that you are utter and complete danger to public safety. And I will do everything in my power to protect my public in every single way. Because the last thing I want is you to pick up a murder case like we have here this morning. Someone else goes with you.
Judge, one more thing. There's a bond condition on there that he's not allowed to return to that address. That address is his business. It's his place of business. The other person has no right to that address. So hasn't worked for the last week and a half because there's a bond condition, I'm assuming from the magistrate, that doesn't allow him to go back to that business.
Show me proof.
I'd like to be
Show
able
me
to take
proof. And, the proper, and you need to advise, the proper way to do things is you call the cops. Really. I mean, that's, if you own the business, you show it. I mean, how easy would it have been to just call police?
I mean, he has a right to defend his property and
not while the case is open. He does, but not in that manner.
It's one of those things where things happen quick and you have to make a decision. When we're talking about trucks that are worth hundreds of thousands of dollars and things like that.
911, man. Really?
How long do they take to get there, Judge? So
they will still take his ass to jail and then, you try to get restitution or whatnot. But
so as far as the bond goes, can you set him a bond today?
Of course.
And Judge, we've contacted Conrad because it's his case, but I just want to confirm that bond has been revoked for his prior case. Is that correct?
Yeah. Okay. Yeah. On the assault, I'm revoking it.
Yes, Judge.
Looks like they set the bond at 20,000 on the new case.
Yes, Judge.
I'm going to mirror it.
Because he's already posted that bond. He's already hired me. He hired me on the other case as well. There's a motion to sub in your queue that I need you to sign as well.
I'll sign it for you.
I'd ask that you set that new bond at $500. It's tough for the family, Judge. I mean, at this point, he hasn't worked in 2 weeks. He's trying to get back on his feet. He did everything properly. He didn't go back to the location because of the bond condition.
I'm not doing $500. I mean, I was thinking that was going to mirror the same one. I was put it at 20,000.
And that would be his next position to mirror.
So he understands that we mean business. If he's unable to bond out, I'm always willing to talk after a couple days. But I want him to understand that we take it absolutely serious. And when you go over there with a gun with the intent to do some serious damage, hell no. No way. No. And I think that making it 20,000, what the other one is, hopefully it'll get his attention. But like I said, look,
10,000?
Like I'm not out for blood, Eric, so if he's unable to, after some time, come back, and I'm not talking weeks, but a couple days, so he realizes that we mean business.
So we're talking about 2 weeks minimum. So would you consider getting 10,000?
Well, remember, I Zoom. So you can be in Abu Dhabi. I'm still, here.
His mom's present, so let me talk to her.
Yeah, for sure. Okay. You were Samuel Torres. Mr. Torres, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow, so you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. Okay. On November 14th, 2024, the officers observed the defendant's motor vehicle make a wide right turn at an intersection with a dividing concrete median, accelerate at a high rate of speed from the intersection, failed to maintain a single lane, moving halfway into the center lane before returning to the outside lane, crossed over a solid white line into a bike lane before returning to the lane, and the officer observed other cars in the area at the time, rendering the failure to maintain a single lane dangerous to the other motor vehicles. The defendant's motor vehicle stopped at a red light and remained stopped after the light turned green, obstructing traffic, and the officer then initiated a traffic stop once the defendant's motor vehicle finally proceeded through the intersection. The officers had to travel approximately 0.5 miles from the original location as the defendant continued to drive. The officer made contact with the defendant, the driver, and the officer observed bloodshot eyes, an odor of an alcoholic beverage, and the defendant stated he did not immediately pull over because he lives at the apartment complex where the traffic stop was eventually performed and did not want his vehicle towed. The defendant stated he was coming from his sister's house, and the officer observed the defendant using the motor vehicle to regain balance. The defendant stated he had one Long Island liquor drink that he was currently consuming inside the motor vehicle, and the officer found a frozen daiquiri, still frozen and half consumed, on the passenger side of the floorboard.
So he's drinking while driving?
Yes, Judge. And the officers performed standard field sobriety test, HGN 6 out of 6, walk and turn 7 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and consented to breath. The results were .151 and .160.
Mr. Torres, do you have a Texas driver license?
Yes, sir, I do.
I'm now taking away your privilege to drive. You are not allowed to drive at all for any reason. And I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing. You can be facing up to 6 months in jail and a $500 fine every time you get into a car and drive. Do you understand? From now on, you'll be taking the Dodge Patas. This is an affidavit that you're going to be signing with me today, promising me. And I don't care what your excuse is. If there's a burning building with 50 kittens you have to save, you get into a car and drive, we will have issues. I'm also ordering you not to consume alcohol or illegal drugs. I will randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail. You will not get any more PR bonds, sir. Any priority to be honest, Alex? How old are you, sir?
23.
What do you do for a living?
I'm a mechanic.
How much money do you make a month?
About 24 right now.
Who do you live with?
My wife, my sister, my daughter.
Who else in the house works?
Just me.
Apply for an appointed lawyer, sir. So help me. Any issue, Mr. Torres, if I set your bond $5,000 to $10,000 and you ain't got anyone to pony up that kind of money, you will be stuck like Chuck until this case is over with. Make wise decisions while you're out there, because if you don't, I'm going to keep you. Do you understand?
Yes, sir.
Okay. Do you mind giving me an application, please? Have you application for an appointed lawyer? I need you to fill out everything. Don't just put zeros, because I'm going to send it right back to you. I'll have you sign a reset with Victoria. You're going to have to meet with Felicia for your bond conditions, and then we'll have you take a seat in the jury box.
Vasquez, Guillermo.
Jaquan Peterson.
Yes, sir.
Mr. Peterson, you're charged with reckless driving. You're facing up to 30 days and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On November 14th, 2024, the officer was part of a task force with the main focus being hostile street takeovers and racers. A large group of motor vehicles were meeting at the 11700 East Freeway in a parking lot in Harris County, Texas, when the officer observed the defendant's motor vehicle enter an area of the parking lot and began to spin his...
Si tú hablas, te pongo en la cárcel. Okay, sorry, please.
Would you like me to start from the beginning, Judge?
Please.
Yes, Judge. On November 14, 2024, the officer was part of a task force with the main focus being hostile street takeovers and racers. A large group of motor vehicles were meeting at the 11700 East Freeway in a parking lot when the officer observed the defendant's motor vehicle enter an area of the parking lot and begin to spin his rear tires with a loud screeching noise. The defendant's motor vehicle did several donuts, losing control of the rear end within 10 to 15 feet of other motor vehicles making up the pit. The officer observed the defendant's motor vehicle complete approximately 2 to 3 donuts, and a traffic stop was initiated. The officer made contact with the defendant, the driver and sole occupant, and the defendant admitting to doing donuts.
run his NCIC. Does he have any other cases like this by chance?
I'll run his NCIC, Your Honor.
Please. Mr. Pearson, I'm going to find that there's probable cause to go forward with your case. Can you imagine if you start doing these donuts, you hit and kill someone? Who gets charged with murder?
Caldwell?
These are things you must consider when you're out there in the free world. You think before you act, think before you speak, because actions may be your last.
And Your Honor, he has no other open cases or criminal history.
Do you have a Texas driver license? Do you have liability insurance in your name? Can you run this license,
It's
please?
eligible, Your Honor.
I'm ordering you as a condition of your bond not to participate in activities like this again. No reckless driving, donuts, street takeovers, racing. If I find that you do, the first thing I'm going to do is take your privilege to drive away from you, and the next thing I will do is I will put you in jail. Do you understand?
Yes, sir.
610. The freeways, toll roads, parking lots, this isn't the right way to put. You don't do this over there. And I'm going to tell you now, the Texas legislature has made it extremely easy for DAs across Texas to seize and take cars for individuals who participate in these types of actions. And I've had defendants come here with their cars seized, $50,000 trucks taken because of these types of actions. So be careful out there, because not only can you next time go to jail, but you may lose that very car that you had. Can you follow those conditions, please? No donuts, reckless driving, etc. We are going to reset your case to give you time to hire a lawyer. So I'm going to have you sign a reset with Victoria. After that, we will have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. When you come back, please have a lawyer, sir.
All right, Judge Potter, page 16.
Robert Potter. Mr. Potter, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On November 17th, 2024, at 1:10 a.m. in the morning, officers conducted a traffic stop on the defendant's motor vehicle after observing it traveling at a high rate of speed, 67 miles per hour in a 45 mile per hour zone. Upon contact, the officer observed the defendant to be the driver and sole occupant and observed him with slurred speech, strong odor of an alcoholic beverage, and bloodshot, glassy eyes. The defendant admitted to drinking and scored himself as a 5 on a 1 to 10 intoxication scale. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 7 out of 8, one leg stand 2 out of 4. The officer observed the defendant to be disoriented, drowsy, had slow and sluggish reactions, was uncoordinated, unsteady, as well as disoriented during the tests. An inventory search of the defendant's vehicle revealed a 12-pack of 12-ounce Modelo's in the back seat, as well as a 6-pack of 14-ounce Michelob Ultra with 1 container left. The DICs were read and the defendant consented to breath, the results being .097 and .099.
Is there any evidence that he's consuming while he's driving?
No, Your Honor.
Mr. Potter, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license? Do you have valid liability insurance?
Yes, sir.
In your name?
Yes, sir.
Are you sure? Can you run his license, please? Any priority WIs?
No, Your Honor.
I'm ordering you as a condition of your bond, Mr. Potter, not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any illegal drugs, unprescribed controlled medication, I will put you in jail. No more PR bonds. Do you understand?
Yes, sir.
How old are you, sir?
19.
What do you do for a living?
Goal maker. Work.
How much money do you make a month? We're going to reset your case to give you time to hire a lawyer. So I will have you go to Victoria, sign a reset. I'll get you with Felicia for your bond conditions, and after that, you'll be free to go. Be careful. Don't use. I don't care what your excuse is. If I find that you're using, there's a one-way trip. You understand?
Yes, sir.
Okay, man. Come on.
All right, Judge, next is
You said paid at 8?
page 8.
Okay. Tatiana Green. Good Good morning. Ms. Green, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
The complainant and the defendant have been married for 3 years. On November 17, 2024, officers were dispatched to a welfare check at a residence in Harris County, Texas, where the officers met with the complainant, who stated that the defendant and the complainant were having marriage issues due to the defendant cheating. The complainant stated that on November 17th, he observed the complainant laying on the couch, he observed the defendant laying on the couch talking to another man on the phone. An argument then ensued. The complainant stated the defendant grabbed a curtain rod and hit him twice on the leg while he was laying in bed. The complainant stated he called 911 because he was worried about safety and needed help. Just before the officers arrived, the defendant bit the complainant's left arm, causing pain. The officer observed the injury on the complainant's arm.
Do we know if he wants to have contact with her?
I'll read the RIF, but RIF was performed, so.
Okay. Ms. Green, it looks like a protective order has been issued in this case. Get to know it. If you violate it, the state will file additional charges against you. A violation of protective order, it's one of the worst cases you can pick up. Until I know that he wants to have contact with you, I'm barring you from having any contact with this person. Do you understand?
Yes, sir. So it appears that the complainant does not want contact and the complainant is moving out in order to make sure no contact.
Okay, do you have a child with this person?
No, sir.
Great. I don't want to talk about the case.
It's not about the case. The apartment that we have together is my apartment, but right now, since I got out, I've been at my grandma's.
Okay, so for now, right, this bars you from going to the Westmead place, right? So, you need a lawyer to represent you in this case. You need a lawyer to represent you in this case, ma'am. Do you work?
I do work. I just started working. Whenever I was in court for
You get a lawyer for the magistration.
I didn't talk to anyone.
Okay, so what kind of money do you make a month?
Nothing right now.
How do you support yourself? Okay. Did you want to apply for a court-appointed lawyer, ma'am?
Yes.
The other option is you can go hire one. What would you like? Okay. Actually, I have one. So I have an affidavit already filled out. So what we'll do is I'll have you just sign a reset with Victoria. I'll have you sign here the order for protection, and then we'll have you take a seat. Don't leave until you sign our additional bond conditions, and then we'll have you talk to a lawyer here momentarily.
Okay.
Okay? Please.
It was already signed, Judge.
Oh, that's right. Okay. Yeah, we just need to sign the reset, and then we'll have you take a seat. No, come up. Well, no, the deal is that he's moving out, she's moving out.
He is moving out, and he previously told the prosecutor on the case that he has a new place, but I see on the MOAB that it does list the apartment that belongs to the defendant. Yes.
Okay, I want you to go back, but I want to make sure that the person is out first, because I don't want you to go back. He's there and boom, just.
And don't talk about the facts of the case, just talk about this situation. Yeah.
My lease is up on the 7th of December, so I'm okay. I just need to get my personal belongings.
But if he's not living there, Your Honor, I mean.
I just don't know if he's still there.
I can reach out to him.
Do you mind real quick?
Yes, Judge.
Okay, they're going to try to reach out to him real quick to see if he's still there. If he's not, and he's gone.
He's still there.
Until what day?
Until December 2nd.
Oh, okay.
Is he on the lease too?
No, I mean, he doesn't have to leave. I'm with my grandma. I'm okay. I'm okay.
Sure?
Yes. Yes.
Well, is there also?
I don't want to exclude you from your own home.
There were no contact here?
It's okay because.
Yeah.
Yes, Judge.
Yes. Get a no contact because he
Wants
doesn't.
a no contact?
Yeah.
Yeah.
It's over. Allegedly.
Till next one?
I don't know. You never know. Time heals, right?
Okay, so you're for sure not going back there. He's
I
gonna
haven't
be,
been back.
but what about December 2nd when he leaves? Do you need to go back? You said December 2nd he's getting out of there?
Well, he's gonna communicate with my mom and my sister. That's how we've been conversing.
So let's do this. I'm gonna have Alex reach out to him. At a minimum, let's see when he's gonna go out. That way you have an idea he's gone and you can go back because
Can your family go get your stuff if need be?
Yeah, I mean,
probably a lot of
And,
stuff.
and the reason we're bringing this up is because if you go to that address
I know,
and he calls the cops,
I know.
even if he tells you, invites you, even if he's gone, you will get charged with a new charge, and I don't want that happening. So if he's out December 2nd is his last day, do you want to come back to court December 3rd? And we can,
I have to remove that residence restriction off. So if you go back, you don't get in trouble.
You don't have to do because I'm about to move. My lease is over.
right, but who's gonna get your stuff out of it?
But it's because it's only right that he lives the rest there because he paid the rent for this month.
Okay, well, I'm just trying to
I understand.
get her to get her stuff out without getting in
I'm
trouble.
gonna get it. My sister will get it for me. They don't-
Okay,
Ms. Green, you've got a great lawyer. If you ever need anything, reach out to Greg.
Yes, sir.
Greg knows how to get a hold of me and we can always work something out.
Yes, sir.
Just the worst possible thing you can do is take matters into your own hands, go over there, or because you'll end up picking up a new charge and then things will really go sideways quick. So just please don't. If you ever have any questions, reach out to Greg, he'll always talk to you and yeah, I mean, we're always here as well.
Okay.
We live here. So
okay, so then just I'll do a regular reset, and if you need something moved up, let me know and I'll get you here.
Okay.
Okay?
all right, man.
All right,
Am I able to leave?
not yet, I'm gonna give you a reset.
Let's get you the reset, have some other paperwork.
All right, thank you, Judge.
Okay, thanks, Greg. Anna,
Can I have the-
do you speak English, sir?
Flores José Antonio.
Acérquese aquí al centro. Solamente mire el juez y le contesta con respeto en español.
Claro que sí.
Florencio Martinez Vázquez Guillermo.
Guillermo, yes, solo mire el juez.
Charged with driving while intoxicated.
Solo mire el juez, por favor.
You are facing up to 6 months in jail and/or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one, sir.
No, para usted, si usted no puede pagar por su propio. Solo quédese mirando el juez, por favor.
On November 17th, 2024, the officer conducted a traffic stop after observing the defendant's motor vehicle run a red light. Upon contact with the defendant, who was the driver and sole occupant of the vehicle, the officer observed the defendant with bloodshot eyes and a moderate odor of an alcoholic beverage. The defendant admitted to drinking and advised that he was coming from a party. Standard field sobriety tests were performed. HGN, 6 out of 6. Walk and turn, 5 out of 8. One leg stand, 2 out of 4. Inventory search of the vehicle reveals one open 12-ounce bottle of Modelo.
Drinking while driving.
DICs were read, and the defendant consented to correct. The results being .122 and .126.
Mr. Vasquez Guillermo, I'm going to find that there's probable cause. Tell me, are you a United States citizen?
Solo mire el juez, por favor.
Are you in this country with or without permission?
Sin permiso.
No, sin permiso.
No, without permission.
What happens if you go to jail?
Si usted va a una cárcel. Acérquese, señor, y no me mire, por favor, solo el juez. ¿Qué pasa si usted va a una cárcel?
No, pues, no sé.
Well, I don't know.
Are you in this country with or without permission?
Sin permiso.
O sea, entré con permiso, me quedé.
I entered with permission, but I stayed, I remained.
If you go to jail and immigration finds you, Mr. Vasquez, they will put a detainer on you and you will be stuck in custody until this case is over with. And then you will be shipped off to immigration where you will sit for another 6 to 9 months waiting for immigration to do whatever they're going to do. I would hope that you recognize it's elementary that you're not to have alcohol in the car while you're driving. And it is a minimum of 5 days in jail to any sentence you get if they allege the open container. I will tell you now that immigration sweeps it every single day. So if you spend more than 6 hours in custody, you will be stuck like Chuck with an immigration detainer. I am now putting conditions on your bond, and if I find that you violate these conditions, you will go to jail in a moment's notice. And I don't care if you're kicking and screaming Do you understand?
¿Entiende, señor? ¿Sí, señor o no, señor?
Sí, 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 entiendo.
You are not allowed to drive. And you will be signing with me today a promise that you're not going to drive. I don't care what your excuse is. If I find that you drive, to jail you will go. Likewise, I'm ordering you not to consume alcohol or illegal drugs. You will be randomly tested. If you test positive for alcohol or drugs, likewise, you will go into jail.
De igual manera la va a ir a una cárcel. That's fine, that's fine.
Any prior DWIs?
No, Your Honor.
Ninguno, señor. Señor juez, por favor, entienda eso.
We are going to reset your case to give you time to hire a lawyer. So I will have you come up here, swear to us that you're not going to drive. This is an affidavit. I'm going to tell you now, Mr. Vasquez, look at me.
Míreme.
This is the only warning you will get from me. One violation whatsoever. I'm going to keep you with me.
Manteniéndote conmigo.
Do you understand?
¿Entendió eso, señor?
Sí, señor.
Yes, sir.
Okay, come up here, swear to us that you're not to drive. We'll get you to Victoria, and then we'll get you with Felicia for your bond condition.
All right, Judge, next is page 22, White.
Good morning, Ms. White. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. The complainant and the defendant are married. On November 16th, the officer was dispatched to a residence in Harris County, Texas, in reference to an assault. The officer met with the complainant, who stated the defendant and him had a verbal altercation that began the night prior, due to the defendant thinking the complainant was talking to another woman on the phone. The complainant stated he tried to sleep, but the defendant wouldn't stop arguing. The complainant stated that he slept in a separate bedroom, but the defendant came into the bedroom at 5 a.m. and started yelling at him, accusing him of cheating. The complainant stated he tried to walk out when the defendant struck him with a closed fist right between his eyes, causing him to feel pain and discomfort. The complainant stated he feared for his life and had no other choice but to call 911.
Okay, Ms. White, I'm going to find that there's probable cause to go forward with the case. Do we know if he wants to have contact with her?
Let me see if a RIF has been done, Your Honor.
Please.
No RIF has been done, Your Honor.
Okay. I don't know if he wants to have contact with you, so until I know, I'm ordering you not to have contact with this person. A protective order has been issued in this case. I would suggest you get to know it, because if you violate the protective order, the state can and will file additional charges against you, a violation of a protective order, and it's one of the worst cases that you can pick up. Do you understand, man? So you're not to have contact with this person and not to be in possession of any weapons. Do you work, ma'am?
I do.
What do you do for a living?
I'm school bus driver,
What kind of money do you make a month?
$3,000 a month.
Okay, we're gonna reset your case to give you time to hire a lawyer. I'll have you go to Victoria, sign a reset. After that, we'll just have you take a seat in the jury box, so we'll get your bond commenced, you'll have you sign it, and then you'll be free to go in. Okay? Please. So no contact, no weapons. Yes. You were Aaron Durden?
Yes, sir.
Mr. Durden, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, yes. Okay. On November 14th, 2024, the officer was on a traffic stop in Harris County, Texas, with emergency lights activated when he heard an engine roaring of a performance motor vehicle and observed the defendant's Lamborghini on the feeder road traveling at least double the speed of moving traffic with a posted speed limit of 45 miles per hour. The officer observed the defendant's motor vehicle swerve in the feeder lanes and enter South Highway at a very high rate of speed without signaling a lane change. The officer terminated his traffic stop and attempted to catch the defendant. The officer observed the defendant's motor vehicle turning into a bar and initiated a traffic stop. The officer approached the motor vehicle and observed the odor of brakes and engine burning from aggressive driving. The officer observed the defendant to be the operator of the motor vehicle sitting behind the wheel and observed a strong odor of an alcoholic beverage and watery eyes. The defendant stated he was coming from Captain Tom's and standard field sobriety tests were started. The defendant then complained he had poor balance, and the defendant fumbled through his wallet trying to find his Texas driver's license and stalled when answering where he was coming from. The defendant was searched, and the officer found a receipt from a bar in the defendant's short pocket. An HEN eventually was conducted, finding 6 out of 6 clues. Walk and turn and one leg stand were refused. The D was read the DIC, but refused blood. A search warrant was obtained and executed.
All right, Mr. Durden, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to drive any vehicle that doesn't have an ignition interlock on it. That is a blow and go that you put on your car to make sure that you don't have alcohol when you get into a car. If I find that you drive a car that doesn't have one, I will put you in jail. You will not get any more PR bonds. Do you understand?
Yes, Judge.
I'm also ordering you not to consume alcohol or illegal drugs, and I will randomly test you. If I find that you're consuming alcohol or illegal drugs, likewise, you will go to jail. No more PR bonds for you, sir.
Yes, Judge.
Understand that we send notice to DPS in Austin so that any and all officers know if you get pulled over, you're to be driving a vehicle that has an interlock. And if you drive one that doesn't, they will immediately take you to jail. So beware that the all-seeing eye knows. You understand?
Yes, Judge.
We're going to give you time to hire lawyers. So I'm going to have you go to Victoria, sign a reset. You will then get with Felicia for your bond conditions, and after that, you'll be free to go. All right?
Judge.
Okay. Please. Hi, Billy.
What is that?
Jose Antonio Guzman Flores. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
The complainant and the defendant are in a dating relationship. On November 16, 2024, the officer was dispatched to a residence in reference to a disturbance. The officer made contact with the complainant, who stated she and the defendant began to argue. When she discovered the defendant gave her an STD. The argument began as verbal. The complainant wanted to leave, and the defendant grabbed the complainant's wrist and began to pull her. The defendant then grabbed the complainant's purse, which was wrapped around her waist, and then began to pull her hair. The complainant and the defendant separated when officers arrived. The defendant stated he did not put his hand on the complainant by grabbing her wrist, and pulling her because he wanted her to calm down. The officer observed an injury to the complainant matching her statement.
So you said pull the hair? Is that what you said?
He pulled her hair, yes, Your Honor.
And did you say that it hurt?
The complainant did state that she felt pain.
All right. Okay, Mr. Flores, I'm going to find that there's probable cause to go forward with the case. Do we know if she wants to have contact with him? Yay or nay?
A rip was performed. Let me see real quick.
Take your time. No rush. I don't see. All right, so.
It does not appear she wants contact with the defendant, Your Honor.
No
contact.
All right, so, and I'm entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Robles as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Yes, sir.
If you violate this court order, the state can and will file additional cases against you, a violation of a protective order, and it's one of the worst misdemeanor cases you can pick up. So just stay away. Don't have contact with her. If she texts you, don't reply. If she calls you from an unknown number, hang up the phone. Just don't have any contact and everything will be fine. How old are you, sir?
22.
What do you do for a living?
I'm a technician right now.
What kind of money do you make a month?
Sorry?
How much money do you make a month?
Mr. Holland is showing personal growth work and sobriety matter.
$3,500 a month.
And who do you live with?
With my mom.
We're going to reset your case to give you time to hire a lawyer. So I'm going to have you come up here. We'll have you sign for the order for protection. I'll have you sign a reset with Victoria. We're going to get you out of here to hire a lawyer. After that, I'll have you take a seat while we get your bond conditions. We'll have you sign it. And after that, you'll be free to go. Okay? If you can file no contact and no weapons.
Yes, Judge.
3,
School, I just forgot to,
Last Friday, why did you miss court?
the school, and it just slipped my mind.
How old are you, sir?
17.
Okay.
Courts notice when someone takes responsibility and acts right.
How'd you get here?
I drove.
Okay. You're charged with tampering. You're facing up to a year. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Officers initiated a traffic stop, observing the defendant's vehicle run a stop sign in Harris County, Texas. The officer asked for the defendant's driver's license, and the defendant provided it to the officer. When the officer went to verify the driver's license, the number came back to a Leslie Salazar. The defendant admitted to the officer that his driver's license was fake. The defendant then provided his legitimate driver's license to the officer.
Why? Don't say anything. Do you have any indication? I mean,
I'm not entirely sure, Judge. I don't know if it was like a mistake or to hand over the.
no, fake ID, I see. Did they take it? Do you know if they confiscated that license?
I believe they did. They have a photo of it. That the officers took.
Well, Mr. Brock, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license? Do you have valid liability insurance in your name?
Yeah, I'm assuming so, or in my mom's name.
Don't assume anything. Never assume anything in life. Because if you get into a wreck and you kill a 5-year-old kid, they don't care whether you make assumptions or not. The only question is whether you do or not. And if you don't, then you're not allowed to drive. And I'm making that a condition of your bond.
Yes, it was taken.
Wonderful. I'm making it a condition of your bond that you're not to have any fake IDs, fake licenses, or anything of this nature. And if I find that you're using that, or you're trying to get booze, you're trying to get illegal drugs, I will put you in jail. You will not get any PR bonds. Do you understand?
Sir.
Life is really going to suck. At 17, you going into jail. Let me tell you what kind of field day the people in custody will have with you. Do you have any clue what they will do to you in custody? Take a guess. Imagine your worst nightmare. It's worse. Get my drift? If I drug test you today, what are you going to test positive for? And be aware that you're going to get tested. Anything else? I'm sending you for a test. You're to go test and you're to come right back. If you fail to go test, if you fail to come back, I will put you in jail and I will revoke your bond. Do you understand? I will appoint you a lawyer today. We will talk about that when you get back, but I want to know what, if anything, is in your system, and we'll go from there. What are you doing now with your life? Are you in high school?
Sir.
Okay. Senior, junior?
Senior at Memorial.
Okay. What's going next? What's happening next?
College, UT, or LSU.
You sure? Okay. Let's see. You've got to understand, this is not a good start to your college career. This is, in fact, about one of the worst things that you can do, because all career services, all schools, they're going to look at this. And this can really impact you for the next 40 years of your life. So go take a test, come back, and then we'll talk further, okay?
Reinstating, Your Honor?
Oh. Have you played Monopoly before? Okay. In Monopoly, you get a get out of jail free card. This is the only one that you're going to get from me. If you ever miss court again, if you ever fail to come when you're supposed to, I will issue a warrant, and I will keep the warrant, and I will lock you up.
Sir.
Do you understand? No more get out of jail free cards.
It said no fake IDs or licenses for confirmation.
Don't worry about it, because I'm gonna.
All right,
Yeah.
Judge, the next.
Oh, what? Did you think that you were coming to the beach today in shorts?
Yeah, I'm sorry. I completely wasn't using my head.
You know, when my kids tell me sorry.
It's my first time in court. I'm sorry.
It's a court. You know, in court, you're supposed to dress a certain way. This isn't the circus, man. You know? You continue to say sorry for things. At some point, your sorry will go in this ear and will go out that ear. Do you understand?
Sir.
Everything you're doing here, I'm going to mark it and we will know it. So that if you come in here and try to play this game again, I will put you on my knee like a little child and I'm going to spank you like a little child, but I will do it with a ton of jail time. Do you understand?
Sir.
I'm making your bond conditions severe. I want you to understand, no more fake IDs, no alcohol,
Situation again, promise.
no illegal drugs, and I'm going to test you. I will test you 40 to 45 days from today. If you test positive for marijuana again, that tells me that you've continued to smoke. I will put you in jail. You will not get any more PR bonds, and I don't care if you're kicking and screaming and praying to Allah that it wasn't this. I don't care. You will go into custody. You are on notice now. Forewarned is fair warned. Do you understand?
Sir.
All you have to do is stay in school, graduate, don't use.
I know.
Do you understand?
Sir.
Okay, we've given you a lawyer. It is your responsibility to stay in touch with Jillian, and she will tell you when you have to come back to court. If you test positive, or I'm sorry, negative, at that point, we'll just give you a normal reset, but you are still under bond conditions not to use.
Sir.
Because they can call you in at any time to come test.
Sir.
Understand?
Sir.
Okay? All right, Jillian, thanks. That's it. Good morning, ma'am. Ma'am, you're charged with, please spit the gum out. Do you have a trash that she can spit so you're not smacking with? Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Officers observed the defendant driving without lights on at night. Officers used the intercom to tell the defendant to turn her lights on. The defendant pulled over into a parking lot. The officer approached the defendant to ask why she did not have her lights on and observed strong odor of alcoholic beverage. Officer detained the defendant and placed her in the back of the patrol vehicle to wait for a secondary unit to assist. When officers returned to the patrol vehicle with backup, defendant had slipped out of one handcuff, and while officer attempted to place her back into handcuffs, defendant bit one officer and kicked the other. Defendant was taken to JPC and a blood warrant was signed and executed.
They didn't, I guess because of that, they didn't do any field sobriety tests on the scene. They didn't do any at the station, I guess, either.
Right, Judge.
Okay. Ms. Barrows, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I will randomly test you. If I find that you're using alcohol or illegal drugs, I will put you in jail. You will not get any more PR bonds.
Yes, sir.
Do you have a valid Texas driver license, ma'am?
No, sir.
Then you're not allowed to drive. I'm making that a condition of your bond as well, and you're going to sign with me today a promise. This is an affidavit that you're going to sign that you're not to drive any vehicle whatsoever for any reason, and I don't care what your excuse is. If you drive, I can have a contempt hearing. You can be facing 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
If you want to drive, go get a license, get liability insurance, show us that you have this, and then I'll happily take this restriction off. But until that point, if I find that you drive, I'm going to go nuts on the bond. Do you understand? Okay. So you have a lawyer. It's your responsibility to stand to us, Mr. Brooker, and he'll tell you when you have to come back to court. If he tells me he can't get a hold of you because you're ducking and dodging phone calls or text messages, likewise, I'll issue a warrant. No more PR bonds.
Yes, sir.
Okay. I'll have you come up here, swear to us that you're not to drive. We'll have you sign a reset with Victoria. You'll meet with Felicia for your bond conditions, and after that, you guys are free to go.
Thank you, Judge. Step over here. Thank you, State.
Thank you.
John, come on up. He did re-enroll in school, Judge, as instructed.
So are you appointed or are you retained in this case? Is Mom here as well?
Yes, yes, yes.
Come up, Mom. You can come up.
Judge, for Barrows, did we have any special bond conditions for a child?
Same as normal with the DWI. And then she's here in shorts, man. I'm going to talk to her here in a second.
I'll speak with the judge.
No more marijuana. Do you understand? I will test you 40 to 45 days from today. If you test positive again, that tells me that you've continued to smoke. I'm going to put you in jail and I'm going to make your bond high. You got to understand, your mom probably doesn't have a lot of money as it is, every time you go to jail, it's going to cost her money to get you out when she could be feeding and using that for rent. Do you understand? You are also to stay in school, not hang out with the people that you were in this car. No associating with the co-defendants in this case. No weapons. Stay in school. Do you understand? We've now given you a lawyer. It is your responsibility to stay in touch with counsel, and he will tell you if and when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, I will issue a warrant. And I'm going to tell you now, I'm not going to give you any more PR bonds. Do you understand? Yes, sir. Okay. Anything that you'd like to add? Do you need anything? Because I don't know how he is when he's at home with you. Does he act up? Does he help you out?
Yes, he helps me out. He does side jobs at home. Recently, I was able to get him enrolled back into his homeschooling program, so he's actively working on it.
Okay, I'm going to want proof that he's actually enrolled in school and actually doing well.
And provide it. It's online.
Great. And I'm also giving him a curfew because I don't want you out in the middle of the night. You're getting a curfew at 10 p.m. and I'm putting a monitor on your ankle so I know that you're not out. Do you understand? Sir. Don't act a fool. When you start being a danger in the free world, I will take the free world away from you in a second. My only concern is public safety. And when you're in a stolen car with a bunch of other people with stolen guns and everything, that's not a good look. All you're going to do is end up with a number on your back perpetually in and out of jail, never amounting to anything. That's not a good way to go through life. Life is a journey. It can be a great journey where it's filled with love, fun, vacations, nice cars, or it can be a miserable, rotten toilet of an existence where you never have any money. You argue with everyone about everything because you ain't got no money. You got no education to be able to support yourself. That's not a good way. That you don't go through life like that. And it starts now at 17. You understand, Mr. Melendez? You won't get any more warnings from me. Straighten up and fly right. You stay with me. Okay, guys, thanks. We will pay for everything for you, so it shouldn't be a dime out of your pocket, okay? All right, Mom, thanks.
Yes,
Are you Samantha Walker? Ms. Walker, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge.
Okay.
On November 4th, 2024, an officer was dispatched to a family disturbance call at a residence in Harris County, Texas. The complainant, a 15-year-old, stated that the defendant, her mother, assaulted her after they got into a verbal argument. The complainant stated the defendant displayed verbally aggressive behavior towards her, grabbed a hold of the complainant's left wrist, and said, "If you come near me, I'll beat your ass," and began to engage in a physical altercation with the complainant. The complainant stated the defendant, using both open hands, placed the complainant in a headlock and the complainant felt pain. Both law enforcement and CPS records indicate a history of physical altercations and verbal altercations between the complainant and the defendant, and the officer observed video footage showing the defendant acting as the primary aggressor towards the complainant and observed a minor injury cut on the complainant's left arm.
So we have prior violence, any prior charges?
There's no prior charges,
No
Your Honor.
prior injury to a child, felony charges?
No, Your Honor.
Okay, so you take all this stuff. Child means 14 years or younger. Okay, ma'am, I'm going to find that there's probable cause to go forward with your case.
No, Your Honor.
Don't. Now's not the time, ma'am. You have the right to remain silent. Exercise that right. I've got a bunch of DAs here. Anything you say, they're going to use it against you. Guys, what do we do about contact? you know? Yeah, well, so Michael, I need your help. You know, this is a 15-year-old child. We have a history of violence allegedly between mom and daughter.
Yes, Judge.
Now we have an assault case against a 15-year-old. And according to what Alex says, there's a history of it. It's unacceptable.
Judge.
Do you have a lawyer, ma'am?
I'll be retaining a lawyer, but there's no history of violence between us.
You're calling for a walker?
Yes.
Which walker?
One Walker.
It's in custody.
Thank you.
Okay.
So, what my plan was, and I already spoke to my people about this, is we were going to check the offense report to see where the child was taken. Were they taken to CPS custody, state custody? Was there some other guardian? Once we're aware of where the child is, we are going to be asking for a no contact order to be granted based off of the allegations of the history.
What about now? Is there something that we can do now as far as finding out where the child is?
Well, we're going to call CPS today and see if they're in state custody. The offense report also might indicate where it is. If not, we can call the officer and they should know.
Yeah, I'd like to, because I think it's serious. I mean, if we have a history of violence, I don't want that to happen anymore. I know that you're telling me no, but I have other people that are telling me differently.
I've never.
Okay, well, ma'am, don't. Now's not the time. But my primary concern is the protection of every single person in Harris County, bar none. That's it. Especially if it's a child. And
I'm not a threat to my child, I promise you.
You are now charged with assault, ma'am, on that 15-year-old child.
I never assaulted.
Stop. Now's not the time. I'm just trying to tell you, if I find that there is a history of violence with the child, I'm going to order you not to have contact with this child.
I understand.
As it stands now,
but I promise there's no history of violence.
Called a magistrate's order for emergency protection that identifies EJ as a protected individual.
I have to take her to appointments and stuff like that.
Please listen. Okay, I know that you're trying to think of stuff to say, but I want you to listen, because this is very important stuff. And if you don't hear it correctly, you do something to violate this court order, they're going to file additional charges against you. I'm entering in an order for protection for that 15-year-old child. She's now a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Technical Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon. Typically, this also comes with a residential restriction that you're not to go within 200 feet of where she lives or where she works. Do you understand? Okay, I'm entering this order now. We will try to figure out about how we go from here, but my only concern is the protection of this child. To me, nothing else matters. I know that you're telling me one thing, but the evidence will show what it shows, and that's going to point to whose side is correct. So for now, I'm just going to have them reach out to see where the child is and how we go forward. So for now, I'm going to have you sign a reset, and then we'll just have you take a seat in the jury box, please. Okay?
So, Judge, I met with the defendant with defense in the room.
Oh, okay.
I'll let defense.
Your Honor, I showed him some video of the alleged assault, I believe. Of course, I haven't gone through the state's discovery, but this, in my opinion, is a child out of control. She's on juvenile probation in Tarrant County, according to her mother. The complaint says that she caused bodily injury by grabbing her. I mean, the complaining witness has a statue. She's threatening to get a knife. She's bigger and stronger than my client. My client's called the police numerous times.
This is why we appoint. There's always two sides, right?
I think this is almost enabling the child. When the police come, the police saw all this, but they're so sick of going out there. They're like, we're somewhere.
But I don't understand why they wouldn't, if you see this. Michael, did you see it?
I saw the video, Judge. Based off of what I saw and what defense told me, I'm unopposed to removing the residency restriction, to not granting a MOAP at all. and to just.
No more.
I wouldn't.
Okay, I mean, if that's what you think, I'll go with what you think.
Based off what they're telling me, Judge, and I did corroborate some of the information as well. We're just going to subpoena the CPS records to take a look.
Come up, Ms. Walker, come up. So I guess the $25 million question is, how do you wrangle in a child who's out of control?
I've been doing everything in my power to love her, do everything to help her get some type of mental help. I've had her admitted to several programs. I've even contacted CPS myself personally, had them come out to the house. She got up and walked out on us. I've tried therapy. I've tried medication.
Hell hath no fury as a scorned 15-year-old. I tell you what, I mean, I remember I was 15. Oh God. And I hope it doesn't, I mean, I know it's going to happen to me but what's she on probation for?
Trying to stab her older sister, my other daughter.
And that's in Tarrant County.
In Tarrant County.
And a juvenile case.
Okay, so I'm at your disposal. I guess whatever you want, ma'am. I'll take off I won't do the order for protection. Just be careful, I won't put I'm not going to put any conditions either, I guess,
I would just say no threatening or harassing, Judge, if the court's inclined to do that. This is some sort of.
I mean, how do you handle a 15-year-old?
How can you be a parent if, it's almost like you're disarmed and the child can do whatever she wants. And if you touch me, well, you're going to jail, Mom.
Correct.
I mean, imagine that. The child will have unfettered access to.
And the arresting officer told her, if you feel triggered, you can leave and take a walk. Well, that walk turned into her being gone for 7 days.
Oh, my Lord. You can bring her here? She'll come here. I can try to talk to her.
Yeah.
Show her the jail. I don't know.
She's in the jail in Tarrant County already because she continues to violate.
And that's the juvenile detention. It's not the same thing.
I don't know. I mean, I don't know how worse juvenile detention is versus regular.
And she had an ankle monitor, but it was cut off.
It's not like the jail.
Really?
Yeah, they're in plain clothes. They're not in handcuffs. They have plenty of hours.
Really?
It's completely different.
It might as well be a playground.
Yeah.
Wow.
It's not like Dr. Phil where he sends them to the.
No.
Okay.
It's playground.
No.
I'm not going to put any. Just be careful. It's evident she's bringing you down too, and I'm so sorry for it. You're welcome to come bring her here. We'll try to help you out.
Yes.
If she'll listen to me, I'll try to talk to her or whatever you need. We're at your disposal.
Thank you. I appreciate that.
You ever need funds for anything, just let me know.
Okay.
That's why, I wanted to appoint you someone because there's always two sides, right? We get one side here, but a lot of times you don't get the other side. And a lot of times we take that for granted, and it's good to have another ear in just so that we always know we get a complete picture, and it's just so important. So I'm sorry you're going through that, and I hope it gets better. If you keep loving, I got to imagine she's going to get better, really. Because I tell you, I was the same way. Hell on wheels, and if it weren't for my folks, holy moly, I don't know where I would be, really. So, okay, man, thanks. So we've given you a lawyer. Just stay in touch with James. He'll tell you when to come back, what you need to do. I'll waive your appearance. You don't have to waste your time to come into court. Just stay in touch, and then you guys work it out, okay?
Yes, sir.
Okay. Best of luck to you.
So the protective order and the.
No conditions, no.
No conditions. Okay. Just hold on to it.
Yeah, we'll shred it. Just shred it.
Okay.
Yeah. Okay. Okay.
Your Honor, I'm here on Leo. Leo's the last name, Leo Terrence. And he's here today, Your Honor. This was rolled over from yesterday. And we have an issue on the PTI. We need to bring to the attention of the court. There was a violation. Yes, sir, he is here.
Come up, Mr. Leo.
There's some issues, violations. Mr. Nathan is PTI chief. is willing to agree to extension of the PTI. He had just almost about to finish it when the violation occurred, but they're willing to agree to a 6-month extension. We're before the court today to request to see if the judge will agree and approve that 6-month extension on this PTI. I'll let your staff here advise you on this violation.
A lot of it depends on how he was doing. Has he done anything? Has he done most of it? What are the hiccups? Is he continuing to use?
Yes, sir. In that regard, he is scheduled for 2 classes. One is being November 13th. What are the 2 dates?
November 13th and 15th, 6 p.m. to 9, and second class is on December 2nd, from 6 to 9. That's virtual.
So those are the 2 classes they had set him up for. But
what has he done?
He has to complete the DWI education course and that's the decision making. Those are the classes he's registered for.
Well, he hadn't even done that, and it's.
So he's kind of financial hardship, so they're doing all of the programs in-house. His device has been in lockout since July. They've been drug testing him more frequently because of that. His last 5 drug tests were positive for marijuana.
You don't say. If I test you now, what are you going to test positive for? Really? Really? I'll send you right now. We'll see.
His last drug test was October 16th, and he was positive for marijuana. So they want to extend him for 6 months to allow him to complete the 2 classes in Iowa.
Joe, he hasn't done anything. All he's done is continue to smoke weed the whole time.
Your Honor, I did sit down before we approached, and he assured me that he had stopped. I told him, talking to you, and that you would test him, and, I gave him the option because, I was willing to speak with the DA too to see where they wanted to go with this and talk with the client as well about that. One of the things about the machine, he says, as you said, he's been out of a job, and the probation officer's working on him knows that, and that's why he hadn't been able to pay for the installation of the machine, which is no excuse.
But he has enough money to smoke weed. People spend money where they want to spend money, right? If you truly want to do something, there's always a way. So when someone is not working, it's because they choose not to work, not because they can't work. If you really wanted to work, you could. It's a matter of you just don't want to. And I get it. But don't come here asking for us to be lenient when you don't do anything. You've been in lockout since last July? You've been in lockout for an entire year. And Joe, if I send you for a test right now, what are you going to test positive for? Man.
I ain't been smoking at all.
Look,
I just have no marijuana and nothing. I don't do no other drugs.
No, you're in a diversion program where the idea is you're supposed to stay clean, and when you do, the reward is that they dismiss your case. And if you do, you don't even have to do that much. All you got to do is 2 classes, right? And just stay out of trouble. And they dismiss the case. Joe.
Yes, Your Honor. Your Honor, I wanted the opportunity that if
he's been in lockout for an entire year.
I was going to talk with the DA and see if there's another resolution of the situation and see what options. He wanted me to check on that if the court was not in. I explained to him 6 more months means he needs to be in compliance 6 months.
Yeah, I'm not, and he's not been in compliance at all for anything. I'm not inclined to do another 6-month reset for him to just do nothing for another 6 months. I mean, we're delaying the inevitable. You know what I mean?
Yes, sir. I understand.
So you might as well just.
Yes, sir. Your Honor, we'll talk to him right now, and thank you for the opportunity to come before you.
Sure, Joe. I love you, man, and I'd say that of all the people that come here with violations, 99% we do. But you got to show that you want it, that you really have a willingness to do it.
Yes, sir.
And when you don't, really, I mean. The program is designed to reward people who faithfully work for it. And I get that there are hiccups in life, but when you do nothing, you've been in lockout for an entire year, you literally have done nothing for an entire year, and all you've done is continue to smoke weed the whole time. That shows us you don't care. So why would we care? You know? All right, you guys talk. Let me know what you want to do. You must either accept or we're going to set your case for trial today. Okay? All right, please.
Don't I have one other one, Brenda Reese?
Sure.
The court had asked me to approach on this one. This is a client who's also working toward dismissal. He just needed one more reset in order to get the funds to pay for the driver's license. Which is the
Yeah,
last
I mean, it's 140 days. If you need more time, of course. Yeah, for sure. Whatever you need.
Thank you very much.
Of course.
We're going to do that plea on Leo.
Okay, of course.
Mr. Leo?
Yeah, Mike did.
Mr. Michael, what was his last name again?
Leo was the last.
That's right.
Terrence Leo.
You know, Mr. Leo, you got into this program and may not be today, may not be tomorrow, may not be in a year, but one day you're going to kick yourself for not making this work because now this DWI will go on your record. It will be there for the rest of your life. It's even there after you die. And this is important because if you ever get pulled over in a car, first thing an officer does is they look at your record. If they see that you have a prior DWI and they come up and they smell weed on your car, they smell alcohol, what do you think they're going to do to you? Right. What we're doing today, from now on, you are facing a minimum of 30 days in jail. No more catch and release. Do you understand? So if you want to get lit, you want to have 52 beers, 32 joints, don't get into a car because you do, there's going to be a lot to pay. Not only that, but there is a surcharge of around $3,000 in this case that you'll be responsible for. Not to mention the court cost, which is another $500 something. Yeah, when you get a DWI, it's really expensive. You get a second DWI, it's around $7,000 in fines and fees and surcharges. And if you don't pay it, you don't get a license. And you don't get a license until you pay it. So it will be in an indefinite suspension. Do you understand? DWI in Harris County, it's big business. Not only that, it's so dangerous, it's ridiculous. So how do they get you to recognize that? By hitting you where it hurts, in the pocketbook. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen or possible immigration consequence, you can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will go on your record. Like I said, it'll be there forever. You can never come back and complain about this. Do you understand?
Yes, sir.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I will find you guilty and I will sentence you to 3 days in jail. I'll give you credit for the 4 that you've done. I'm going to suspend your license for 180 days. Do not drive until you get a license. So what are you doing with yourself these days?
Looking for a job.
When was the last time you even had a full-time job?
Last time it's been like 4 months since I couldn't get Ubers back and forth because it was like 40 minutes away, so I couldn't afford the Uber. So they basically let me off because I couldn't show up. So I've been 11 interviews. I've done a lot of applications as well. I've been just trying to find me a job.
Did you graduate from high school?
Yes, I did.
Okay. You know, the idea in life is that you were young and you bust your ass when you're young so you don't end up 70 years old without a pot to piss in. Because I'm going to tell you, the older you get, the more difficult life gets. And if you don't have a pot to piss in when you're older, your life will be all the more difficult. You work hard, you set yourself up now so that you have a future and that you have a nest egg when you're old, because you're not going to be young and vibrant forever. At some point, your knees start hurting, your back gives out, you get bald, you get fat, you get ugly, you smell bad, you get hair where you never know it even exists and starts coming out. It doesn't get easier. And if you don't have money, this life will really suck for you. So you work hard now so that you have money in the future and take vacations. You buy nice cars. People divorce now because all they do is they fight and they fight about money. That's why half of this population is divorced, because they ain't got no money. Do something with yourself, Mr. Leo. I will give you this now. I will roll your court costs and I will quash your otherwise $3,000 surcharge. But if you come back, look forward to HE double hockey sticks, if you catch my drift. Do you understand? Next time, it's going to cost you big. Do something with your life. Don't be a wasteoid like. Good luck. Thanks, Joe. Well, Mr. Leo, we want what's best for you. What you're doing now is you're doing nothing. And you will end up as a nothing. Just smoking weed all day. You got to stop. All right. Good luck. Thank you. Thanks, Joe. Good morning, Mr. Westbrook. Mr. Westbrook, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On November 10th, 2024, the officer was dispatched to a residence in Harris County, Texas. The officer made contact with the complainant. The complainant stated the defendant, the complainant's son, and the defendant's friend had broken a window to get inside the night before. The complainant stated that she woke the defendant up and told him his friend had to leave. The complainant stated that she questioned the defendant about her missing prescribed oxycodone, and the defendant became irate, and the defendant struck the complainant with an open left palm across the right side of her face, causing pain. The defendant began to destroy the residence, grabbed a kitchen knife, placed it to his own throat, and fled as the complainant was on the phone with dispatch.
All right. Mr. Westbrook, I'm going to find that there's probable cause to go forward with your case. I'm sending you now for a drug test. I want to know what, if anything, is in your system. You're not to use alcohol, illegal drugs, unprescribed controlled medication. If I find that you're using, I will put you in custody. If you have a problem with drugs or alcohol, Mr. Westbrook, you better tackle it, because if you don't, I'm going to do it for you, and I promise you, you're not going to like the way that I do it. Do you understand?
Yes, Your Honor.
It's now, 12:10. All my lawyers are gone, and I need to get the results back, but it's not going to be. So we need to roll this case to either, tomorrow, Friday, come back and we can finish what we're doing. Now it's just too late for us to get the results and finish everything up. I'll let you pick whatever day you want to come back, but we have to come back and finish.
Yes, sir.
How old are you?
I'm 19, sir.
What do you do for a living?
Right now, I'm just working at a fast food place, trying to get back into college.
Who do you live with?
My mother. Well, that's who I was staying with.
I don't want to talk about the case. I only want to know what you're doing in life and see.
I'm trying to get back. I'm trying to go to college. I'm at trade school to become a welder.
That would be fantastic. I tell you what, there's no better way to make a killing than getting a trade like that. It's a great idea, right? Unless you want to go the school route. Either way, but you got to do something, because now is the time that you build your life. Not at 46, at 48 to try to say, well, you know what, I'm going to go to college now. Most people have their careers by then.
Sure.
All right. So, we're going to send you for a test now. We'll have you come back, and then, we don't.
Yeah.
Yeah. Yeah. Do you know the complaining witness? Have you guys reached out to this person?
No, Your Honor.
What is the relation?
The relationship, the defendant's her son. That's the mother, Your Honor. The complainant.
So the complaining witness in this case is mom?
Mom, yes, Your Honor.
I want you to understand something, Mr. Westbrook, that I'm issuing a protective order, and your mom is now labeled as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. What you need to understand is what is threatening or harassing. Doesn't matter what you think. It's how she perceives. So if I go like this, is that threatening or harassing? It most certainly is. And it can land you back into jail if you threaten or harass your mother. Do you understand? Is she here now? I want to send her right now. So what we'll do is, guys, this is Westbrook. We've got mom as a CW. Yeah, or I guess let me give you the cost number. You're right. I'm sorry. It's 253-8133. My concern is that when we have these cases and no one has spoken to the complaining witness, I order no contact. How are we going to do that here?
Let me see, Judge, if I can step out and try to contact her.
Yeah, do you mind? Let's see if we can, please. All right, so let me impart to you one more thing, Mr. Westbrook. You got out of jail because we gave you a free bond. When we revoke bonds, we normally set them in around 5, maybe 10,000, maybe 15, depending on what happened. If you don't have anyone to pony up that kind of money, you will be stuck in custody until these cases are over with. So when you're out there in the free world, think before you act. Think before you speak, because it may be very well. Do you understand me?
Your Honor.
Okay. What did you want to say? I don't want to talk about the case.
I was requesting, is it okay if I check myself into the mental hospital? It's not involved the case, but that's where I was supposed to go. My mother had called my shrink, and she told my mother to call the police to take me to the Cypress Creek Hospital, and they told me they were taking me there.
How did you get here today? Your mom didn't take you?
No.
How'd you get here?
My friend took me. And because I was going to sign myself into the mental hospital,
Someone now, please.
I called up here and they told me, well, that you shouldn't
Let's do this, because I don't want you to say too much, because you never know what you're going to say that's going to end up hurting you. I do, above all else, want to get a test today, because I want to know what, if anything, is in your system.
Yes, Your Honor.
I want to do that. If you fail to go test, if you fail to, I'm going to revoke your bond. I want you to know that. I just want to know what's in your system. And no more dope. It could be very well affecting your life in more ways than you know. When you take, do you take medication prescribed by a doctor?
And that's what we're working on.
Okay. You got to find something. If that's what they prescribe, you got to also have to understand that it may take a while to find something for you to get used to that. When you start taking these psychotropic medications, you may take one and there's a side effect that doesn't agree with you. So you move on to the next one. It may take a couple days, but you got to just wait, find the one that agrees with you, but give it time and be patient, because it affects everyone in different ways. So if you find that you're agitated, that you find yourself angry, just time out, relax. It's never the end of the world. Anything can always be resolved with time, love, care. So just take that.
Your Honor.
I'm going to appoint your lawyer. I'm going to see if we can get you one here real quick. Okay. Jillian, this is Mr. Westbrook. We're going to have him just sign conditions. We'll send him for a test now. They're reaching out to mom. Mom's a complaining witness. He's thinking about checking into a hospital. If you feel that that's something that you like to do, great. That's a good thing.
Just want to get help.
It's anytime you try to help yourself like that, that's great. And I'm proud of you for doing it, because not many people realize that, hey, I may need this kind of help. And we're support you. Anything you need, we're there to help. I can't give you a ride, but do you have a ride here now?
Yes, sir.
Okay. I guess bear with me a second. Just take a seat for me. I just want to wait to see if she was able to get in contact with your mom. Once we do, I'll bring you back up. We can talk. Okay. Thank you, Mr. Westbrook. And good job for coming, huh?
Would you like him to return to address results?
We're not gonna return. We'll send him off another day or two. Yeah. Lillian, you ready? Okay, tell me.
So I just spoke to the complaining.
You got a hold of her?
Yes, I got a hold
Yay.
of her. She's his mother. She was extremely distraught on the phone. She said that the defendant is mentally disabled. He has a lot of conditions, and he has these episodes. I didn't get quite a great understanding of what episodes is, but she had called his therapist or his psychiatrist, and the shrink instructed the complaining witness to get him transported to Cypress Creek Hospital.
Okay.
Because he was making threats of harm to himself. And so this complainant called the police in order to try to get their help in transporting him to the hospital because she couldn't get a handle of it. So she says it was never an assault in progress call and not one that she intended to make. She said when the police asked if the defendant was hurting her, she said no. So she is very distraught as to why this was filed.
Did an assault occur?
She says that when he's having episodes, he flares his arms around and sometimes it could strike her, but it's not like intentional, is what she said. And she said she's not afraid of her son. She is upset that this happened when they were supposed to help him. She was just very distraught, Judge. And I don't
It
have
really
any.
makes me mad how people ask for help and then, instead of taking someone or helping someone into a facility, they just arrest because it's easier to arrest.
We've literally set up a system now to where it's just as easy to not arrest them and they
The
still
hell
arrest
is,
them.
I don't understand people.
I can see if they didn't take them to Cypress Creek, they took them to wherever the designated location is, but there's a whole, it's just as simple now to take them where they need to go.
No, I agree, Judge. I don't
We
know.
need to start holding people accountable.
Yeah.
Yeah, she's very distraught and she said that he's on the way to.
Did an assault occur?
She says no. She said no assault occurred.
Is there evidence that an assault occurred?
Judge, this was just.
Right, because we know a lot of people recant, but do you have any evidence that one occurred?
I don't have anything right now, Judge. It was only filed 3 days ago. It wasn't even set for arraignment until, it was set, it's not even set until the 18th for arraignment, so I really don't have anything besides the offense report right now. So I can't look at body cam and see if she made any statements on scene. All I have is this writ.
Will you read to me the DIMS again, I guess?
You want me to read the DIMS, Judge?
Yeah, or
Yes.
whatever you got to detail.
I have the case jacket.
Do it.
Okay.
Please.
On November 10th of 2024, officers were dispatched to a residence in Harris County, Texas. Upon contact with the complainant stated that the defendant, her son, and the defendant's friend had broken a window to get inside the night before. The complainant stated she woke defendant up and told him his friend had to leave. The complainant stated that she questioned the defendant about her missing prescribed oxycodone, and the defendant became irate, and the defendant struck the complainant with an open left palm across the right side of her face, causing
Okay, all right, so mom says that this happened?
This is, according to the DIMS, but she told me something completely different on the phone.
Michael, what do you think?
She's recanting, yes.
Is this a bond? Are you approaching on bond condition?
No.
Okay.
PC?
Just on PC.
PC. Ultimately, what's happening is she called the police in an effort to get mental health help. But what ended up happening is they just took him to jail. Now, she allegedly does say that assaultive behavior did occur, but now she's saying something completely different. What's right?
Yeah, Judge, I mean, what they do this all the time. They say what actually happened to the police, and then they'll recant the second someone goes to jail. They want them out of the house to be safe because they're in danger at the time. And then when they realize the person actually went to jail and is being held accountable, they call us and tell us, well, nothing happened. I think at this point,
I mean, I know that.
Time to watch the body cam and listen to the 911, but I think what she said at the scene is what we need to go off of based on PC. And what she's saying to us in the RIP call, we need to evaluate the case at that point. But what's in the offense report, what she told police at the scene, should judge how we evaluate PC for now.
And I was gonna say, I would disagree. It's not your run-of-the-mill recanting, because the first phone call that was made was to his psychiatrist. And his psychiatrist says, call the police so they can transfer him to the mental health hospital. And so that's what she did based on the advice of his doctor. And so
That's according to what she told me, Judge, that she called the shrink. Well, she called the person a shrink, so I don't know if it was a therapist or a psychiatrist, which is why I'm saying shrink. She told me that she called them first, but again, that's going off of her word, and if she's recanting now, I don't know how much.
I think that for now, I'm going to find it, okay? But I guess,
Judge, in lieu of any drug testing right now, I mean, he can go today, but as far as like resetting him for tomorrow or Friday, he is supposed
Mr. Westbrook.
He is supposed to be checking in today, as was the plan last week. Is that okay with the court? I'll get the proof that he's checked in. They've got a bed ready for him, and he's supposed to be going in today to the hospital.
I'd like to test you real quick, because I just want to know what's in your system. Will you go to the hospital afterwards? I think it may be a good idea, you know? Your life is valuable. You have only one. When you take a catastrophic move where it's you harm, it's something, it's not like Target, you can return it. You can't, there's some things that you just can't come back from. If you have patience, then anything can be achieved. So don't make rash decisions. Take time, take care. We're here to help you as well. I want to help you. The goal for us is to have you leave better than you came. And if you give us time and be patient, we can help you with that. I have all kinds of resources, have all kinds of things at our disposal to help you. All you have to do are two things. Come back and stay in touch with Jillian. She's great. She will help you with whatever you need. She has a direct line to me that she can always call me. If you need anything, we have resources to help you out. But you got to stay in touch with us. And I think that that's a good call. If you make it down there, let me test you real quick. I'm not going to have you come back. Just go directly there to the Cypress place right after. As long as we know that you're there, I'm not going to revoke your bond. We will let you just take time that you need to go do what you need to do. But I got to know that you're there.
Sure.
If I don't know that you're there and I think you're out monkey business and not doing what you're supposed to be doing, I'll issue a warrant. I don't want to have to do that. So just please stay in contact with us. Do what you say you're going to do, and good things are going to happen. I promise.
Sure.
You can always get a hold of us. If you ever need anything, just come back here as well. We're always willing to help you with whatever you need. Do you have any questions? Okay. Let's set it off a week. I don't want to do a long one, just to make sure that we stay kind of close with Mr. Westbrook. You know, she'll give you her number so that you can always get a hold of her. Okay. All right. But we'll also take care of costs. You won't have to pay for anything. So don't worry about the money. All you got to do is show up and stay in touch with Jillian.
Sure.
All right.
So, quick question. When I do get out of the hospital, just to let her know that I am getting out of the hospital, correct?
So what happens is usually when you check in, we'll get a rough kind of figure for how long you'll be there. I don't know. It could be a day, it could be 2 days. The idea is to get you as the best way you can. And it may take a day or two, it may take a week. I don't know. But stick with it.
Sure.
You know, take your time. Rome wasn't built in a day, as the saying goes. It takes time. And if you've got the patience, you got the love, you got the want, anything can happen, you know, here soon. And I also have resources to get you on track to help you with welding if you want it.
Mr. Spencer has hit and run plus aggravated assaults on record.
Know people, and I'll help you out with it. If you help me with yourself, I will help you with the job aspect afterwards. I promise.
Sure.
You know? Okay?
Sure.
All right, Mr. Westbrook. Best of luck to you, okay? We'll see you soon.
Thank you, Your Honor.
All right, thanks, Julian.
All right, Judge.
Again?
Again?
There are some people that I see
Prior history is critical for bond decisions and sentencing.
over and over and over and over. Miss Cambrick. Since 1999. Deadly conduct, 99. Failure to stop and render aid, 2002. Failure to identify as a fugitive from justice. Now let's get into 2000s. 2004, theft. 2004, theft. 2005, felony theft. 2005, theft. 2005, theft. 2006, theft from a person, felony theft from a person. Possession of a controlled substance, 2007, possession of a controlled substance, 2007, and 2008, theft. 2009, possession of a controlled substance, 2010, possession of a controlled substance, possession of a controlled substance, possession of a controlled substance. 2012, theft, assault, theft. 16, 17, 18. Now, 2019, theft. 2020, theft. 2021, theft. 2021, theft. 2021, criminal trespass. 2021, theft. 2022, theft. 2022, criminal trespass. 2022, theft. 22, theft. 22, theft. 24, theft. 23, theft. 23, theft. And now, another theft. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On August 29th, 2024, officers responded to a theft of business at a Walmart in Harris County, Texas. Officers made contact with the complainant, the loss prevention associate, who stated on August 28th he contacted officers about a shoplifting, but no officer responded to take the report at that time. The complainant showed the officer the surveillance video, and the officer observed the defendant select a blue tote, walk towards the automotive section, look around to see if anyone was observing her actions, and select multiple Benzoyl motor oil cords off the shelf and conceal them in the tote. The defendant was then observed walking towards the health and beauty section and exiting through an emergency fire door without attempt to pay for the tote or the concealed oil.
How much the value?
Value. Let me check the OR, Your Honor. It's not in the DIMS.
And I'm guessing because they know it's going to be reduced to a misdemeanor, they just now file it as misdemeanors, Michael, instead of a felony?
I'm sorry, what's the question, Judge?
Do they hence assume intake that is going to be reduced to a misdemeanor as to why they filed it as a misdemeanor?
You know what, Judge, this has been happening a lot, and I'm not sure why. I think honestly, a lot of it is negligence into not looking at what their criminal history is before they file the charge. Quite honestly, because I see it a lot, and I don't think there's any policy for it.
And Your Honor, total is $98.
Amber, I'm going to find that there's probable cause to go forward with the case. I'm now sending you for a drug test. I want to know what, if anything, is in your system, and you're to come right back, and then we will discuss where we go from here. I'm going to put a GPS monitor on you, and I'm forbidding you from going to any store that you have a prior contact with in a theft case. Do you understand? And if I find that you have any contact with any of these stores, I'm going to make your bond so high your teeth are going to fall out. Do you understand?
Sir.
Catch and release days are over. No more catch and release. We are going to get to the bottom of why this continues to happen. And if that means some kind of treatment facility with a dual diagnosis residential program, then hey. But now you're working what? 30 thefts? Stops today. First things first, I'm sending you for a drug test. You must come right back. And if you fail to come back, if you fail to take the drug test, your bond will hit the skyline. You understand? We need to do a deep dive, Alex, into every single store that theft, that all those thefts come from, and just I mean,
Foster,
I know, if we can just forbid from going to any and all retail stores in Harris County, I mean, just.
Yes, Judge, if you would like, we can create a list.
Yeah, I'd like to do a dive into every single step she's done and.
Yes, Judge.
Okay, I was sitting in the dirt box store. Going around that way. Go have a seat over there.
page 7, Foster.
You're Tristan Foster.
Yes, sir.
Mr. Foster, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir. Okay.
On October 1st, 2024, officers conducted a traffic stop for a vehicle with no front license plate in Harris County, Texas. The officers made contact with the defendant, the driver of the vehicle, and observed an odor of marijuana. A search was conducted and officers observed a black plastic bag under the front passenger seat containing marijuana and drug paraphernalia, such as a weight scale, a bong pipe, and multiple small bags. The officers also found marijuana grinder in the trunk of the vehicle. Marijuana was identified based on training experience and had a weight of 65.9 grams.
Mr. Foster, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license?
Upon the traffic stop, I found out that it was suspended.
I want to impart something to you, that I am making it a bond condition for you now that you're not to drive any vehicle for any reason. I don't care what your reason is. If I find that you drive, I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you drive. I don't care if there's a burning building or Mother Teresa needs to go to church. You get into a car and drive, there's going to be HE double hockey sticks to pay. Do you understand? What do you do for a living, Mr. Foster?
Sir,
What do you do for a living?
I do for a living, landscaping.
We're going to reset your case, give you time to hire a lawyer. So I'm going to have you come up here, swear to us that you're not going to drive. After that,
Can I file off for an attorney from the state?
why?
So I don't have money for a lawyer.
How do you know? How do you know?
Well, it's not my first time, dealing with lawyers, and I just don't have that kind of money right now.
2018, unlawful carrying of a weapon. 2019, criminal mischief. 2018, assault of a family member. 2019, assault of a family member. 2021, criminal trespass. 2022, unlawful carrying of a weapon. 22, felony possession of marijuana. And now you've gotten another possession of marijuana. In all of those cases, how many times have you gotten a court-appointed lawyer?
No.
Yeah, right. I want you now to go looking, and I want you to get a full-time job. And I am now making that a condition of your bond as well. The days of you sitting at Xbox, playing Xbox all day, smoking dope all day, doing nothing are over. I am making it a condition of your bond that you get a full. You've got that smirk on you, and I'm going to tell you now, it's not going to go well if you try to play with me. Do you understand?
I don't need to go spend my money when I'm taking care of my family to get a lawyer on a case that, you know what I mean?
No. I want you to go start looking for lawyers.
Okay.
And I want you to start Googling Harris County lawyers. There's a gajillion and one of them. Mr. Foster.
Yeah, they calling my line. They sending paper through the mail. Y'all know.
Okay. Start calling those and finding one you can afford.
Okay.
you pick up a new case, you start driving, I'm telling you now, I'm gonna revoke your bond and I'll make it sky high. Do you understand?
I understand.
You know, I'll tell you this though, Mr. Foster, you look like you have a lot of arrogance to you. If you put that arrogance into working really hard, holy moly, you could command the entire world. I know people who started as a freaking dishwasher at Chick-fil-A and they worked their ass off. Now owns 2 of them making 400 GER a year. That's hundreds of thousands every month that he's raking in because he put his chutzpah into working and his heart into working his ass off. And now, dude, he's killing it. And people thought he was a joke working at Chick-fil-A. And dude's he's the American dream. That's what it's about. Not this, not what you're trying to sell. Don't. Put your heart, soul into it. You can do anything. That's what makes this place so great.
Is that pre-trial bond conditions?
No, we'll have him sign the no driving affidavit. Hey, Don Lee, you ready?
Sir.
Mr. Kozlowski. Mr. Kozlowski.
Come up, Mr. Kozlowski. You're doing so well.
I know I screwed up.
What do you test positive for?
Just from a Sunday night I drank.
Stop.
I know, so.
Stop. I mean, what am I supposed to do? You're staying with me? I gotta take you in now. No means no. You know, either you don't care about conditions or you have a problem. But no means no. If I let you go, that means that I'm telling you it's okay. Just like Mr. Galvan over there, you know. We have court orders for a reason. When you don't comply with them, there's only one result that happens. It goes with you. All right? So Don Lee. It's with a K, right?
Yes, sir.
I'm really happy it's not cocaine because that's what I thought it was going to be when they told me that you tested positive. That's what I was. So the bond's at 5,000 now. I mean, I'll just do 6,001. I'm not gonna, you know. We'll see if he bonds out. If not, then we can talk. But I mean, we're not out for blood. So if he's unable to bond out, then we can talk about something in a couple of days. What about it?
I think he's gonna work these testings and he's just missing. He's asked to be there like 5 o'clock in the morning. Finally got a good job.
What's he doing?
He did. I want to say. I don't think so. He's clean.
Donley, will you talk to him, see what he's doing, and then let's see what we can do.
Yeah, I'm afraid that that's all. Because he really is on track.
Okay, find out what he's doing, then let me know, will you, please?
Mr. Cody Critter, so he was not sent today to get tested because the conditions were amended?
Yeah, he doesn't have to.
Okay.
It was Monday and Thursday, right?
Tuesday, Thursday.
Oh.
Well, it looks like on.
It's supposed to be Monday, Thursdays, because that's what we always do.
Right, on 10/3, they were changed to no drug testing medicine. So I wasn't here today, so I don't know.
Okay, I don't know, maybe I misspoke and said Tuesday instead of Monday.
Double check with Abel.
It's my fault. It's my fault.
Let's blame Abel.
Shush. It's my
said Tuesday, Thursday.
It's not his fault.
We have you on YouTube.
Come up.
That's what I'm saying is the conditions say nothing about drug testing.
Do me a favor, Mr. Critter, can you please have a seat real quick? Can we go ahead and knock out this one?
Hey, just give me a second, let me.
Come on, Ron.
Morning, Mr. Campbell. How's jail?
Not very good.
Good. That makes me happy. You know, what I find at least, the worse of an experience you have, the higher likelihood you have of actually, when you get out into the free world, of thinking about consequence, because that's what we want everybody to do. Think before you act, think before you speak, because you never know when it's your last time. All I know now is that you're wanted out of another state. You're wanted out of the state of Arizona, specifically Maricopa County, for manslaughter, 2 counts of aggravated assault and endangerment. Day,
Yes, Judge.
tell me about Mr.
That's all I have so far. I do show a Georgia State ID, which I didn't see at first, but I don't see any history. Originally, I believe this is only offense, but because of the severity of the offense and with the warrant stating that while there is a $150,000 bond, is that they're requesting no bond until he's in front of a magistrate within their state. And so because of the severity of the offense and the risk of flight, is that state requests no bond for this defendant.
Is this a 2B?
This is a 2B, Judge. It was issued out on September 25th, 2024.
Okay. And the bond over there is at 150,000.
150, but they will not permit it to be honored until he goes in front of a magistrate within their court.
Okay. Do you know what the manslaughter is about?
No, I don't have the probable cause affidavit, but if you're looking for specifics, I can request it from the DA's office, but I don't have it at this time. I just know that the charges are valid.
Do you have anything that you'd like to add?
Yes, Judge. Mr. Campbell actually hired an attorney, is known about the investigation, so this was not an instance where he's trying to run. The attorney told him they could take a family vacation. So he was arrested at a connecting flight in Houston with his wife and 3 children. So he wasn't trying to run. He was going on a family vacation. His attorney there told him.
We're on the way to the
family. He doesn't live in Houston.
Where are you going?
So essentially, he gets arrested in the connecting flight process. He's not from Houston. He is ready, willing, and able to go back to Arizona. He's got his attorney set up there. If he gets out, it's not like he's legitimately gonna stay at a hotel and then the next day get on like a bus, because we talked about the flight problem. And he has a vested interest going back. He's 41 years old. I think he has a license case from like 15 years ago, nothing else. Wife, 3 kids in Arizona. He's got 2 prior children in Georgia, but he has like a family life and a business in Arizona, lives there. So he absolutely wants to get back to Arizona. And with that in mind, we would be requesting a bond here so that he can just go back and turn himself in.
No, Mr. Campbell, I really value my city, and I want to protect everybody I can for as long as I can, because the last thing I want is more death, more destruction. And you're wanted for something where there's a dead body.
Oh, sorry, Judge. It just pulled up just now. So, Trey is correct. There was a suspended license, but he also had a prior hit and run and failure to stop and return to scene, which seems aligned with the manslaughter and 2 accidents with the vehicle and the
Is
driver.
that with this case or another
No,
case?
sorry, Judge. This is back in Georgia. So after the license suspension, there are 2 cycles. Hit and run, failure to return to scene. There's also DWI back in 2014.
Continues to happen.
I don't know what happened to that one, though. It just...
You want me to set you a bond? Silly?
Yeah. I had to run the state ID and it wouldn't pop up on the other side.
Yes, absolutely.
Sir, those cases were like thrown out. I didn't, whatever he has there, the DWI thing, I never had a DUI. With the hit and run business, that wasn't it.
How do I know that? Am I supposed to take your word for it?
For that thing, my car was stolen, sir, and then they assumed that, it's like how here they're assuming that I'm trying to run from.
No. No one's assuming that you're running. No one's assuming that you're running. All we know is that you are wanted out of Arizona, where there's 2 aggravated assaults and there's a manslaughter, so there's a dead body, right? And you also have priors out of another state where there's alleged DWIs and you running from the scene. So my problem is that I have no idea what the circumstances of the manslaughter are. How do I know you didn't shoot someone? How do I know you didn't run someone over in a car at a parade? And so it would be really just dangerous for me to really give you a bond and just let you go when I don't know how dangerous you are. Do you know what I mean? That's just, it's logic. As much as I'd like to get you back to Arizona as quick as possible, Mr. Campbell, you scare me. How soon can we get Arizona to come pick him up?
I don't know, Your Honor. I mean, well, for him, because he originally waived the magistrate, I know they've already.
He's waived.
Yes, I believe he waived 2 days ago when he went to.
Great.
Yes, so I believe the notice was already sent out.
Typically, the way it works is once you waive, we give that jurisdiction 2 weeks to come get you. Now, sometimes there are circumstances that they might want an extension for a day or two at the max 3, but by and large, they're pretty good at getting that jurisdiction to come get you within the next 2 weeks. And then we give you a free ride back to Arizona where you can answer those charges. Now, like he said, they're willing to set you a bond. Now, it's going to be a high bond, but you got to get there first. And me, I just don't feel comfortable giving you a bond. I don't know you. I know you're telling me it's little bunnies jumping in the woods, but I really just don't know you. All I know is that there's a trail of destruction, and I don't want any more. That's it. Do you understand? Okay. So, I'm sorry, Shreya. I can't.
No worries, I just want to make sure there's nothing else you want the judge to know about bond before we discuss issues.
Now, if you're able to post bond, if you're able to get your family to post a bond in Arizona, then they can release this hold and then we'll let you out. But I don't know if that's going to happen, right? Arizona wants you there before they're going to set you a bond, is what they've said. So, but you know, you never know until you try. The worst they can say is no. You have a lawyer, perhaps he can go get you a bond there. Okay?
Thank you, Your Honor.
Good luck, Mr. Campbell. Donnelly.
Yeah, I was.
Oh, I'm sorry.
I was cut off forever.
I know, I'm sorry. Again. Fritter, come on up. How are you, Mr. Fritter?
I'm okay.
What are we doing?
There were bond conditions that he be tested on Tuesday, Thursday. We came.
It's too close.
Right, so we came Thursday of last week, and they were taken off. So now he doesn't have any bond conditions of testing. That's what.
Okay, so we need to put him back on.
Back on, Monday, Thursday now.
So what's the matter, Mr. Fritter?
Monday I was supposed to have counseling, so that's why we're doing that on Tuesdays.
But the test was, no, I will figure it out. I got that.
Mr. Fritter, I still have to drug test you.
Yes, I know.
And if you can show me after a while that you've got it under control, then we can modify it. But for now, I want to test you to make sure that you're not using. Okay. That's it.
All right, so we just need you to order.
We'll do the bond, so Monday, Thursday, and then the anger management classes, and that's it. Okay? When was the last time he tested? Thursday?
Thursday.
Okay, we're gonna send you now for one, and then we'll see you next week. We'll set him off to Monday for next week.
Monday?
Yeah.
All right, thank you.
Mr. Fritter, you all right?
Yeah.
Okay. Okay, man. Have fun. Or he said he was using his. Okay, done.
I also have Mr. Gonzalez Martinez. I'm sorry, not Gonzalez Martinez. Oscar Cruz Hernandez.
In custody on bond.
On bond, Judge.
Okay.
Judge, you ordered him to come as well for testing. He is not here today. I got a call from the mother saying that they were on their way to the hospital. His appearance was required today.
Ask him for proof on SFBF tomorrow.
Tomorrow?
You know, Abel, it's not the first time they've taken him to the hospital.
Yeah,
So maybe
he's
they
having-
truly
he is-
are.
He is having issues.
And if he's really going to the hospital, I don't know about this bond, right?
No, I'll look at that.
You know, even if they can, like, send them a picture of some kind of proof that he's been admitted or something, you know? She really seems concerned. Right. She seems like a good person. But he's done, totally.
Your Honor, Mr. Osborne, I had a PCI agreement worked out back in February. He is a high school student. The phone number I had for him got disconnected. I couldn't reach him, which is why he ended up forfeited. I guess they picked him up where he lives now with his mother in Gregg County. He's a high school student. I'm just saying, like,
You have taken off on me 3 different times, Mr. Osborne. If you think that we are going to give you a PR bond, you are charged with assault, bodily injury. You're facing a year in jail. You had an offer in this case where they were going to dismiss this case, and you have repeatedly taken off, not once, not twice, but thrice. I am not going to give you a PR bond, and we are taking you into custody now. Your bond is now set at $10,003 because of all the times that you have taken off. And I get that you're in high school, but the problem is that you have already taken off 3 times. If I let you go now, what does that tell you? What? It tells you that it's okay for you to do what you're doing and not to hold you accountable. And that's not what we do here. You need to understand that courts are here for a reason. We do court orders for a reason. And when you fail to comply, when you fail to show, there are real world consequences. And I don't know if you have anyone that's going to bond you out. If not, you will be stuck like Chuck with me until this thing is over. And I'm going to tell you now, I'm not into this pleading guilty, time served just to get out, just to ruin your life. I'm not going to let you do that.
Your Honor, we accepted the PCI. The state said they would still accept the PCI.
I get it, but I'm not letting him out. I mean, it's 3 times the case. How old is this case? It's a year old, and
You set your bond at 10,000, so you post 1,000 worth of bond.
well, I don't know, because whatever they're going to charge you, I don't know. You're a flight risk. They may charge you more.
Can I ask a question?
Sure.
I don't recall, leaving 3 times.
You have a criminal case. You know that you are supposed to keep up with it. There's no out of sight, out of mind. You should have enough wherewithal to say, you know what? I haven't had court.
Oh, you don't do it for yourself yourself. This ain't the place where you ask questions, okay? All right.
You should have enough wherewithal to know, you know what? I have court and I haven't heard in a long time. What's going on? The only reason you are here now is because what happened?
Bonding company is attempting to get the case reinstated and or a new bond set for them. That's it. We wanted to let the court know it was our fault for not notifying him of
I'm
the
not
May
going
setting.
to all of the sort. It's not your
I do understand. Yes.
You know, if it was one time, okay, but we have 3 different times. It's unacceptable. Okay.
If I may.
Sure.
He did miss court 3 times, but he missed the first one because I couldn't reach him because the phone number I had was disconnected. I reset it 2 more times to try to get in contact with him. So he didn't purposely miss 3 court dates just because I couldn't, the phone number I had for him.
He knows he has court, Mr. Schofield.
I understand.
You know, behavior has consequences. And now you're going to see that there are serious consequences to it. He goes with you. Guys, I'm not out for blood, but I want him to understand that we mean business. If he is unable to make a bond by tomorrow, then we can talk, and I'm happy to entertain perhaps something tomorrow. I get it that he's in high school. But I want him to understand that we mean business. And if I just let him go now, it's enabling him. And it's not a good thing. But I'm happy perhaps tomorrow, if he's unable to make bond, we can talk about a PR bond tomorrow.
Should we just set it for review for
He's
tomorrow?
going to come back tomorrow regardless because they'll auto-populate.
Okay.
Because that's what happens when we take someone into custody, they auto-populate for the next day. So we can talk about it tomorrow about, because I'm not going to let him plead guilty just to get out and just to get a conviction on his record. And I'm happy to do this, but I want him to understand that we mean business and we're not playing games. So if he's still here tomorrow, we can talk about doing a PR bond and we'll let him try that. But I'm going to tell you now, he gets an ankle monitor, curfew, and I'm going to drug test him. And I'm going to be his dad. That's it. Okay. All right. Thank you. Mr. D.
Yes, sir, Your Honor. Your Honor, I'm here on Mr. Tempenby Akers. Mr. Akers was advised by you to go take a drug test. It's my understanding from talking to our pretrial services that Mr. Akers had tested positive for THC, alcohol, and
Oh, he tested positive for alcohol. Come up, Mr. Akers.
Ms. Akers?
You know, Mr. Akers, I was going to give you the benefit of the doubt as far as meth. Shh. Hey, we need to talk. As far as meth, cocaine, amphetamines, ecstasy, THC, I was going to give you the benefit of the doubt on all that. Because I know, because you tested positive just a couple days ago, that you were probably going to test positive today again. But alcohol is a different story. That doesn't stay in your system 2 days, 3 days. No. And I'm going to tell you now, Mr. Akers, the days of catch and release, done. Guess what happens now? So I think that at this stage in the game, because we've had so many issues with Mr. Akers, I think probably a TRAS is what we need to do to figure out how we go forward here.
Yes, sir.
But I think that I'm going to do, Mr. Akers, I'm going to do everything in my power to help you. I know that you're not going to like it, and I know that you're going to go kicking and screaming, but I'm going to tell you now, that's it. It's done. And I'm not going to take anything because I want you to get the help that you need. You understand? Okay, goes with you. There's nothing, no justification you can get.
So 3 weeks for mitigation package.
Good morning, Mr. Vidales.
Morning.
You know, believe it or not, we want to help you, but we need to have you evaluated. And every time we try to do that, you don't let them do it. The quicker way to get out is just talk to them. Let us know what's going on. And once that happens, we can work to try to get you released.
Man, I got my plans. I got like 1,000 deals going out of the free world. I got about 10,000 deals.
And I want to help you get to those deals, but can you help us with do the report?
I already did the report.
They said you wouldn't talk to them.
I did talk to them. They were asking me stupid Y98 questions, all types of stupid questions. I got 8 apartments. I got 8 bandos. I got 10,000 deals going on. I got all types of, I'm leaving Broadway. I'm not going back to no Broadway. I'm going to Honduras. I'm going to El Salvador. I'm going to Tokyo. Fuck Houston. I'm not staying in Houston. Houston is bullshit to me.
Oh, Houston's great. It's hot.
It's bullshit to me.
Why?
It's always been bullshit.
And I love my town. It's just too hot. But other than that,
leaving
it's
it.
great.
So can you please just let me go?
If you talk to my,
I already talked to them. I did talk to them.
but they told me you started acting up, then they couldn't talk to you because
Started asking me stupid. I'm gonna scare them back up again. I'm gonna scare them back again. I'm gonna tell them, stop asking me stupid questions.
I mean, we're not gonna do anything until you talk to them.
That's a
people.
misdemeanor. That's a misdemeanor. Misdemeanor is 24 hours in jail. That's a ticket and a warrant.
How long you been in jail?
I've been in jail for 4 months. My charges are for 2
Was
weeks.
it 24 hours?
My charges are for 2 weeks in jail. Walgreens got their own policy.
Look, I want to help you out.
Walgreens got their own policy.
Talk to them.
If I steal $5 from Walgreens, that's ticket and a warrant.
Mr. Valdez, quit interrupting the judge. Listen to what he has to say.
Talk to them.
Talk to who? Right now?
The doctors that come to see you.
I'm starving at this point. I'm starving. I eat $150 a week. I'm only ordering 1 bag of coffee. I'm starving. You got me sitting down looking like an idiot, starving.
Look, no one's looking at you like that.
I'm the one who's starving at this point. I could eat 10 chicken soups and 10 bags of chips, cheese, and then a whole bunch of coffee and chips and sodas and then water. I'm starving at this point. I'm starving. You got me sitting like an idiot, starving.
If I get you the food, will you talk to the people?
Right now?
Well, it's going to take a bit of time.
You're going to get me resetted again.
If you talk to them, we'll work to get you out. But be
I'm
nice.
not going to talk to them. I'm refusing. I'm refusing.
Then I'm going to set your case for trial then. We'll go to trial. If you're found guilty, then we'll just do the DDRP.
For what? For a misdemeanor?
Yeah. You keep picking
I'm not going to even take it to trial.
I'm going to put it to trial.
How are you going to put a misdemeanor to trial?
3 cases, and we can do one after the other. And if you're found guilty, at that point, we'll just.
I'm gonna drop off there. I'm gonna act a fool. You can punch me down and put me back in.
Come on.
Come on, Mr. Valdez. Let's talk about it. Come on. All right.
Go for plus.
Here we go.
So the thought process was instead of the TRAS, let's do a competency because maybe they can make a determination based upon the behavior or what they experience and when they do their evaluation.
Perhaps you do it right after lunch. You know?
It's like how he's acting with you, he's works with the citizens.
Is he on his medication? Do you know if he's taking medication? Perhaps let's schedule it for a time where right after he takes the medication.
Schedule competency or the TRAS?
Comp, yeah, no, not TRAS is just, right.
Yeah.
No. At this point, I'm with you on the comp. That's what we have to do. But you have to do it in a strategic way, right? When he's got a big belly, taking the medicine, and he's happy, that's when you do it. 30 days, I guess?
Do you need a comp? Without order?
So competent five.
Oh.
Yeah, five that. As soon as we.
Okay. Morning, Mr. Roach.
Good morning.
How's jail?
Not so nice.
Good. That makes me very happy. The worse of an experience you have, the more likely that you'll have to finally listen.
Yes, sir.
Why did you miss court?
I was in Galveston County Jail.
For what?
Evading and resisting. I walked into a.
Don't give a detail. Facts of the case make no difference.
Yes, sir.
What I need to know is why and why you keep picking up cases. Do you have a drug issue? Is that the problem?
No, sir. I am homeless.
Why?
Well, I'm on disability and,
tell me, where's mom and dad?
My dad lives in like Jackson with my stepmom. My mom lives in League City.
In League City?
Yes, sir.
Why don't you live with either of them?
Well, I would if I could. I would like to.
Why not?
Maybe I could ask. I can go to my brother's house, I'm sure.
No. Why would you not live with mom or dad?
Because I'm 30 years old.
So, After law school, you know what I did? Went back and lived with my folks too. And I was, God, how long ago was it? Not too long ago, right? 20 years ago. God, you know. 50.
20 years?
But I was in my mid-20s too, and I went back to live at home. There's nothing wrong with that. I mean, the question is, will they let you live?
I think so, but I could ask, and maybe so. It's possible.
Because I'm going to tell you now, me, I'm not letting you out to live on the street.
Sir.
It's not going to happen because chances are you're going to do whatever you can to survive, and that means probably picking up another case, and it's not going to happen.
Sir.
Believe it or not, I want to help you as much as possible. And
Can I ask him one question without going into the details, just because I hate it? Tell me this. Are those Galveston cases still open or are they resolved?
They're open. I'm on a PR bond.
On both of them?
Yes, sir.
Okay.
how many cases does Mr. Roach have open?
That is what I'm looking for right now, Judge.
No. Until I know that he has stable housing, I'm not letting you out. You now know that no one in this world is going to bond you out. So when you go to jail, you are stuck like Chuck until someone either mysteriously and magically gives you a PR bond or you plead guilty. And I'm going to tell you now, I'm not going to let you just plead guilty to get out and ruin your life. It's not going to happen. We're going to do whatever we need to do so that you get your life straightened out. And if that means sticking you back there until we get to your folks or whoever it is, that's it. No more street living. That's it.
Your Honor, would you consider lowering his bond to around the same amount as the felony, so that if one of his family members does post bond and has to go through the bonding company, that they're not out, hundreds of dollars?
I'm happy to do that. And I'm happy to set it at $100. But I want to know first that mom and dad or someone is going to have the wherewithal to let him come in, and so he has a stable place to stay. So I will do it, but I want to talk to folks first. And I think that what we can do is probably roll it to tomorrow. Okay. And then if you don't mind giving your numbers to Greg, and we can try to reach out to them to see who, hopefully someone is ready to take you. But street living, it's not going to happen, dude. And I'm going to tell you now, if we let you out and you get to your house, either mom, dad, brother, whoever it may be, is nice enough to take you in, and then you take off because you don't want to follow their rules, I'm not letting you street live. It's not going to happen.
Sir.
That's it. Typically, what I see is that people would rather party and live on the street than follow rules and get a job. Is that what the case is here, Mr. Roach? Then why live on the street?
Well, because I don't even really want to explain no more. I think you know. It seems like you do. So I'm kind of going to talk about it respectfully.
And I'm going to tell you now, Mr. Roach, that you've been in and out of jail now here for about 2, maybe 3 years. And I'm going to tell you, in the blink of an eye, just quick, 15 years will pass. And then if you keep the hard living, you're going to look like a Quasimodo looking MF here. At 30, you're going to look like you're 71. No prospects. Okay. 41, looking like you're 82. Because the hard living, as you see, like those pictures, this is what you look like on meth after 15 years.
Or 15 years of process, huh?
Yeah.
Crooked process.
Are you blaming me?
Well, I don't know who you is.
Just my name right there.
I ain't choose this life. This life chose me.
Really?
Really? Really, really.
Okay, let's stop.
It's easy to change. Okay? The hard part is keeping the change. And I will help you as much as possible. But I'm going to tell you now, I'm not throwing you out here and I'm not throwing you to wolves so that you can end up like that. And I don't care if you get mad at me, kicking, screaming, it makes no difference. But that's it,
sir.
So
I want the flow.
You want to roll it tomorrow and see if you can reach out to someone and see if they'll take?
I'm not sure I can make a phone call, but I know my brother to let me live at his house.
Okay, I'll call your brother. Okay. Yes, we'll roll you tomorrow. I'll bring you back tomorrow.
Yes, sir. Thank you, Judge.
But if his brother's like him, hopefully we can find,
Let me talk to his brother, see if they're willing to bond him out. Okay.
Thank you, Judge.
Thanks, everybody.
Linda?
Come up.
Step forward.
What? No. For real? What do you test positive for? You said everything?
Everything.
Stuff.
Yeah, bunch, a lot of stuff.
What's positive for?
Mr. Galindo?
Meth, ETG, alcohol, amphetamines, cocaine.
Yep. You said everything. That's right.
It's been a hard, it's a hard year. It was a hard year. I got out of jail in February. I lost my grandma. They're trying to sell the house. That's why they put cases on me. They offered me 30,000. I didn't take them because where am I gonna live? So, I don't know. It's been a hard year, man.
But it's really not though. It's mind over matter, Mr. Galindo. Mind over matter. You should be able to overcome these things and not have to always turn into dope. You know, when you have issues, if you're stressed out, if you're having a bad time in life, running to dope, that's not the way. You find another outlet, like working out, running, you know, boxing, playing bat. Anything is better than doing this. You can look at you now, man. I could tell the moment you came up here, I knew something was up. You know what I have to do now, right? What do I got to do now? What?
I don't know.
You staying with me?
What is it?
You staying with me?
Where? Oh,
Jail.
jail? Well, I don't care about no jail. I lost my grandma. I don't care about no jail.
Why?
I don't.
You should.
I don't, sir. I lost my grandma. I'm telling you, trying to tell the house, I don't really care.
Who else do you have in your life?
I got my sister.
Well, then that's something to.
I got my sister straight up.
Isn't it?
Yeah, but I don't really care about the jail. I lost my grandma. Any other shit is irrelevant. Irrelevant.
Do you think that your sister would be proud right now?
I already told her. She's mad.
Why?
Well,
She should be, because that's next time when you're in this, you think of your sister. Hey, if I do this, would my sister be proud of me? Would she be upset? That's what you need to think about.
Yeah, it was too much for me. Can I go now?
I'll take you now. Hey, I'm gonna wish you good luck on the next 2 to 3 days, because coming down. So good luck, Mr. Galindo.
Judge, we had him set for the 24th. Should we keep that date? Or do we need to do a bond review or get a bond set?
No, so the felony is set for.
I think it's the 23rd.
10/23. I mean, do you want to do the day after?
Yeah, I think we already have it set on the 24th.
Yeah, I mean, keep it, and then.
Okay, we'll just keep that.
Bond's 3,000 now.
Okay.
I'm gonna double it. 6,001. And then, if he bonds out, we'll do the same type of conditions. I don't know if he's gonna bond out or not, but if so, I'm gonna put a whole host on. And drug treatment will be one of them.
Okay.
Okay, thanks you.
All right, thanks, Judge.
Hi, Josh, who do we have? Salguero? Good morning, Mr. Salguero. Mr. Salguero, you're charged with burglary of a motor vehicle. You're facing up to a year in jail and or a $4,000 fine. What have you guys worked out?
It's
Time served.
Authorities with
He was sentenced to 2 TDC on his felony revocation, etc.
Had a lot of trouble getting a hold of you, Mr. Salguero. You pick up cases and you never come to court. I had one bond at $15,005 because you repeatedly failed to show up. The only advice I'm going to give you now is you're headed to prison. From now on, you are nearly what's called a true habitual. When you have 2 pen trips, you're labeled a true habitual. Is this 1 or 2 for you? Pen trips.
First time, sir.
Okay, from now on, anytime you pick up a serious felony, you're looking at a minimum of 15 years to life. So I would be very careful what you do, because like I said, when you're labeled a true habitual, you're looking at a minimum of 25 years to life when you pick up a serious felony. So when you get out of prison, wash that jail funk off and be good. It's not hard. Is it a DWI? Is that what he's going to prison for? Such a stupid crime. All you have to do is push a button, $20, anywhere you want to go. And now, just keep that in mind next time, you know? You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you plead guilty, you can never change this. Is this what you want to do? How do you plead to the offense? Or guilty or not guilty? One more thing I'm going to advise you on. You live in Texas. People like their guns and they like their cars. And I cannot tell you how many times we've had someone who's had this same charge where they've gotten shot. Careful. Next time, you may very well end up with a hole in your stomach. Good luck. Okay.
I also had Mr. Bale online.
Are we going to do that, please?
So much. Can you give me 1 second so we can knock out Mr. Roach real quick and then you do that?
Yeah, sorry, Josh, let me just do this real quick. Hi, Mr. Roach, how are you? Good, thanks. So your lawyer, much to my reluctance, has convinced me to set your bond at $500. And I'm doing it for one reason only, because I want you to get the help that you need. And so I'm going to put a monitor on your ankle so I know where you are. And we're wanting you to go to the Gulf Coast Center to get that help. If you fail to do it, I'm making it a condition of your bond. So if you don't go and you just blow us off and you take off, I'm going to revoke the bond and I'm not going to play this game with you again. This is not going to happen. This is so that you get the help that you need. Do you understand? I'm not going to warn you again, and I'm not going to play this game again. Okay, great.
Thank you.
Done. Okay.
Thank you so much.
Mr. Roach, make us proud, man.
Alex,
Yeah.
That's why I want to make sure.
501. Say it again? Yeah. All right, Mr. Bale, so you're charged with 2 cases. You're charged with failure to identify oneself to a peace officer and criminal mischief. On which? On which case though? The failure to ID or the,
No, that is the plea.
okay, that's a great deal. I hope you appreciate it, man. Because I'm telling you, if you pick up a criminal mischief and then you plead guilty to it, they can come around, turn around and sue you and say, he pled to this criminal mischief. I'm going to sue him so that they can fix whatever he broke. You got to be careful what you do in life because you never know when someone's going to come around and sue you to take everything you've got. Know what I mean? So as part of the agreement, you're pleading guilty to the failure to ID. They're going to dismiss the criminal mischief. You're giving up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you can never change this. It'll go on your record. You also need to understand, Mr. Dale, that from now on, you're facing a minimum of 90 days in jail for any cases that you pick up. 90 minimum. Do you understand? Is this what you want to do? How do you plead to the offense, sir? How do you plead? Guilty or not guilty? Are you guilty of the offense? All right, I'll find you guilty. I'll send it to you. Good luck to you, sir. Okay, thanks, Josh.
Mr. Roy?
Ms.
Lori, what was his last name again? Mr. Roy, how's jail? So, you're charged with the criminal mischief and self-control. You know you're on felony probation for something that could land you in prison for 10 years. Have you been to prison before? How many times have you been to prison? Anytime you do something where you can get charged with a serious felony, you're looking at a minimum of 15 years. 15 years. Now you're on a serious ass probation and self-control, picked up a criminal mischief. Lori's asking me to let you out, but how do I know it's not going to happen again?
I graduated university in Baltimore, where I was supposed to Baltimore. I've been associates and I've been productive here.
What's the mischief about? Is it family or something?
His sister lives in Section 8 housing. There was an issue between the sister and his family about where his wallet was. They got into an argument. He finds his wallet in the backyard. Then the police come because he was trying to ask the sister, where is the wallet? The sister says she leaves, then comes back, and there is damage into an iPad and a wall in the Section 8 house.
Where's he going to go?
He doesn't live there. He stays someplace else with his grandmother, I believe.
Yes, sir.
And he works a job.
Does grandmother want him to stay there?
Yeah, he's been on there since his probation. He's been on probation for 3 years without having any problems, getting ready to graduate from university.
Is that right? You've been on probation for 3 years, no problems?
2 years, yes, sir. No problem. Been in school, been working the whole time. No problem.
It says here in 22 that he went to an intermediate sanctioned facility, so he's had at least one ding. Now this is 2. In 22, you were ordered to
go to ISF.
ISF. So that's at least one ding. Now this is 2.
That was part of the probation program. When I signed for probation, they gave me ISF. And once I completed ISF, I came home and was on probation. It was all part of the program.
Okay? I'm not giving you another chance though. If I find that you start acting a fool in the free world, that's it. I'm not going to play this game with you again. You pick up another case, you start violating conditions, because I don't want you to talk to your sister. No talking to the sister, no going to the house, nothing. Is that?
Yes, sir. That's fine.
Nothing's.
Yes, sir.
I mean, you're so close, you know, I would venture to guess that if do you have everything done in the felony case?
Everything on your probation.
Is it done? What do you got left?
The pay fees, all that. They told me I'd be off in 2, so I'm just waiting for them to like let me off. I paid all my fees, been going to school, no dirty USO.
Do you have all the conditions fulfilled?
Yes, sir. All of them fulfilled.
So maybe they'll take you off.
Maybe they can early terminate you.
Yeah, that's what I've been hoping for all this time. That's what I've been hoping for.
All right, Lori.
Thank you,
No
Judge.
PR bond, no contact with his sister, no going to where she lives, no new cases, no dope, no alcohol. Which is, you're not supposed to be doing that anyways. I'm not giving you another one. All right, Mr. Roy. Good luck, bud. Okay. Okay.
This is Mr. Gracie, Your Honor. Is it GA or?
It's pronounced Gossett.
Okay.
So it should.
It's on the bond docket, right?
Yeah, it's on the bond docket.
All right, good morning, Mr. Grasse. Sir, you're charged with unlawful carrying of a weapon. The reason that we took you into custody now is because you have an open felony warrant. Give me one second. Hold on, let me see. I don't even know what it is. Okay, so you have an open fraudulent use or possession of identifying information less than 5 items. Right now, it's an open warrant and there's no bond that's set, so I can't let you go. If I let you go now, not only would I get in trouble, but both of them would get in trouble as well. When you have an open felony warrant, we're not allowed to let you go.
Monday was the court case for that, and I came to court with my attorney. They told me that it was going to be thrown out for no probable cause, and I was free to go. And they would send it to the grand jury, and the grand jury would issue a warrant for my arrest. And at that time, I would possibly go through another case and get indicted.
He's right.
I understand that, but it actually has it down as a failure to appear on the 7th, and it was verified as a good warrant. Yes.
My attorney was with me as well.
So I don't even have a listed attorney here. Who is it?
Judge Fleischer.
I don't know if I have her name.
So I want to say it's out of the 178th. Oh, 248.
Yes, sir.
The 178th.
And I believe it's other.
So I'll let you, when we take you back there, I'll let you, do you have her phone number? I'll let you make a phone call to her to see what can happen. But when there's a felony warrant, I can't let you go. I see that they found no probable cause, and I don't understand why the warrant is still active. I have no idea. You know, typically when like a judge finds no probable cause, a judge still has to sign a motion to dismiss, and that would end the case. Here, I see.
Order in the court.
The magistrate found no probable cause, but I don't see a dismissal, and that may be, I don't know. We'll let you reach out to Ms. Swisher, and then hopefully she can advise you of more. So we're going to do probable cause in this case. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
So record 24, officer observed a red Tesla Model S fail to stop for a stop sign at the intersection of the 5000 block of Holly Street and South Rice Avenue. Officer initiated a traffic stop and the vehicle quickly accelerated into the parking lot of Bel Air High School where the vehicle came to a park. The defendant exited the vehicle and began moving quickly toward the school. Officer tried to block the defendant's entry into the school to further conduct the traffic stop. The defendant was immediately uncooperative and repeatedly claimed he did not know what a traffic stop was. Officer asked for an ID multiple times, but the defendant kept saying he forgot his ID. The defendant stated he did not have a Texas driver's license, but had one from North Carolina. The defendant was placed into custody for traffic violations. The defendant's wallet was removed from his pocket and checked for an ID. Defendant's North Carolina ID was located in the wallet along with a social security card bearing his name and a second social security card with the same name name, but with a different SSN. During an inventory of the vehicle, officer located in the center console a Glock 9mm semi-automatic pistol, which was reported stolen out of North Carolina. On the floorboard behind the driver's seat, officer located approximately 0.5 grams of marijuana. Later in the investigation, it was determined the defendant also does have a Texas driver's license.
Is it possible? Licenses for multiple states?
Not supposed to. You're supposed to surrender your out-of-state license when you get a Texas one.
You can have multiple licenses.
It's after 90 days of residing in the current state, you have to dump the other license.
Correct. I thought it was 2 weeks.
No, it's 90 days.
90 days.
Did they change it?
Yeah, they must have, because when I moved here, the same thing happened. I saw a letter that told me I have 90 days to surrender. Yeah.
This is Mr. Grasset.
Is he on the docket, Judge?
Yeah.
Yes.
GRAI. What's weird is that it looks like the 248 found no probable cause, but there's still an open felony warrant. That
Yeah, it looks like it was direct indicted 2 days ago, Judge.
I don't think I've ever seen it go that quick. Wow.
It looks like the prosecutor may have already had a grand jury day. They just said, I'll just add the case. Yeah.
That's
Pay
why.
attention to the judge, not the computer.
That's why.
Could you explain that to
Judge,
me?
did you need me to?
Yeah, please. I'll have your lawyer explain it to you, okay? Because I got a bunch of people waiting. But it's a good warrant. That's all I'm going to tell you. It's a good warrant. I am going to find probable cause in our case here, okay? I want you to understand, do you have a Texas driver license? Okay, you're not allowed to drive. I'm making that a condition of your bond. Unless you have a Texas driver license and liability insurance, you're not allowed to drive. I'm going to have you sign an affidavit promising me you're not going to drive. I assume that you're going to get out, right? You have made bond in our case. As soon as Ms. Swisher gets up there, I'm sure they'll get you a bond and you'll be able to bond out in felony case, but don't just start driving. If you want to drive, go get a license, get liability insurance, come back to me, show me, and then I'll take the restriction off. The only other condition I'm going to put on you at this time is don't have any weapons, okay? As long as you can abide by these conditions, you'll be fine with me. I'm going to appoint you a lawyer now. If Ms. Swisher at a later time decides to sign on to the case, great, but we'll give you a lawyer for now, and then you can also explain what's going on to that lawyer now.
Am I still able to explain to Ms. Fisher?
Yes, yeah, I mean, we'll take him back now and I'll give you time to make a phone call, absolutely. Do you have any questions?
May I ask, why are you finding probable cause?
The gun is stolen. That's what it is. Alleged.
And may I ask one more question?
Sure.
You all said that it was moved to grand jury 2 days ago. Is that the time that the warrant was issued, or was the warrant issued following the court?
So what happens typically is as soon as a grand jury indicts a case, that it simultaneously issues a warrant at that time as well. So what they do is they'll typically have around at least 9 to 12 independent people listen to the facts of the case and decide whether there's enough probable cause. Just because one judge finds no probable cause, they can still take it to a grand jury and have it indicted. That's what they've done. And they do it to me too. Like, I'll find no probable cause in a case. If they disagree with it, they take it to a grand jury and still have it indicted. So just because I found no probable cause, that's not the end. Okay. All right. Good luck, Mr. Grasset. And, well, can you file?
No weapons and what else?
No weapons and no driving.
Thanks.
John Paul.
Good morning, Judge. Good afternoon.
How are you?
I'm good, Judge.
Come on, Mr. Man.
Judge, on this one, yesterday I had zoomed in and got the court's permission for us to have this setting on Monday because
that's right. I remember.
I'm at the CLE and I'm about to run back in.
Oh, that's right. We had rolled this over to, hey, we had rolled this to Monday because he couldn't be here. Cedillo couldn't be here. That's why. On Mr. Mann. That's right. No, I remember that. No. I guess were you supposed to email Victoria?
I did, Judge, yesterday.
I went through my emails.
She didn't get one.
I have been having it in my emails, Judge. I apologize. I showed up this morning to try and reconfirm it, but,
Well, look, let's finish this real quick, because, and we'll get you out of here. All I have is, huh?
Okay.
Mr. Mann has bond violations, am I right?
Yes, Judge, but given the nature of the bond violation, I very much wanted to be there to speak to him and speak to the court.
He tested positive for methamphetamine, John.
Yes, Judge, that's why I would like to be there to address it.
Yeah, well, I guess I'm not letting him go. He tested positive for meth. His case is 1,300 days old. Am I right?
Yes, Judge, I believe so.
No, I'm sorry. As much as I love you, John, he's testing positive for meth. It's 1,341 days old. We give you multiple chances, and now you're testing positive for meth. And no,
Sir,
I'm sorry.
I can't even explain that to say that. I just came to court, my bills bond told me I had to come, and I didn't want to play with you at all.
Look, I don't want you to say anything without your lawyer being present. I can have him reach out to you in the back if we can always roll it to Monday too, and we can talk about it then. But when do we say when, Mr. Mann?
So, yes, I hear you, sir. I understand everything. I'm not trying to, sir. I understand. I don't have an explanation for you.
John,
can we keep him on for Monday, Judge?
Absolutely, of course.
I understand the revocation, Your Honor, but if I can address it Monday.
Absolutely. We'll talk Monday then.
Thank you, Judge. I appreciate it.
Okay, bud. All right. Thank you for coming.
Yes, sir. Thank you.
All right. Yeah.
Hey, Judge, I'm so sorry. I just saw this appointment on Lorenzo Grace.
Gracie.
Still out of public for Monday. Please sit down.
Oh, they sent him down because it's late.
I'm sorry. I just
It's
saw
okay.
it.
It's okay. Don't worry about it. He's going to auto-populate on Monday. So what happened with Mr. Gracie is,
Judge, we do still have him. Sorry.
okay. So he's on bond. So basically, the state's already gone as well, Shrey. So, I can't really talk.
Yeah, that's okay. I tried to call the holdover, but it oddly enough goes to some PD's number.
Oh, great. You're still here. Okay.
Oh, yes.
Okay, good. Sorry. Just give me 2 minutes, please. So Shreya just got here for Mr. Gracie. So essentially what happened is gets pulled over. I think it was marijuana smoke, or doesn't have a front license plate, weed car smell. So they go through the stuff, they find a stolen gun. He also, in his wallet, has multiple licenses. So they end up charging him with a felony fraud. For some reason, the magistrate found no PC on the felony case.
Oh.
I don't know, right? But he found, or she, I don't know who it was, right? They find no PC. And then literally 2 days later, they take it to a grand jury to get indicted. And so.
I have a child.
Okay, hold on. So this is the lawyer that we
Well,
appointed.
it's the warrant. So I'm guessing that we're taking him in on the warrant.
We're taking him in on a felony warrant, correct? He's on bond in our
Yes, I see
unlawful
that.
point of the case. And so, with our case, I ordered him not to drive because he doesn't have a valid Texas driver license. I also ordered him not to have any possession of any weapons. I told him that we were going to take him in, and he has a lawyer up there, he said, of Cheryl Swisher, but I don't see that she's filed any documents in the felony court, so I don't know.
I don't see any attachment on the felony case either.
Did you reach out to her?
I just spoke with her. She's currently out of town. She won't be back in town until Monday.
Okay, so unfortunately, you're gonna have to sit till Monday. On Monday, she'll be able to go up there, try to talk to them to get you a bond or whatnot.
Would the magistrate give me a bond? You think at PC court?
I don't know. I don't know. I don't want to tell you when I just don't know. Because typically you go in front of a magistrate when you've not been in front of a judge before. So my inkling is no, that you'll have to wait till Monday. But, I mean, stranger things have happened in this life. We are going to give you a reset. The reset will have Shreya's number on it so that when you do get out, you can remain in contact with her. Like I said, don't take off on us. Because I'm not going to give you another PR bond. You take off or you violate conditions.
Can I just get a quick phone number for him?
I'm on a Zoom live stream, so it's not.
Oh, yes. Okay. So what I'm going to do is I'll check his bond paperwork and then I'll look it up and he'll have.
I'll tell you what, here, let's do this. Do you mind writing your phone number? Do you have a cell phone?
Yes, sir.
Okay, write it here and then I'm going to chat it to Shreya. Well, hold on. Hey,
The mic is, yeah.
Yeah, that's
Here,
good.
go ahead. If you can.
We just don't want the entire world to have your number. That's it. Of all 2 people that are probably.
Everyone mind this question.
Victoria, do you want to
Make
put
it
him
famous.
on for Tuesday
What
so
was
that
that? Young Guns? Remember Young Guns?
Yes.
Make you famous.
Felony can get him Monday that way?
Okay, sounds good.
Hold on, Shreya. Hold on.
Okay.
Okay, I've given her your phone number. She will get in contact with you between now and Monday. If not, then on Monday. And then we'll see you then. You'll probably hit felony court on Monday, so we'll probably see you on Tuesday, and then you'll be able to bond out after they get your bond set.
Okay. There's no any kind of circumstance I could speak with someone if I have a child.
I can make you make a phone call back there now. You know, I mean, you got a felony warrant. There's
Public safety and fairness guide every decision here in court.
not much that I can do. You know, I can't let you leave. I would get in trouble. And I already have enough trouble in my life and enough drama. I really don't. So, okay, Shreya, anything else?
No, that's it, Judge, and I'll follow up with Cheryl Swisher today.
Okay, guys. All right, take care, Mr. Gracie.
Thank you so much.
See you soon.
Thanks, Judge.
Thanks. One more, I'm going to put you in jail.
On June 29th,
Mr. Pan was thought to drive on a suspended license, but he was parked.
2024, officer responded to a disturbance call in Harris County, Texas. Arrival, the officer met with a defendant who stated that she was assaulted by her cousin at her residence. The cousin was later identified by her Texas driver's license, or by his Texas driver's license, as Dylan Proctor White. The complainant stated that she was using the restroom when the defendant came into the residence and began banging on the restroom door. The complainant stated that she got up and opened the door and the defendant was angry at her. The complainant stated that the defendant got in her face and told her that their grandma needed to use the restroom. The complainant stated that she didn't know, and the defendant got more upset and began punching the complainant several times. The complainant stated that she put her arms up to block the punch from hitting her face, and she told the defendant that she was going to call the police, to which the defendant grabbed her phone and prevented her from calling the police. The complainant stated that their grandpa came in and broke up the disturbance. The complainant stated the defendant left the scene with the grandpa and the grandma. The complainant stated that she felt pain and discomfort during and after the assault. The complainant also had redness on her right arm.
Okay. Now, can you tell me what kind of criminal history Mr. Proctor White has? Is he on probation or parole?
So I see, it looks like a burglary of a motor vehicle from 2017, an unlawful carry of a weapon in 2017, criminal activity in 2017, and also
Mr. Proctor, I'm going to find that there's probable cause to go forward on both cases. I'm now issuing a protective order. Why are you looking over there? There's no reason for you to look over there. You look at me. Do you understand?
I understand. I'm just waiting on you to tell me it's my turn.
You start acting the fool while you're out there in the free world. I'm going to take the free world away from you, Mr. Parker. Mr. Proctor, do you understand me?
I hate that we met on these terms, John.
I'm sorry, what was that?
I said I hate that we met on these terms. You only have assumptions about me.
One more, I'm going to put you in jail. You understand? You will respect me, you will respect the court, and I don't need any superfluous argument out of you. I'm ordering you now as a condition of your bond not to consume illegal drugs, any kind of dope, any kind of alcohol, and I'm ordering you not to be in possession of weapons. I'm also ordering you as a condition of your bond not to have any contact with this complaining witness. Do you understand?
Yes, sir.
I will do everything in my power to protect every single person of Harris County. And if that means locking you up, I'll do it in a heartbeat. What do you do for a living?
I own a construction business.
How much money do you make a month?
I was making up to probably about $3,000 to $4,000 a month. But now, since these false allegations have been brought up against me, now I have been displaced from my home. That's my home. And other things of that nature that go around those things, that go with my address, and all the people that with my business, my grandfather, other people that helped me with my business. Those people have been stripped away from me as it was supposed to be. If you look up on the call records and the police call records, you'll see that she called the police over 70 times since 2020.
Get there. I understand that there's always two sides to the story.
But I just wanted to let you know that and the probation that she brought up also, that was deferred. And I completed that.
There's always two sides to the story.
Sure.
I get it. And
sure.
I'm asking you these questions now to determine whether you can hire your own lawyer or not. That's why I'm asking you these questions. Are you still working?
No, I can't do anything because all the things that were structured around like I said, my family and my business have been stripped away because you and other people have told me that I can't be around my family. And I
say family. I said this complaining witness.
I'm sorry, but my paperwork, my pretrial paperwork, it says her or any relatives of this victim. That's what it says. So I want to be accurate and I don't want to go against any rules of the court.
I'm with you. Let's do this. I'll provide your lawyer today. The only thing I want to know is I want to make sure that this complaining witness is protected. That's all I want, and that's all. Stop. I want you to listen. That's all I want. So I will provide your lawyer today, and then I'm going to have the state reach out to the complaining witness and to see who all wants to have contact with you, and then whoever does, then we can modify the order to that liking. All I'm telling you now, don't smoke dope. Don't pick up any new cases. Otherwise, I will put you in jail. You got out of jail because we gave you a free bond. You will not get another one. You understand?
Yes, sir.
Okay. I need you to, well, I already have an application on file. So I'm going to have you sign a reset with Victoria. I'll have you take a seat and just hang tight. All right? Don't leave until you sign our bond conditions, though.
No problem.
Please.
Page 17.
I know.
Come on up.
It's a cousin, but you charged it as a garden variety assault.
I saw that.
And because I really would like to do a MOP in this case. But no family member allegation. What do you think about that?
Well, so on the law language that we visited, any offense involving family violence, and we looked at the family violence definition, which could be assault. So it's valid, but it's not, the cleanest, but it's valid. It's a valid law if you issue it.
See, sir.
Okay, can you file it for me, please? You mind? Good morning, ma'am. Ma'am, you're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On August 27, 2024, officers were dispatched to a criminal mischief in progress at an apartment complex in Harris County, Texas. While en route to the location, the caller had admitted to breaking the window. Officer arrived on the scene and made contact with Complainant on the scene stated that he and the defendant had been in a previous dating relationship for 1 year. Complainant stated that he had texted the defendant for her to bring his daughter because he had not seen her in 2 weeks. The complainant stated that the defendant had arrived in his apartment and gave him his daughter. The complainant stated that the defendant showed him a photo of hydrocodone and that she appeared to be under the influence of something like that. The complainant stated that when the defendant went back outside of his apartment unit, he closed and locked the door. The complainant stated that the defendant used a screwdriver to try and break open the lock to his apartment front door. The complainant stated the defendant then broke his apartment window next to his front door. The defendant also crawled through the window and entered his apartment without his permission. The complainant states that he told the defendant several times to leave his apartment and she refused. The complainant stated his window was valued at $100. The complainant had cell phone video footage of the defendant breaking the window and entering. Black pliers with a blue handle were recovered at the scene. In the cell phone video, the pliers were seen in the defendant's hand when she broke the window and entered the apartment.
Very lucky you're not charged with a felony burglary of a habitation. Let me tell you. I'm going to find that there's criminal mischief, that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will put you in jail. You will not get any more PR bonds. Do you understand? And I'm now entering what's called a magistrate's order of emergency protection that identifies Joe Warren Curtis as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, because it's a stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot go within 200 feet of where he lives or where he works. Do you understand? Yes. If you violate this, the state will file additional charges against you, and then you're looking at a lot more time. Yes. I see that you have a lawyer. I will waive your appearance, but it's your responsibility to stay in touch with Mr. Coyne. You do have a lawyer, correct?
Yeah, Jimmy said it because he has a lot of stuff going right now.
Okay, just stay in touch with him and he will tell you when you have to come back to court. If he tells me that you're AWOL and you're not responding to phone calls, text messages, I will issue a warrant.
I have my newborn baby there. I have the messages to prove that he told me to go over there so we communicate.
Stop. Just talk to Mr. Coyne. He will help you out. He'll navigate this for you. I've got a bunch of DAs here. Everything you say, they're just going to use it against you. So now is not the best time, okay? All I'm asking you to do is don't pick up any new cases and just stay away from this person.
I need my daughter. How would you feel as a newborn daughter? Somebody that does those pills, and I have pictures, and I have a private investigator.
Go to the family court. Don't take matters into your own hands, because you're the one that's going to end up in jail. But if you go to family court, you present that evidence, you'll get the baby. The right way to do it is to go to the family court. All the money you're going to spend doing here, all this money that you're going to spend hiring Mr. Coyne and doing all this, that, if you would have hired yourself a family lawyer, would have gotten custody, and then when they start to mess with you, that judge will hold them in contempt or put them in jail or whatnot. Okay, you're not. Did you hear anything that I just said? I know that you're trying to tell me something. The wheels are turning, but yes. Are you listening?
I'm listening, but you're telling me I can't go around there. My newborn is there. That's been with me since day one.
This person. If you want to get your baby, do it the right way, but don't have contact with this person. That's it.
He has contact with me. It's my phone.
Don't answer the phone. Don't answer text. I will put you in jail. I hope you listen. Talk to Mr. Coyne. He can help you navigate this thing. But what you need to do is you need to get your custody, a custody order, or if he's got custody, get a visitation. Every mother, every father should have access to their own child, no matter what. I don't care. Doesn't matter. You should have access, but you have to do it the right way. And that's getting either a visitation order or a custody order through the family courts. Ready? Okay, Mr. Stewart, come on up.
Again.
All right, so I got a bond violation report that says here, you entered the exclusion zone on 7/8 at 9:08 a.m. You left at 9:13, entered again at 3:57 a.m. There was a curfew in this case, was there not?
Yes, and if you would, Judge, if you're anything like me, you have a tank of goodwill that can run empty. And you've given us more than we deserve in this case. Hurricane Beryl, this was the height of when Hurricane Beryl was coming through the neighborhood.
Who in their right mind is supposed to be out in a hurricane at 4 a.m?
His power had gone out. He learned that his sister had a generator. And so that's where he was, that's the address. It's his sister's home where there was a generator that could provide some cool air. And that's what was happening in this case. But there's no excuse. He understands what his bond conditions was.
Let me ask you this, was he allowed to be at the house that he went to?
Not according to his bond.
I had nowhere to go. It's hot.
So what? Everybody else in Houston still doesn't have power. 1 million people still don't have power. Still, to this very moment. And they're dealing with it.
Did you contact pretrial services to let them know where you were going?
Yes.
When did you do that?
Yesterday.
Okay, but you didn't do it
Days
before you went.
I called them. They wasn't answering the phone. I got pictures.
I don't care about calling Jesus. It don't matter who you're calling and what's your excuse. You have bond conditions. This is not the first time. This is not the second time. This is not the third time that you've had bond violations. How many is this?
This is the sixth time I've been here in the past 45 days.
Am I supposed to let you go after 6 times? Mr. Stewart.
To be fair, the first time was my first appearance, so that was just a regular court date.
You know, we all have to deal with very stressful situations. We are all under, we all deal with the stress, and really 1 million people still, or I gotta imagine it's hopefully less now, but
you don't have lights.
So many other people don't.
Sure.
But that doesn't give you the right to go where you're not supposed to go. And not only have I ordered you not to be out in the middle of the night, but the police and everybody else told you, stay at home. Don't go out in a hurricane. And yet, you go out. It's not goodwill. You know, I mean, Mr. Mercer, now it becomes enabling. And that's what it does. And it tells him that if I let him go, it's okay. It's not. He still thinks he can do whatever he wants to do.
I'm tired of coming in here and making excuses. What I've had to do is to remind myself.
Look, if you want to withdraw from that case, you can withdraw, and I'll appoint him a lawyer today. I'm not letting you go. It's not fair.
Go, Judge. I got asthma, allergies. I'm literally sweating bad. I couldn't even breathe in the house, Judge. I could not.
Stay.
No, I couldn't never. I can't go nowhere else. I'm steady. I'm looking for a job. I can't find a job. It's hard. Everything is hard for me. Like literally everything is hard, Your Honor. Like
I didn't have power either. I don't have air conditioning. I have a fish that I'm trying to save by sitting there bubbling water myself, trying to keep this fish alive.
I don't have.
So we all have things that we deal with.
No, nothing. You wanna like I can't even charge. I barely can charge my ankle monitor. We have no power. Like literally no power.
Go somewhere else. You don't go to the house that you're forbidden.
I don't have literally I don't have nowhere else to go. I don't have family out here. I only have one person out here, one other person out here, other than my mom. Literally.
Judge, I'm not sure why the address was an exclusion zone. There's no victim in the case. It was an unlawful carry case. I don't know. If I would have caught that, I would have asked the judge to amend that order because it's his mother's and sister's house, and there was no reason to have that on the bond conditions. I don't understand why that was.
Tell me about it, because I don't remember. It's now been so many cases and so much that I don't even remember anymore.
On the first page,
I don't know, which case are we, because there's.
the weather case, so
Okay.
it's March 12, 2024, officers were conducting a fugitive investigation for a wanted fugitive when they observed the defendant standing in front of an apartment in Harris County, Texas with an AR pistol on his waistband. Rifle magazine was visible on the right side of his waist. Officers approached the defendant and instructed the defendant to come to them for their investigation. The defendant then turned and ran away 20 feet from outside to inside of his apartment and ran upstairs with the firearms on his possession. Officers then surrounded the apartment and gave commands for the defendant to come outside, which he eventually complied with. Officers then obtained consent from the homeowner to search the apartment and located an upper receiver inside a dresser, the rifle magazine inside the dresser, and a lower receiver of the rifle in another dresser near the window. The upper receiver had a live .300 blackout round ejecting out of it.
That's the first case.
That's the first transaction. He picked up evading and unlawful carrying in a public place. The other two were evadings.
So
that's where the exclusion zone came from. I feel like I dropped the ball on that because I would have asked the court to amend that. It's his mother's and sister's home, and I didn't feel like that was necessary for him to have it.
Why did we do that in the first place, the exclusion over there? Do you know?
Judge, I don't believe it's something we requested because we didn't really rip anybody since there wasn't a victim in the case.
But your mother and your sister stayed there?
Yes, my sister stayed over there.
What address is that one?
12650 Ashford Meadow Drive, Unit A.
It says he shall not go to or within 500 feet of the 12600 Ashford Meadow Drive.
I don't want to make a presumption, Your Honor, but I do feel like if I had approached the DA and asked them to amend that, I don't think they would have been opposed. That's something that I should have done.
And I'm with you. And Mr. Mercer, I'm with you, but he's still out at 4 a.m. You're still going out at 4 a.m.
I was leaving the place I was at because me and my mom were panicking so much, and I had to go to went to my sister's house. You can ask my mom, you can call my sister, you can literally ask both of them. They'll tell you. Literally. I was hiding. I have asthma and allergies. I can't breathe. I cannot breathe.
So bring them over here. I want to talk to them then.
I can call them on the phone, over the phone.
They've been texting with me. They said, please have the judge call us. So,
and she's even been calling. I promise, she's even been calling here.
Bring them here. Let's talk to them Monday.
Okay.
Okay, Judge. Thank you.
Go to Monday.
In the interim, if it's their actual address, Judge, we will be unopposed to it.
I'm not going to do anything yet. I want to talk to them. Bring them here Monday. Let's roll it to Monday, and I want to talk to mom and sister.
Thank you, Your Honor.
Okay. Be back here Monday.
Yes, sir. Thank you so much.
I know Roger was upset like crazy, but I mean, just fraudulent identity after fraudulent identity after no.
He was just doing his job, but I did tell him, Roger, don't throw yourself at the mercy of the court.
I can't have sympathy, but really.
What's that over there on the wall? Nothing.
Oh.
The next day.
Hey.
Mr. Stewart, we were here Friday.
Is mom here?
He wanted to bring his mother and his sister.
Please. Yeah.
Are you able
Raymond? A human?
Enjoy the power back. It's up to you.
No, I'll never do
Everyone, keep it down, please. If you want to talk, go outside. Good morning. Thank you so much for coming. Are you mom? Okay, and you are a sister? Okay. How much do you know about Mr. Stewart? As far as all the cases that we have and how many charges he's picked up and of all the issues that we have, how much do you know?
We know about them, we don't know about it. What's really going on.
I am at wit's end with your son. I am up to here. We now have a total of 4 open cases. They're all the same. And the bond violations continue to happen over and over and over. And I have put him in jail at least, Mr. Mercer, at least 2 different occasions, right? 3? To try to get him to understand that we mean business. Someone keeps bonding him out, and he continues to do what he wants to do. This last time, I told him I don't want you to do certain things. I didn't want him out in the middle of the night. It's one of my main concerns. Nothing good happens at 2 a.m, at 4 a.m, at all. And in this last violation report, which I think numbers now 6, he's out at 4 a.m.
Came to my house, because he couldn't breathe.
He has asthma real bad.
And bronchitis.
And it's just, when it's hot.
They both came to my house because they couldn't breathe. And I had a mini, generator, and they blew out the air from the fan, and I have one.
And it can't wait another 2 hours until 7 a.m. until he can,
He couldn't breathe. And I had to give him the Buterol through the machine and the steroid pump.
He's been had this ever since he was a baby, and he cannot breathe.
He wake up sometime, I didn't sleep sometime and came.
The noise he makes will wake you up like that because he can't breathe.
How does it continue to pick up these cases, and how does it continue to violate these conditions being out though? And in at least one of the cases, he has an AR-15.
So,
I believe it's because he's been shot before.
Look, it needs to stop. If somehow you guys are telling him it's okay to be out at 4 a.m, it's not.
That was just the one time that he came when the lights went out. That was it.
But it's always one time. It's always this. It's always that. And it just continues to happen. And this is the 6th time. Who does he live with now?
Lights came back on Saturday evening, so he's back with Mr. Freeman. He stays.
Do you stay home all day? What do you do? Do you work?
Just like, I've been on disability ever since 15, 16. I have neuropathy in my hands.
Who else stays at the house?
Just me and him. And it affects my whole life.
Why, Mr. Mercer, why did we do the exclusion in the first place from the house? I don't remember.
It must have been just a standard boilerplate thing that I overlooked or that the state overlooked. I didn't sign on until later on. I subbed in for somebody else. It was just where the incident occurred. There was no victim in the case. There's no danger to anyone in particular. I think it's just where they found him with the weapon. So I don't know, honestly. I think at the last setting, the state indicated that they would not oppose taking that out.
Do you have any reason why we put the restriction on that particular address?
Judge, I think that was a court condition, if I remember correctly, and on the allegations itself, it looks like he kind of trapped himself into that house and caused this whole standoff, and then because of the facts of the case, he didn't want to be around there, and so he had more information. But if it's his house, like I said, I'm not opposed to him. You know.
What is your address, ma'am?
Well, I moved from over there to.
The address is actually her
address.
So that address is your address.
That's the address he came to, but it's not the address where it occurred at. What the address where it occurred at is like way down the way. I live in the front, so he came to the front.
She's a friend of the lady whose house he was at. Some friend
where it happened.
And he ran into her. She was a friend of the family.
He ran into the lady that was the friend of the family house.
I only have 3 things that I want. No weapons, no drugs, no alcohol. Actually, 4 things. Curfew, so he's not out in the middle of the night, and that he's a working man.
I've been trying to.
So that he doesn't have too much time on his hands. That's the only thing I'm requiring from him. And I'm going to say this now, that it doesn't matter to me if he lives with you, sister. My only concern is that he's not out in the middle of the night and doesn't have a weapon. Okay? I'm going to let him go with you guys, but I'm going to tell you now, if I have any future violations, I'm going to set each of his bonds at $50,000.
So is he allowed to come to my address?
I don't think it's an issue. My only thing is I don't want him out in the middle of the night. We will put a curfew of 9 p.m. to 6 a.m. If he's out past any of those times, I'm telling you, I'm going to make his bond really, really high.
He can come out until 6 a.m.
He has to have a full-time job.
I'm working on trying to get him.
Why are you working on it? He should be working on it.
Well, I'm sorry.
Well,
we both are. We all are trying to just help him.
Yeah,
He's 17, so it's like it's not so many jobs that
I understand.
can get him.
Look,
We just trying to help him.
I'm happy that you're helping him. Really, at the end of the day, if that's what it takes, then that's what it takes. But I just want you to understand that I'm at wit's end. I will not entertain any more excuses. I don't care what it is. I don't care where he's going. If you need to have a breathing machine in both houses, put one in there. Because, come up, Mr. Stewart. I'm going to take off the restriction that you can go to your sister's house. I mean, I don't care what house you're going to. Don't be out past curfew.
Yes, sir.
I don't care if you leave your charger at your sister's house and you have to go out at 9:05 to go get it somewhere else. The next time, and I'm going to make a notation clearly here of everything because I'm not going to forget anything. The next time, I don't care what your excuse is. I'm going to make your bond $250,000.
Yes, sir.
Do you understand me?
Yes, sir.
At some point, they're going to stop paying to get you out because they're wasting their money every single time, thousands of dollars to get you out for you to violate to go right back in.
Yes, sir.
Do you understand?
Yes, sir.
You're on notice now. If you are going to go to a particular house, have your overnight bag that has everything in it, your phone, your charger, your albuterol, the machine you might need, have everything because I will not entertain any excuses. Mr. Mercer, you're on notice now. I don't care what the excuse is. The next time he violates any condition, you know what's going to happen.
Yes, sir.
Okay?
We need to make
So
sure.
the only conditions that we have now, get a job full-time or be in school full-time.
Sir.
No weapons, no drugs, no alcohol,
Sir.
and no out past curfew.
Yes,
That's
sir.
it.
Do we need to, I'll talk to pretrial services about that.
Details matter in court headlines do not tell the whole story.
Tracy, so that we iron everything out. And then that's it.
Yes, sir.
Thank
you, Judge.
I appreciate you.
Okay.
It's an AFM in our court, but she has a felony.
So she's on bond for an assault of a family member.
Yes.
Even small changes in behavior can affect outcomes drastically.
On bond for a felony assault of a peace officer, and now you pick up a new case.
And what happened was she went to felony.
Oh, hold on. I don't even think we've done probable cause yet. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You now stand charged with possession of marijuana. You're facing up to 6 months in jail and or $2,000 fine.
Thank you, Your Honor. On March 19th, 2025, a law enforcement officer observed a white Chevrolet Silverado ahead of him on the block 600 block of Wilclin Parkway and ran the license plate through the NCIC TCIC. Registration was shown to be expired as June 2024. A traffic stop was initiated and the law enforcement officer made contact with the defendant, the driver. The law enforcement officer observed a strong odor of marijuana, and the defendant claimed at first she didn't have anything in the motor vehicle, then confessed she had marijuana and several pipes. The defendant was detained. Probable cause search of the motor vehicle was done, and the law enforcement officer located multiple marijuana pipes. Law enforcement officer located a small bag of a leafy green substance and a black bag in the back seat. It was identified as marijuana, and the bag was within arm's reach of the defendant. Total weight of the marijuana was 0.09 ounces.
Since she has a license.
Yes, Your Honor. It does show being
Eligible or
ineligible.
ineligible? You are not allowed to drive. You will now be signing an affidavit with me today promising that you're not going to drive. I don't give a rat's behind what your excuses are. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and or a $500 fine every time you drive. You are on bond for 2 cases. Your first bond violation report was filed in February for you not showing up for testing and not picked up a new case. I now revoke your bond on the assault case.
Judge, if I may.
Please.
She went to felony court. And she was also revoked there. She just spent probably 4 or 5 days there. Is that right? And she's out here, so.
The day that means was, I was in jail for a traffic ticket and a big call.
I don't know if you heard that, Judge, but the day that she missed court here the first time.
No, I never missed the
You missed it, that's right. She actually texted me and she got taken into custody because of a traffic ticket. I have all that. So she was actually on her way to the testing and got picked over, and therefore she couldn't continue to make it there. So she's already been punished for bond revocation on the felony court, which she spent 5 days in jail last week. When did you get out on that?
Saturday.
Saturdays. And so if we take her in, I know you have every right to, Judge. It seems to me like it's kind of like a double whammy for her, especially for the fact that for that first BVR, she did honestly try to make an attempt to get there. I have the phone records for that, Judge.
When someone tells me something and they repeatedly fail to recognize the conditions that we set forth, for me, it goes in one ear and it goes out the other ear. You telling me something when you get out the doors, you still do whatever the hell you want to do without regard to bond conditions in this court. I'm now revoking your bond. She goes with you. Well, hold on. I need to sign this affidavit so she's not going to drive. And then she goes with you. I'm sorry, John, but it's just one thing after the other.
Do you want to go ahead and
issue a new bond, or can I revisit you in about an hour to figure out what we want to do, Judge? Sure. You want to do it that way? Okay.
Keep it down, we got a plea?
What's it for?
You did, or we have to wait till the judge?
Hold on a second. You really want to do a probation with Mr. Proctor?
That's what he said, Judge.
You couldn't even stay out of trouble while you're on bond. Why do you actually think that you can make a probation?
Oh, he's not showing us.
Yeah, I've heard that before. How many times have I heard that before? How many bond violations have we had, Mr. Proctor? You know, you can lie to me, but you can't lie to yourself. You know, if you think you repeatedly fail to appear for court, you repeatedly fail to comply with bond conditions, how on earth do you think that you're going to be able to make probation where you have to do classes, you have to remain clean, you have to report once a month? You can't even report to court once a month. How are you going to do this for 12 months? History says otherwise, Mr. Proctor. Will we do a TRAS on you? Before I do anything, I don't know how to go forward with him. And I think that probably the best way to see is to have Mr. Proctor evaluated to see what conditions and what is the appropriate way to go forward, because I have no idea what's going on in your life. I have no idea what you have, and we don't want to see you fail, Mr. Proctor. We want you to leave better than you came. But just doing this right here, it's just throwing you out there to the wolves. I mean, if you really think that this is the appropriate way, you can even, while you're on bond, for a couple months, stay out. Before, I would like to have him evaluated. So what we do is we have clinicians available that can interview you, talk to about you, what's going on with your life, what has been happening with you, how everything has transpired and how we've gotten here to this point, and to see what's the best way that we go forward. Do we need a treatment plan? Do we need inpatient treatment? Is it sufficient to do out? I don't know. But I'm not ready to do this just yet. I think that we need to have your TRAS to see how we go forward. Let's see what they say. And then at that point, you want to court reporter regardless, right?
Oh, no, sir. No, sir. We will respectfully honor the request by the court.
It doesn't have to take long. I can expedite it so we can have everything done within the next couple days. We're not talking weeks. We're not talking, so we can have everything done quick. Because I don't want you to just sit there and languish. But I need to know how to go forward. And this, I don't think that this is the appropriate way. If they say after we have you evaluated, if they say and they give the blessing, then I'm all for it. I want to do what they advise because they know best. Every time I have someone TRAS'd and I deviate from it, we pay dearly. So that's why I trust them to give us the best advice as how to go forward. All right? Give me a couple days. Let me get the TRAS done. We can come back and then we'll go forward. Okay?
Thank you, Judge.
Thank you. I just want to make sure I had the recommendation. So we're going to wait from TRAS before we do the plea.
Right. Cool. Yeah, because I want to know what are the appropriate conditions that we put, because this right now, this is the type of probation that we usually do when people have, no violations or, they've been, but here we have multiple, 4 different violations from one thing or the other. So that's why.
Thanks.
Okay.
Yes, sir. Thank you.
Your Honor, I'm approaching on Mr. Portillo Sanchez.
Judge, was presumptively positive for alcohol, fentanyl, and cocaine.
Your Honor, he wants to take a plea for 180 days today, which he's got 22 days credit, so.
I don't know. I think the last time we had said a year, right?
Yeah.
We set it for trial, I think, on the 22nd-ish, and he wants to plead to 180. No, okay. Will you, is there anything the court would accept? No.
mean, I'm over and over and over. And I don't know if that's what it is that's causing everything in all these cases. But I have a sneaky suspicion that it could be due to all that. You now tested positive for cocaine, fentanyl, what else?
An alcohol, Judge.
Alcohol. You were on bond for 5 different violent cases. Goes with you. I'm sorry, Mr. Portillo. What I would like to do, because obviously now, we now know that there may be a more substantive issue that may be causing all this. So what I'd like to do is have him TRAS to see how we go forward. That I'm not gonna just continue to take these cases where we're basically pleading guilty, throwing him in there 30 days, gets out, and he picks up another felony. We have now 4 or 5 open felonies? No. I'm not gonna continue to perpetuate this revolving door of you picking up a case, getting out, picking up a case, getting out, picking up a case, and now you're testing positive. No. We will now get to the root of what the problem is and why you have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, now 15. It ends today. Goes with you? We'll have him TRAS. Let's see what it says, and then, you know, but I'm not just going to continue to do the same thing in hopes that when it gets out. So, send it for TRAS. We'll come back in a couple days, get the report, and let's see what they say on how it goes. But I'm not going to just continue to do the same thing and hope for a unicorn, because it's just not going to happen. You know?
You can come on the call. I would like to just.
It's up to you.
I would like, I mean, if. Right.
Let's figure out what's going on.
Sure. I just want to see what I mean, obviously as his attorney, I need to see what his options are and meet with him.
And I don't want you to do anything you are not kosher, or not happy with, you know? Before we do anything, you know, of course I want your blessing. And if he says no to what they say, then we just go try. And we'll go one after the other. Just be ready, please. Okay.
Should we, I guess, set him like for Friday or something and see, I don't know.
It's probably gonna be the processes today. I don't know if it's tomorrow.
No, there's no way. It's now 11:30. Till tomorrow, he's still gonna be processing. Right. So we can't start the TRAS until he's out. Latest will probably be Wednesday is when we get it done. I would say we probably will have the.
I'm just gonna wait on mine.
Well, but he'll be set for bail review automatically, right? For Wednesday or?
But if he stays in holdover, somebody can come over there.
We usually have people come here to do the TRAS here.
Right, okay.
Here, to try to expedite it so that they don't sit there for a week or 2 weeks, you know, because we want to, it's not the idea, it's just to hold, just for the sake of holding, is to get it done quick so you guys can make the informed decision quick. And we'll see, you know, and the idea is hopefully he's honest and then try to get to the cause because, you know, before there's a murder case because he's using and he does something that's irreparable, you know?
I understand.
I mean, how many times have we seen it? So, okay.
Thank you.
Hi.
Mr. Mayor Coach. Sorry, Judge, I'm terrible. I am in this death penalty capital, so I just don't.
Still?
Yes, Your Honor. We're 2 out of 3 weeks. I just have 4 minutes left on my bathroom break. Mr. Thomas tested, it looks like his marijuana levels are going down, but he did test positive for alcohol. I talked
to Mr. Thomas.
He's present, Judge.
Judges balance punishment, rehabilitation, and public safety.
Not only have I reinstated his bond once already, but now we're working a second bond violation for it. What do I need to do to get your attention, Mr. Thomas? Yeah, right. Justin?
Yes, Your Honor.
What do I need to do? Put his butt in jail?
I think we've been in felony court this morning, so I don't want you to think he wasn't here. He was great.
I care about him continuing to use and continuing to do whatever the hell he wants to do without regard to bond conditions. You do what you want to do. I think I have but one choice, Justin, to just put him in jail.
Judge, what do you think about some AA meetings or some?
I don't think it'll. When did we order him not to use?
What was the last name again, Judge?
This is Thomas, Mr. Thomas.
Conditions were set in place on October 11th.
This past October, we told him not to use.
The marijuana is negligible, so it's almost out of the system. It was at 0.005, I think. I understand the court's frustration and concern.
If it's been bond conditions since October, we're now nearly April 1st. It's been 6 months. So it should have been way, way gone.
No, it was from the positive. So you admonished him on the positive not to use, and then, so this was his first test since
February 6th.
Right, and so that's what I'm saying. So the marijuana is negligible. I know it's not an excuse, but I don't know that we read all of our bond conditions about alcohol. Now, I know that's not an excuse because he signed for it. I get it. But I do want to point out to the court that the marijuana is basically out of the system. It was like, that's why I'd asked for the levels, but it was like at a 0.05 or 0.005.
Alicia, do you see that?
The levels, Judge, let me see if it's in the email.
It was, I asked for them, Judge.
I know. I saw that you did. What do you do for a living? Where do you work?
Russo's Pizzeria. I'm a chef.
What is it?
Russo's Pizzeria. I'm a chef.
He's a chef at Russo's Pizzeria, and we're in school. So we are being productive members of society.
How do I know that? Am I supposed to take your word for it?
You can take his mom's, Judge. I talk to his mom pretty much on a regular basis.
Judge, now do you see that number? However, truthfully, I don't know what that means. But it is a low number. So that's all I have to offer for, but.
Here's what we're going to do, is I'm putting a scram monitor on his ankle, so I know that he's not consuming alcohol.
Yes, sir.
I'm now going to put a GPS monitor and I'm giving you a curfew, because I don't want you out in the middle of the night. I'm giving you a 10 p.m. curfew. If you ever have another bond violation, I'm going to revoke your bond and I'm going to make it so high. Do you understand?
Sir.
I'm sorry.
I will test you again in 2 weeks. If you test positive for marijuana after 2 weeks, then that tells me that you've continued to use, and I'm going to lock you up. Do you understand?
Sir.
Thank you, Judge. Maybe excuse to go back to very important cases.
So he's back in 2 weeks to test. If he tests positive after the 0.05 nanograms or whatever the hell it is, if he's still testing positive.
I have nothing left to say, Judge.
All right.
I will be speechless.
All right.
Your Honor, I am here on Mr. John C. Joseph, alleged BBR violation, Judge. Sitting over in the jury box. It's my understanding that he left his area curfew area on 9:07 p.m. on 5/20 came back at 9:31, approximately 24 minutes. I spoke with him. It's my understanding that he went over to his sister's house because he and his girlfriend had gotten into a heated discussion. He informed me.
Mr. Joseph.
He informed me that he left to stop proceeding to assault or possibly assault between the two.
I do everything in my power to try to prevent people from going back into custody. But some people just refuse to just, I don't know what I can do to get your attention. You now have 2 open cases, and now this is your second bond violation. What do I need to do to get your, what do I need to do to get your attention? Is it putting you back in jail, Mr. Joseph, and making your bond high?
Sir.
Your actions tell me different. This is what we're going to do. I'm sending him now for a drug and alcohol test. I want to know what, if anything, is in the system. You were to come back. If you fail the test, if you fail to take the test, if you fail to come back, it's not going to go well for you. Do you understand? I don't want you to say anything. I want you to go take.
I'm offended. I don't have time for it to get on my system.
You have been on bond, Mr. Joseph.
Okay, so yeah.
I think the last time he was in court, Judge, I think he made an admission that he had used drugs during that court appearance. And if that's the case, he may be correct in that it may still be in his system, Your Honor, because it hasn't been 30 days.
The first burglary motor vehicle has been open since June of 2024. Since that time, I have told you not to use.
Okay, I'll.
Take a seat from me. I don't know what we're gonna do. Take a seat.
Thank you, Judge.
You were here in June last year. You have a violation because you came in late then. But now we have another set of bond violation for you coming in late.
Was he,
Why would I continue to let you go? I let you go already once and you did it again.
instead of voting, we'll put it on Thursday.
Do you see what I mean? Because me, if I let you go, then I'm telling you it's okay for you to do what you're doing, when it's not.
Judge, if I may, I believe that he has a legitimate reason. I believe that if he had not gone, there was the possibility that an assault or some other harm could have happened to his girlfriend. From my conversation with Mr. Joseph, he informed me that he left, and it was just for only 24 minutes. He left in order for both of those parties to cool down before a fight or an act of violence escalated between those two parties. I personally think that that was the right thing to do.
Hold on a second. Who do you live with at home?
My girlfriend, but my sister stay right down the sidewalk in the same apartments.
You stay in a complex.
Yes, sir.
She doesn't live with you.
Huh?
She doesn't live with you.
No, not my sister.
So who is the fight with?
It's my understanding that it was his girlfriend.
Is it the family here?
My girlfriend here.
So the fight was with who?
It wasn't a fight, it was a words that was about to escalate into a fight, at which time he left for a cooling off period with his girlfriend. And she left, nothing serious could have happened. I believe that was, even though it was a violation of the bond condition, I believe that it could have been worse had he not left.
If you put your hands on anyone, I don't care who it is, if it's a woman, if it's a man, I'm gonna put my hands all over you. You understand?
Yes, sir.
Nothing in this life can justify you putting your hands on anyone. You have two.
I just left so the situation can cool down.
You have two open cases. At all times, you need to be thinking to yourself, if I do this, what's going to happen? If I say this, what's going to happen? If you're going to antagonize, meaning if you're going to say something that makes someone flip out on you, and the laws come over, and they see you, and they look you up, 9 times out of 10, they're going to go against you. You need to be thinking of these things at all times. You get into a fight with them, words, it's always going to end up bad for you. I understand and I appreciate de-escalating the situation, meaning you're leaving so that it doesn't end up in anything more. But it shouldn't be like that in the first place. Are you working?
No, I just did 3 job applications. I'm waiting on the interview to begin.
Judge, yes, sir, I know you are.
I don't care.
I do, Judge.
Why aren't you working?
I just recently started looking for jobs.
You have too much time on your hands. You need something to do in this life before it takes you down. When you have too much time on your hands, you become self-destructive. You need something to do in this life. It's time for you to start working, and I want to see that you get a job. Toria, can we help them out?
Yes, I'll give them some resources.
We're going to give you resources to try to help you get a job. There's no reason why you can't have a job within the next couple weeks if you try. When you put your heart and soul into it, you can achieve damn near anything. It's just how badly do you want it? That's what it amounts to. And when you do get a job, if you really do a bang-up job, and if you do well, and you don't do stuff half-assed, all you're going to do is you're going to go up, and you will make more money. The higher you go up in the job, the more money you're going to make. And then everybody's happy. When you get to buy nice things, that's what life's about. Not the janky, stupid-ass jobs where you're making $6 an hour. No. Work hard so you can make a lot of money. All right.
It's great.
I'm not going to ding you. I don't want any more issues. Do you understand, Mr. Joseph?
Yes, sir.
I'm bringing you back in 2 weeks, and I want to see that you have a job. 2 to 3 weeks. If I see that you haven't put any effort into it, it's not going to go well between us. I also don't want you to use any dope. Do you understand?
Yes, sir.
If I find that you're testing positive, likewise, it won't go well for you. All right, Mr. D.
Thank you, Your Honor.
Good.
Just approaching on a new fugitive case, it's Robert Mizell. And Judge, he would like to have a bond set. It's kind of an odd one, Judge. It's failure to possess the required license for home improvement or residential construction. And basically, Judge, he told me that he owned a construction company, but he's totally blindsided by this charge.
Good morning, Mr. Mizell.
Good morning.
Your lawyer's asking for me to set you a bond. You
Yes, sir.
now stand charged with, I guess you said, home improvement fraud.
Judge, essentially, that's what it sounds like the allegation is. It's a failure to possess the required license for home improvement.
I have your fraud.
This was in 2020, during the 3 hurricanes that hit Louisiana. And according to City Hall, and we went down to everybody, and they said we didn't need one because it was an emergency situation. Everything was flooded and devastated, and we were just trying to help out.
My only issue is that this is now a second fugitive case that you have.
The first one was a lady that we did work for.
Let's be careful.
Doesn't matter.
Oh, sorry.
Mr. Mizell, is that, we usually, as a matter of courtesy, I guess, so to speak, we'll give you a chance when you get one fugitive case. But we can't continue to do the same thing over and over and over.
Understood.
Do you know anything about this?
Yes, so first I'll state as opposed to a bond. This particular case is because he didn't have a license, but it originated out of the fact that the complaining witness, after a hurricane, had paid the defendant money to repair her house. He did not do so. The money amount was...
So he allegedly took money for fixing the house and didn't do the work.
Correct. And then when the officers went to go look him up, he didn't have a license under that name. So that's the basis for that charge. We are, of course, opposed to a bond given that he has had a prior fugitive case. He was granted a bond on that one, but he didn't actually show up. Looking back at our notes. The only reason...
So we gave him a bond, he bonded out and he didn't show up?
No, he appeared, yes, he appeared in court on that day when you guys provided him a bond. He appeared in our court here in Harris County.
Okay.
The only reason that case was dismissed is because I believe that the main jurisdiction in that case had recalled their warrant or something of that nature.
But so he didn't turn himself in?
No.
the lady that was charging us, I ended up paying her $21,000. And she dropped the case.
How? Am I supposed to, we can't just take everybody's word for what they
But
say.
first off, I did not know that even the warrant existed. So I had no idea. But I ended up paying the lady off. I gave her some money and said, okay, that's good, we're fine. Because I truly didn't think we did a very good job.
Okay.
But may I ask you this? This is an LLC. I have a business, or had a business partner at the time. We were 50-50 in the business. I just wonder why I'm the only one being charged here. I mean,
That's beyond what I would know anyways. The simple thing about it is that I gave you a bond last time. You bonded out.
Yeah.
You didn't show up. And now you have another fugitive case. We can't continue.
I bonded out and I paid the lady off and she dropped the charges.
That case was dismissed? Is that
Yeah,
correct?
the case was dismissed.
Not because he showed up like he was supposed to.
I see what you're saying,
He
Judge.
came to court on the day that he was due to go turn himself in Louisiana. I don't know, but I can't continue to do the same thing. The good news for you, Mr. Mazel, is that it's Louisiana. So we have buses coming from Louisiana probably 2 times a week. So from the time that you waive, within the next probably 2 to 3 days, you'll be back in Louisiana to be able to answer the charge. But I'm not going to just continue to give bonds on fugitive cases when you continue to pick them up. Because
Got it?
Okay. Has he waived or did he refuse?
To refuse extradition.
Okay, so you need to decide what you would like to do. If you want to waive extradition, I would say probably within the next, 3 days, Louisiana will be here to come get you. If you want to refuse, which is well within your right, the state can get a governor's warrant, but that'll take 90 days. And at that time, they can have you remanded
I can
back.
sit in jail for 90 days. No, I'm not interested in that.
So, but I'll let you talk to James to figure out what you guys want to do, and then you just let me know.
Okay.
Mr. D.
Yes, sir, Your Honor.
Nobody's here for like another.
Your Honor, I'm trying to find out where are we with Sean Sullivan?
Sorry.
Yes, okay, Judge. Sean Sullivan, Judge, is my understanding.
You got it, okay.
Yes, I have the case. I wanted to know, were you concerned with DVD? Did you want to get any DVD involvement?
Michelle?
Yes, is this the NBC one?
Yeah, this is the one that we were talking about.
We'll let it stand. They just want to see it. Dems, so they don't have anything else to add.
Okay.
So I had a concern because is it mutual combat? Because
It looks like from my understanding, Judge, looks like the complaining witness is the person who actually initiated the contact. She was alleged to have been lying on the couch or not dressed appropriate in the presence of 2 other male men that resided in the residence with them. And he tried to wake her up to let her know that she was dressed inappropriately. And out of slumber and sleep, she woke up angry and started hitting him, and that's when the altercation.
She pops him 3 times in the mouth initially.
Yes, Your Honor.
And then they fight.
And
But there's no assault from him at that time, right? I guess they separate, they part ways. An argument ensues later. Does she go at him and that's when he hits her?
That's not what we
So
have.
tell me that one part. What happens then?
Yes, Your Honor. So it seems as though the complaining witness, she crawled into bed and was laying on the corner of the bed when, after about 10 minutes go by, then the defendant comes back and begins to argue with her, crawls onto the bed, grabs her, flips her backwards on the mattress, and uses body weight to lay on top of her while placing both of his hands on her upper arms to hold her down.
So there's no...
And there is a subsequent punch where the defendant uses his right hand and punches the complaining witness in her mouth, causing pain and visible injury.
It's my understanding, Your Honor, that this incident occurred on a date certain, at which time the complaining witness told the police officer that she did not want to press charges and he did not want to press charges.
Right, but
And they came back the next day.
Why is it that they didn't file assault charges on her on the first? I mean, are we going here just because she's a woman? She gets a slide for getting to hit him? You know?
Was there, Judge? I don't know why this is.
I know there was no arrest on the initial date the incident is supposed to have occurred. The arrest occurred the following day. The first date, the officers did not arrest either party, but some type of disturbance occurred the next day. Officers were called, they came in and they looked at the report and they arrested the defendant.
My guess is, when I can limited knowledge of intake, they probably put a call in the intake. They said, yeah, it's just my guess. Refer out, do follow up, and then they went back out there next day, saw the referral on file, and they decided again.
So he goes up to her and he sits on her. Is that what you're saying? What happens? He turns her over.
More so, she's on her, from what I understand from the desk, she's on her stomach. He turns her over to where she's on her back, and then he is on top of her and holds her.
He's straddling her like this.
Yes, Your Honor. And then subsequently after that, they were still arguing and he punched the complaining witness in the mouth.
I don't see where that's, if she was the initiator of the confrontation between the two parties, it's my understanding it's my understanding, from the complaint, from the defendant's perspective, it was not a hit with a fist, it was a push that caused various injuries to her mouth, but he did not take his fist and punch her.
But that's, of course, but he's saying to you, right?
Right.
And then you're saying that there was a hit to the mouth.
And she didn't press charges. She requested that no charges be filed. Somebody get punched in the mouth. If that were the case, you would think that someone in their right mind would say, yeah, arrest that person. However, if that person realizes that he or she is possibly responsible for the incident, then that would probably lead them to say, okay, I started this mess, it shouldn't have started. I don't want to press charges.
10 minutes pass, right?
Allegedly.
And I don't know why they didn't. Come up, Mr. Sullivan. Let's do this. Let's set it for a formal probable cause hearing. Okay. I'd like to do some additional research as well before I find probable cause in this case. So what I'll do is I'll put this case on for Wednesday for a formal probable cause hearing. In the interim, Mr. Sullivan, I'm ordering you not to have any contact with this person whatsoever. You understand?
Yes, sir.
I don't care what's going on in your life.
I got you.
For the moment, I'm gonna, I don't want you to have any contact. I don't want you to go where this person lives, where this person works. If I find that you do, I will revoke your bond and put you in jail.
Yes, sir.
We'll come back in 2 days. I would like to do some further research on it because, I really like to look at every case, do a deep dive to ensure that there's probable cause before we go forward. So, I don't blindly find PC for anyone. I'd like to do things in the fair way, but at the same time, I want to ensure that my county and every person in it is protected. So don't have any contact with this person. We're going to create bond conditions to this effect. They're probably going to reach out to her between now and Wednesday, and if they find that you're trying to communicate with her, it's not going to go well. Do you understand?
Yes, sir.
Do you mind filing no contact in the weapons, please?
Yeah, sure. No context, I'm sorry.
No weapons.
No weapons, yeah, sure. Thank you.
One of the things that they teach us is, never make rash decisions because it may be the wrong decision. And that's why I'd rather take a little bit of time before we do something to ensure that what we're doing is the right thing to do. So we'll put it on for Wednesday, come back Wednesday, and then we'll have a decision for you.
Thank you, Your Honor. Appreciate it.
I've given you a lawyer, so just stay in touch with Mr. D, and then we'll come back, and then we'll finalize it for you.
Thank you so much.
Don't leave until you sign our bond conditions, okay?
Thank you. Thank you, Judge.
We appreciate that to the message files, they know what's going on.
Yeah, great. Maybe they can be here Wednesday to add anything further, and then we can. Okay.
Judge, I am here on our friend. I feel like almost like he's family. Daniel Frazier.
Okay.
He was charged with another escape.
Oh, we got him back.
Yes, sir. Yes, sir. I was surprised to see him pull up on my docket as well, but not really.
Will you stay on it?
Yeah, I'm on, Judge. We have a decent relationship. even though we believe we know how this is going to go, at least from you, because right now the bond is set at $50,006, and $50,000 in the felony court. He wants me to ask you for a time served. I believe I already know what the answer is going to be. And in the event that you deny my request for a time served, he said he's willing to go back into treatment and he's willing to complete treatment this time. Now, I don't know how that's going to affect him upstairs because
Ours, until the upstairs is taken care of, because they won't take him with an open felony.
Understood.
Kind of
Understood.
standstill until.
And the big problem is I'm not representing him upstairs, but his court date is like May the whenever. It's like really far down the line. Yeah, so.
Get you going. Do you mind bringing up Mr. Fleischer, please? Okay. Thanks. How are you?
I'm good.
You're back.
Yes, sir.
Good to see you. How are things?
Good.
Good. What's good to see you?
Work good.
Say it again?
I said they were good.
You know, you can run, but the long arm gonna get you every single time. You can only go so far. Sorry, no time, sir. You know how it goes. I told you, every time we come back, we're gonna do it until it takes. And, you
So
know,
my only option, in all honesty, my only option for this, for the misdemeanors treatment is no other option. No matter what. No matter if I got treatment on my own.
really? Really?
I mean, I've done it already. I've done it once. I've got behavioral treatment and I've also got mental health. Behavioral and also substance abuse treatment. I've done both already.
I want to use ours. The problem is that I cannot do anything until the case upstairs is taken care of. So we're kind of in a holding pattern until upstairs. Hopefully, they will see that that's what we want to do here and they'll, you know, but I don't know. I can't. You're not representing upstairs, right?
No, sir.
So, we got to wait to see what happens upstairs. And then we'll just, told you, we're just going to keep doing it until it takes. Hopefully one day it does.
I really don't. I don't have a substance abuse problem. I really don't. And honest to God, I don't. Like I've stopped a long time ago. And honest to God, I've stopped, and I'm not trying to go that path. Honest to God, I don't have a substance abuse problem issue. I've stopped.
So, I guess let's set it for 30, Mr. Brooker. We'll wait. Because if they take care of it beforehand, you know, we'll see. And then if it's still set for the May 17th, we'll set it for the day after at that point. And then we'll see, hopefully, you know, reach out to the lawyer upstairs, let them know this is what we want to do here. Hopefully they'll see that that's what we're trying to do. And then, you know.
So basically, I'm waiting for the felony, so what happens.
Hopefully they will see what we're trying to achieve and be on the same page as us. You know, this is the second time you're facing this charge upstairs. They may offer you 4 years, 5 years upstairs. You know, it's no joke. You know, I'm trying to help you, Mr. Fleischer, believe it or not. You know, really. You're facing a lot of time and it's not the first time. So if you try to, you know, we played this game the first time. I don't know if they're going to.
Yes, sir. It's a different court, Judge, so I'm hoping that we can have a similar outcome. And if they do it beforehand, I'll come off document.
I want to do it, and hopefully if they see that you're really willing to. So, all right.
Yes, sir.
I just want to say hello. That's it.
Yes, sir. All right, thank you.
We'll see you in 30.
Judge, I'm approaching on a plea for Mr. Lacero Tremendia.
I'm ready when you are.
All right, I'll call him up, Judge.
You were charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're off you 9 days in jail. Days that you have done. You need to understand,
necesita que entender
guys, going on
este
your
delito
record.
va a estar en su
You'll be there for the rest of your
ahí
life.
por toda su
You
vida.
get into a car,
Si usted se
you
sube a un
drive,
automóvil y maneja
after having
después de
consumed
haber
half of
consumido
a beer,
medio
you get pulled
de
over, an
cerveza y te
officer
para
sees a
un
property to be behind,
oficial
they smell
de un
anything in your
antecedente y
car
huele
that,
algo en tu vehículo, pues no le va a ir muy bien.
you understand.
¿Usted lo entiende?
Sí, señor.
Yes, sir.
You have another
Si tienes
DWI,
otro
and you
delito
do
de
anything more than
conducir
6 hours in jail,
6 horas en la
you
cárcel,
will probably get an immigration
va a
detainer if
tener
you're
una
not in this
detención de
country with
migración si
permission.
no estás aquí con permiso.
Consider these things
Necesitas
when you're out there in the
considerar
free world.
cuando estás ahí afuera
You
libre
understand?
en el mundo. ¿Usted lo entiende?
From now on, it is a
A partir de
minimum
hoy es lo
90
mínimo
days
de
in jail
90
for
días
any
de
new
cárcel.
cases that you pick up. No more proverbial slaps on the wrist. You're giving up the right to a trial,
Tiene derecho
right to compel witnesses to testify on your behalf, confront and cross-examine your accused.
testigos a sus
If you're not a citizen or possible immigration consequences, you can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will go on your record forever and a day. You understand?
¿Entiende?
This is what you want to do.
¿Esto es lo que usted desea hacer? Yes, sir.
How do you plead to the offense?
¿Puede
Guilty or not?
culpable o no culpable? Guilty.
I'm going to find
Voy a hallar que eres culpable, suspender su licencia por 90 días.
Do not drive
No maneje.
until you get a license and insurance in your name. Otherwise, you will be back here and it's not going to go well for you.
Para ir muy bien.
Good luck.
Judge, the only thing is, I'm appointed on this case. I wanted to see if you'd consider waiving the supermax fine for him.
What do you do for a living, Mr.
¿En qué
Chimendi?
trabaja usted?
Ahorita no estoy trabajando.
Right now, I'm not working.
The lawyer is
Su
asking
abogado
for
está
me to
pidiendo que
waive
yo
$4,500 to around $5,000
hasta $5,000
that would otherwise apply to you.
que serían
It
aplicables
is a first
a usted
DWI,
como es la
so I will.
primera
But if you
no
come
se
back
puede
with
cobrar. Si regresas con otro delito de conducción,
$6,000 surcharge,
son
the
$6,000
second
de llevar
DWIs,
de
and if you don't pay it, you do 1 day in jail for every $100 you owe.
Si no le pagas
So you will find that you
$100
spend
cada día.
months in jail and you pick up another one, potentially. Do you understand? I'm not
Yes, sir.
asking for much. I want my streets safe. And if you're not going to comply, then I have a place for you. Good luck.
Thank you, Judge. Appreciate it.
Good morning, sir. Sir, you are in February charged with terroristic threat of a family or household member. It's come to my attention that you have now picked up a violation of a bond condition or a protective order. I have no idea what happened, but I want to find out. You have the right to remain silent. Anything you say can and will be used against you. I want you to know that you're not here alone. I have a lawyer for you here. He's right there, so you know that you're not here alone, okay? Okay, so what happened in the DPO, please?
Well,
Not you. That. You have the right to remain silent. Exercise that.
On March 29, 2025, law enforcement officers were on patrol when they observed a white Honda Accord driving south on a public city street located in Harris County. The law enforcement officer ran the vehicle's license plate through NTIC and observed that the vehicle's registration had been expired since June 2023. Law enforcement officers initiated a traffic stop and activated their emergency equipment and followed the defendant's vehicle that drove into a gas station parking lot and pulled over to stop. The law enforcement officer approached the defendant's vehicle and observed the passenger sitting in the front seat wearing a seatbelt. The defendant requested the full name and date of birth of the passenger, who identified herself as Stephanie Avalar, and that was confirmed by the law enforcement officers. The law enforcement officer also found that that her name came back as a protected person from a domestic violence incident, and ran the identifying information of the driver, also known as the defendant, that came back under the same protective order as the defendant for that case as well. The law enforcement officers reapproached the vehicle and detained the defendant, and confirmed that one of the bond conditions and protective order was, the defendant shall have no contact with the,
So it was just the Blackbird Shield deed. So we had issued the no contact, right?
Yes, Judge.
All right, so Mr. Avilar, I'm going to find if there's sufficient probable cause to go forward. You have to understand that when we have court orders, we mean it. It's not hard. You have a lawyer. When you want something changed, you talk to the lawyer. The lawyer can come to us and we hear things out and we can change things. But when you try to do stuff on your own, everything goes sideways, and it goes sideways quick, as you now know. So,
In Your Honor, we will be, we'd like to approach off docket tomorrow to try to have the MOAP amended. The state did in fact try to call the CW, but they have not been able to speak with her to clarify that she would in fact like him to be able to come home and have contact and the like.
So what happened?
Terrorism threat, he appeared in PC court on February 13th. He received a PR bond, and next week he came in here for arraignment. He appeared, he got a reset for April 23rd.
Right, but I'm showing now he's bond active after the new case. Why? Did they give him another PR bond?
No, this case was never.
Look, it shows bond made on the terroristic threat.
That's from the previous PR bond. He was never revoked after since the new case. This case has still been on bond.
Did they not address it? And I'm at a loss if they never addressed it.
Yes. His new court, his only reset is for April 23rd.
Mr. Woodward, my concern is that, they gave them a PR bond on the terroristic threat. I don't even show that a PR bond was given. Oh, here we go. On 213, now he's picked up a violation of protective order. So I can't continue to give you a PR bond when you're picking up new cases, man.
That's not speaking. Can I ask? It's because I made bond.
No.
Sorry.
You need to talk to your lawyer before you talk to me, because I don't want you to say something that hurts your case, Sir. I'll give you time to talk to him, but I can't, we do things a certain way. You can't do stuff on your own. You've been through the system long enough to know that,
Yes, sir.
Are you on parole at this time?
Oh, sir, I'm not on parole, but I paid for my bond.
Hold on. So no PR bond on the terroristic threat. Okay, let's do this. Your lawyer said he can be here tomorrow. So we'll have him come here tomorrow so he can talk to you and you guys can regroup, try to figure something out. So Mr. Woodward, you say you can be here tomorrow?
Absolutely.
You want to address it, I guess, then?
Yes.
Okay, so we'll roll you to tomorrow. We'll try to figure something out.
Judge, he's supposed to get released today because of the surety bond on the VPO.
Right, I'm not giving him another PR bond when he picked up a VPO though.
Do you want me to revoke
the PR bond? Yeah.
No,
Your Honor.
Yeah.
I certainly understand how you work, but since I'm not there with my client, I just like for him to experience that. The facts of the underlying case, Your Honor, are that he and the CW they're in a relationship. They had an argument. She grabbed his hair first, was pulling him. Then he was grabbing her. But a text message was sent from an unknown number saying, "If you don't come home, I'm gonna fuck you up." Excuse my English, Your Honor, but that's what was the crux of the PC, Your Honor.
Of which one?
For the terroristic threat case.
I don't know. I guess what happened in the terroristic threat?
Yes, Your Honor. Wait just a moment.
My understanding is that the CW is willing to communicate, that there was a little bit of a misunderstanding of the facts. I believe the state called her once. She said she wasn't available, but she would be if they called back. I don't think that she's been able to communicate that there was a little bit of a misunderstanding of the facts.
Your Honor, what I have is that this was from the threat was made during an altercation where the defendant told the complaining witness, and I quote here, I apologize for the language.
Don't be shy. Come on. We all know the F word.
I'm going to fuck you up if you don't come home.
Understand that could be made during an altercation, Your Honor.
Don't come home. It was made during, the defendant admitted that there was an altercation, admitted that he told the complaining witness, I'm going to fuck you up if you don't come home.
Your Honor, I'm looking right at the summary of facts. It literally says, on her cell phone contacts, complainant stated the defendant then began to threaten her via cell phone text, which he stated, I'm gonna go kick your door. I got you. I'm gonna fucking kill you. Complainant stated she was fearful for her safety. But before that line, it says they came from an unknown number. It says it in this number.
Your Honor, it is further down in the summary of facts that there is an admission.
I mean, of course, Mr. Woodward, someone can make something from an unknown number, but they can corroborate it at the same time, you know? And I think that that's what the state is saying here, that he corroborates the actual text message saying that I'm gonna go fuck you up. Right?
Yes, sir.
Yes.
The problem is that we have him, he's still doing stuff on his own. You know, I've told him not to do it, admonished him not to do it, and he's still, you know?
Yes, sir.
In this life, when you do things the right way, good things happen. When you do stuff the way you want to do it, in violation of orders, and you've been through this sufficient that you know? Now, it's not the end of the world, but how do I get your attention so that you realize that we mean business? If I just give you PR bond after PR bond after PR bond, I mean, we have no teeth.
Yes, sir. I paid out of my pocket to get bonded. They gave me a bond downstairs and I paid for it.
You're on your VPO, but I'm not going to give you a PR bond when you're picking up a VPO.
She called me, her home had it.
I'm not going to, no. Like I said, talk to your lawyer first. Start telling us stuff, because I don't want you to put yourself in your mouth when you think you're trying to help regardless. Now, look, we can come back tomorrow. He's going to come here. We can try to work something out, but
I was just trying to help, sir. I've been staying away from her. I got like 10 days left.
Sir, I got you. I'll come check up on you, okay?
Back tomorrow, we'll deal with it and we'll figure something out. So you'll definitely be here tomorrow, Mr. Woodward?
Absolutely, Your Honor.
Okay, so I'm gonna revoke it for now. Come back tomorrow, we'll talk. Do you have a place so that they can reach out to the complaining witness so they can get a rip done by tomorrow? Mr. Woodward?
I do not have it readily available, Your Honor. I can likely get it.
Okay, so can you try to do a rip between now and tomorrow so we can try to figure out what she wants and then we'll go forward? Please. Okay, all right, we'll see you tomorrow.
Thank you, Your Honor.
All right, bud, we'll see. Good morning, Ms. Dews. Man, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, man.
On March 18th, 2025, at 5:21 p.m., an officer was dispatched to a theft at Walmart with a female in custody. Upon arrival, the officer took custody of the female identified by her Texas driver's license. The officer searched the defendant before passing custody over to another officer. That officer spoke to the loss prevention officer, who stated he was following the defendant in the store and observed her concealing items in her purse and backpack. This was done in a blind spot of the cameras, so there were not videos. The defendant then continued shopping before checking out and paying for some items. The defendant did not pay for the items she had concealed in the bags and passed all points of sale before the loss prevention officer stopped her. The defendant admitted to stealing before turning the items back over. The total value of the items was $120.86.
Thank you. Ms. Dews, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any Walmart for any reason whatsoever. If I find that you do, I will revoke your bond, put you in jail, and no more PR bonds for you. Do you understand? Yes, sir. Likewise, if I find that you pick up any new cases, your bond will be revoked, you will go into custody, man. Do you have the ability to hire a lawyer? Okay, I will have you fill out an application. Deputy Miranda is going to give you an application. I'm going to have you sign a reset with Victoria. After that, we'll have you take a seat in the jury box while we get your bond conditions ready. Do not leave until you sign them. Okay? Please. Do you mind filing those? No going to any Walmart? Anywhere.
No Walmarts anywhere?
Anywhere. Thank you. Frank Reyes.
Yes, sir.
Mr. Reyes, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. So, okay.
Officer was dispatched to a minor crash in Harris County, Texas, where the defendant had rear-ended the complaining witness. Upon contact, the officer found the defendant in the driver's seat, slipping in and out of consciousness. When the officer woke the defendant up, the defendant attempted to start his car and drive away, but at that point, officers had his keys. The officers did not notice any injuries on the defendant. When the defendant exited the car, he was unsteady, and officers observed an odor of alcoholic beverages, bloodshot eyes, and slurred speech. The defendant admitted to drinking at a bar earlier. Standardized foot sobriety tests were conducted, and the officers observed 6 out of 6 on the HGN, 8 out of 8 on the walk and turn, and 4 out of 4 on the one-leg stand. While en route to the Joint Processing Center, the defendant fell asleep in the officer's vehicle. At the Joint Processing Center, officer read the DIC and defendant consented. However, the defendant fell asleep again and began vomiting. The defendant was transported to the hospital, and a blood warrant was signed and executed.
So no breath test was done.
No, you don't.
Mr. Can you run his license, please? See if there's a valid license.
Yes, Your Honor.
Mr. Reyes, I'm going to find that there's sufficient probable cause to go forward with your case. You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you do not, I'm going to give you a portable device. You're not allowed to drive any vehicle from now on that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock on it, I'm going to put you in jail and I'm going to make your bond high. Do you understand?
I understand.
It says ineligible, Your Honor.
You are not allowed to drive. You will be signing an affidavit with me today promising you're not going to drive. Mr. Reyes, heed this warning. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car and drive. Do you understand?
I understand.
You cannot justify driving for any reason. I don't care if there's a burning building and you have to save 50 babies. Do you understand? Mm-hmm. I'm sending notice now to DPS so that every single officer in the state knows that you are not allowed to drive a vehicle that doesn't have an interlock. If you're caught driving a vehicle, it doesn't have an interlock, they will arrest you and put you in jail. I am now giving you a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. You will also be tested for illegal drugs as well. You test positive, you consume alcohol, into jail you will go. Do you have the ability to hire lawyers, sir?
I do.
We're going to give you time. I'm going to have you come up here, swear to us that you're not going to drive. I'll get you to Victoria. We'll have you sign a reset. You will get with police for your bond conditions, and after that, you're free to go.
Please, I'm confirm that you can.
Good morning, Mr. Sullivan. Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. For the right to have an attorney present, if you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On March 23rd, 2025, at approximately 15:39 hours, a law enforcement officer was dispatched to an address in Harris County, Texas, in reference to a disturbance. When the law enforcement officer arrived on scene, they made contact with a witness who stated that her husband, the defendant, had been arguing because her adult daughter does not like the defendant and asked the complaining witness to pick between having a relationship with her and her grandchildren or the defendant. The complaining witness stated she decided to sever a relationship with her daughter and informed the defendant that she would be moving back to Arizona. The complaining witness stated this upset the defendant and he began arguing with her. She then expressed that she hated him and this made the defendant more upset and he told her to hit him if she hated him so much. The complaining witness stated she hit Mr. Sullivan with a close fist on the head and face area 3 times before losing balance, slipping and falling. This fall caused her to hit her face on their bedroom dresser. The complainant then said she got up and crawled into bed, and she was laying on the furthest corner of the bed closest to the wall and covered her body with a blanket. The complainant was saying that approximately 10 minutes went by. Mr. Sullivan, the defendant, continued to argue with her. He crawled on bed, grabbed her, flipped her over, put her back was on the mattress, and used his body weight on top of her while placing both hands on her upper arms to hold her down. The complainant said this caused her pain, and she was able to free one of her arms and use her hand to grab the defendant's genital area and making him let go of her completely. The defendant then used his right hand and punched the complaining witness on her mouth, causing pain and visible injury. The complaining witness added the fight then diminished, is that the law enforcement officer observed visible injuries, including large purple bruises on both arms and injuries to the top and bottom inner glove.
Lays, are you hearing this?
Yes, Your Honor.
Interesting. So she's the initial aggressor though, correct?
Your Honor,
So it looks like he says, hey, hit me, antagonizing. She gets into it. She pops him, what, 3 times in the mouth, you say?
Yes, Your Honor.
Don't say anything. Sorry.
So, Your Honor, only thing I would ask is, this is not home court's case. If we can just stand down, wait for the DVD prosecutor to be here. I don't know if he's spoken to the complainant yet, if he has anything more to add. I would just ask the court to withhold the finding until we can get the prosecutor.
All right, Mr. Sullivan, just do me a favor. Will you just take a seat in the jury box? I'm going to get, I'm going to also appoint him a lawyer, if you don't mind. I'm going to appoint him someone as well, so we can do just.
That's totally fine, Your Honor. Let me, and I'll email DVDs.
Okay, all right, thank you. Do me a favor, just take a seat for me real quick, all right?
All right, Judge, next is.
You're Abner Guzman.
Guzman. Yes.
Mr. Guzman, you're charged with displaying a fictitious license plate. 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed for you, sir.
Thank you. On March 24th, 2025, at around 11:20 a.m., officers were dispatched to a DMV call at 2520 Airline Drive in Harris County, Texas. Upon arrival, officers observed the defendant's vehicle parked in the west side parking lot near the fence of the Houston Farmers Market, with the front passenger window broken. Officers conducted a vehicle check on the temp license plate and returned a dot match the defendant's vehicle. At 12 p.m., the defendant arrived on scene, told officers that he was the owner of the vehicle. Defendant was detained. Defendant said he had purchased the vehicle 5 years prior in Florida and paid an additional fee to the seller to change the title to the thing. But the seller did not do that. Defendant stated he met a woman on WhatsApp who offered him a fake temporary license plate for $40, which he purchased. Defendant stated he had been driving the vehicle with fake temporary license plate for 4 years. The defendant was ID'd by his Guatemalan.
Mr. Guzman, I'm going to find that there's sufficient probable cause to go forward. If you do not have a Texas driver license and liability insurance in your name, you are not allowed to drive. I don't care what you need to do in this life. If you're not properly licensed and have insurance, do not drive. You'll be signing a promise with me. This is an affidavit that you're going to swear to me that you're not going to drive. You cannot justify driving for any reason. If I find that you do, I will revoke the bond and put you in jail. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they will put a detainer on you and you will be stuck like Chuck in there until this case is over with, and then you get shipped off to immigration. Do you understand?
Yes.
Do not drive. This is the only bond condition that you have. Do not pick up any new cases as well. If I find that you're a danger to my community, likewise, I will put you in jail. You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with him. If he tells me that he cannot get a hold of you because you're playing games, you're not responding to phone calls, text messages, likewise, I will revoke your bond. Do you understand?
Yes.
Okay. I'll have you sign a receipt of Victoria. We'll have you swear to us that you're not going to drive, and after that, you're free to go.
Thank you, Judge. Maybe excuse me. Thank you.
Yeah, take care. Hey,
Aaron Durden, bond violation report. You said bring him today. He's here.
come up, Mr. Durden. We're here on yet another bond violation report. It is now alleged that the client was instructed to install an ignition interlock device, not to tamper with the device, to blow into it. And from 2/20 to 3/20/25, you skipped 8 tests not using the device as instructed.
Can I explain, Judge?
Please.
All those violations except one are on the same day. If you look at the photos, the person there's only one person in any of the photos. It's not him. He owns a company. He allowed his employees to drive the truck. They didn't understand the deal. All the other pictures show nobody in the truck. What they did, they're roofers. They just left the truck running while they were doing work to keep the climate control on. He has since clarified that. We've emailed pretrial last week asking them to try to get the photos before the violation so we could see who was actually driving the truck, but we didn't hear any response.
He has guys, does he have a blow schedule that he's supposed to blow? He has a blow schedule. He's supposed to blow at certain times, and he's not blowing.
Are you not blowing at certain times?
That's not true, Your Honor.
I have here 8 skip tests.
No. So one of my guys was driving the truck, and he did not. I didn't instruct him that when you stop the vehicle, that you can't just leave it running. So he wasn't informed about that. So he just left the truck.
But it was rolling retests that were skipped. That's the allegation. Rolling retests. So somebody started the truck, got out of the truck and left it running, and it just kept saying blow, blow, blow. If you look at the times and date, they're like 5 minutes apart for 15 or 20 minutes.
Yes, Judge, I do see that it's the rolling retest. As far as what specifically that entails, honestly, that's something I haven't encountered before.
I haven't either, but bottom line, he's supposed to test at certain times.
Yes, but that would be a missing test, but the allegation is in the bond violation, rolling retest.
So yes, there's no allegation that he has missed his flow schedule.
What times, do you have this time set that he's supposed to actually blow?
I can reach out to the manager and get that information.
Do you mind? I'd like to know what specific times is he supposed to test?
Yes.
And did he actually do it on that times, or is it someone else blowing? That's what I'd like. So let me see what they say, and then we'll come back.
Judge, I have Odiambo on today's docket. He's doing the DWI PTI program. He just needs a little more time to get the device.
Last name is?
Marina Odiambo. It's hyphenated. She's been having some financial issues, and so he's trying to get some money together to get the alcohol monitoring device. And we also need to submit the industry affidavit, but he's provided that to me to get the
213 days old.
Just we can get 2 weeks just for him to get the device. That's all we need. We have the contract already, and we just need to get the fee waived as well.
Bring him up.
Yes, Judge. I'm just trying to get this wrapped up, Judge, and we're really close.
So are you doing that for the fee, right, James?
Yes, Judge. We have to submit the device, or we have to submit the industry affidavit for the $300 fee, and then he also has to get the alcohol monitoring device.
Filled out the affidavit.
Judge, he has that filled out. It's just I need to get a PDF copy of it, and he says he can scan that to me.
Do you have everything now? Because we can scan it, bring him back, and I can.
No, Judge, he took photos of it, and that's not going to work for them.
Your case is 215 days old. I'm not giving you any more time after that. It's not, if you don't have it done, I'm going to immediately set you for trial, or you're going to take a plea bargain agreement from the state. But I'm not giving you any more time after that. You need to have everything done by that time. You need to submit the affidavit today, not tomorrow, not next week, because they need time to review it to see if they're going to grant it for you. I will not give you any more time after this 2 weeks. If you don't have it done, I will bring you back day for day until you have it done. Do you understand? Okay.
Thank you, Judge. Can I get 2 weeks? Thank you, Judge.
I just got hired on Miss McKelvey. This is the one you emailed me about. She's in the box. Pretrial has indicated to me that she did take a test last Tuesday and she did test negative. She tried to go to Quest, which we sent her to. They wouldn't take it because they didn't have enough information. But she ended up testing, I guess, through pretrial.
Yes.
Okay.
When did you test last?
Tuesday.
Tuesday, just the 25th of March.
Okay, come up, Mr. McKelvey. I'll just admonish her now.
Thanks, Judge. And I told her zero tolerance. I mean, she's a real sweet lady. I don't think you're going to have any issues with her in the future.
It's no tolerance. If you miss again, it's not going to go well. All I'm asking you to do is show up when they call you to take a test. You understand?
Yes, sir.
So right now, nothing's going to happen today. But if it happens again where you miss a test, then I will issue a warrant. No tolerance. You understand?
Yes, sir.
You're not to use any alcohol. You're not to use illegal drugs. And that's how we ensure that it doesn't happen. Understand?
Yes, sir.
Okay. All right, Carter.
May she sit in the audience? Thank you.
Good morning, Your Honor.
How are you?
I'm fine. I don't have any big problems today.
Something nice.
All I need is a reset for 45 days. The prosecution and I have come to an agreement. Christian Willis. The prosecution and I have come to an agreement as to the resolution of this case. He just needs about 30 days in order to.
It's nearly 200 days now. What do you, what did they offer? What did they offer?
We've offered a PTI now, Your Honor.
And what did,
I spoke to the weapon and gun safety class and a drug and alcohol awareness class, I believe.
You know what?
Drug awareness class, I believe.
So I'm gonna give him 2 weeks to get the stuff done.
2 weeks?
Yeah, it shouldn't take that long. It's a gun safety class, it's probably 2 hours.
Yes.
And the other class also is just a couple hours.
So you only need 3 weeks instead of 2? Because I still have hours.
3 weeks.
3 weeks. Thank you, sir.
Mr. Willis, where's Mr. Willis? Come up.
This is Christian Willis. This is the first time ever getting in any.
Mr. Willis, he has secured you an amazing deal where if you do 2 simple classes, both of your cases will get dismissed. If you do not have if you don't have them done in 3 weeks, I'm not going to take anything else. I will immediately set your case for trial. Do you understand? There's no excuse why you can't get both classes done in 3 weeks. All right, Mr. Cashin.
Thank you, sir.
See you.
See you next time.
Take care. Hey,
Judge, we're here on Mr. Aziz. Newly retained on the case, Judge. Newly retained on the case.
oh, you retained?
Yes.
Got it. Okay, so come on up. We were waiting because he said that he hired a lawyer. We were waiting to see the voice. Come on up, Judge. So have we done PC on this case yet?
Judge, he was CHA. They just had to sign on.
Okay, so we have here, do you mind doing me a favor? Can you run his license to see if he has a license? Sure. This is a failure to stop and give him information.
Yes, sir.
Leaving the scene of an accident. So I just want to make sure that if you're going to drive, that you have a valid Texas driver license and liability insurance. If you do, then you may continue to drive. If you don't, then I'm making it a bond condition that you not drive until you have both of those things.
Yes, Judge.
Yeah, basically, Bispin is eligible.
Okay, you do not have a Texas driver license.
I have a California driver's license. I was stationed in California. I'm a veteran.
Is it eligible?
It does say eligible, Your Honor.
Okay. All right, so one of your other bond conditions is you are not allowed to drive unless you have liability insurance in your name. That is a bond condition. If I find that you drive without car insurance, because all I'm asking you to do is follow the law. If I find that you don't, then I'm going to put you in jail. You understand? Great. You've got a lawyer. Because you have a lawyer, we will waive your appearance, so you don't have to waste your time coming to court, but you must stay in touch with them. They'll tell you if and when you have to come back to court.
Quick question. Do I just need to come back with like my insurance and give it to them so that they know that it's valid?
Yeah, just let them know, then they can show it to us so that we can verify it and then you're good to go. But like I said, I'm waiving your appearance. You don't have to waste your time coming to court, but just stay in touch with them and they'll tell you. If they tell me they can't get a hold of you because you're gone, then I will issue a warrant for arrest.
Okay, that's right.
You don't pick up any new cases. Got it?
That's right.
We're good.
Thank you.
Thanks, Judge.
So don't leave until you sign the conditions and then after that you're free to go.
Yes.
So he filed no driving without a valid license and liability insurance.
Yes, Your Honor.
Okay.
Thank you, Your Honor.
That's have fun.
Urging on Jasmine Tovar Martinez, Judge.
She had a BVR. On Friday, she came to court. She was sent to go get drug tested, and it's negative. She is present. Martinez had a cause of mercy like that. That's it. That's the one.
Judge, it's 254.
8319.
There's boys. I think it just.
Ms. Tovar, come up. Did we put a scram on
I
her?
believe that's what happened. I wasn't here on Friday. We should have scrolled.
Do you mind checking?
Yes, scram device not Friday.
That's positive again. It's not going to go well for you. You better know every single thing that you put in your body before you do. If I see that you have a positive and you try to tell me it's mouthwash, it's a tequila lollipop, it's hair dye, I don't care. No more excuses. You understand? Okay? All right.
Thank you, Judge.
Yes, sir.
Step back, have a seat, give me 1 second.
Who's the guy that took in? What to you?
Oh, James.
What was all the letters? No, I don't need it. No.
So 30,006. 30,006. No, maybe I'll make it higher.
What do you think?
Every charge builds a bigger picture the court must consider.
No, they didn't say it's Slim's fault. Oh, I didn't know. I let them know. Okay. Did you hear that? Yes. Safety. God, bond, you